ಅನ್ಪೋಸ್ಟ್ ಆಗಿದೆ ಅದು ಸ್ಟೇಟ್ 3 ಕೊಟ್ಟನಲ್ಲ ಒಂದು ಬಂದಿದೆ ಇವತ್ತಾ ಎಷ್ಟನೇ ಎಷ್ಟು
memo minutes.
For auction purchaser, my lord, Ata Marthaila Samara. Auction purchaser of the property, my lord.
ಏನಕ್ಕೆ
Petitioner. Ata Marthaila Samara.
ಆಯ್ತು ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರ್ ಏನು
24, my lord.
ಈ ಗ್ರೂಪ್ ತಾನೆ
Please, my lord.
my lord
My lords, it's a fresh matter, my lords.
give all the memos we need 2:30 move or else you don't have to move
It's a fresh matter, my lords. The respondent is
Didn't
claiming
declare.
ownership right without
ಕೊಡಿ
kindly tomorrow, my lords. It's a
ಡೇಟ್ ಕೊಡ್ತಾರೋ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ನಾಳೆನೆ ಕೊಡ್ತಾರೆ ಬಿ ಗ್ರೂಪ್ ನಿಧಾನ ಕೊಡ್ತಾರೆ
My lord, in that matter, the respondent asked them notice, my lord. So they will stay.
which year
Other 22, my lord.
it will come in the seniority it will come either this week or next week it will come
This week, my lord. This week, because they issued a notice to us.
it's waited for 3 years I'm sure it can wait for 1 more week also
He's asked for that.
I'll get it posted don't worry
There is sad demise in my senior's family, 6973.
ಏನದು ಆರ್ಡರ್ ಸರ್
Huh?
ಆರ್ಡರ್ ಸರ್
ಇಲ್ಲ, ಫೈನಲ್ ಇಯರಿಂಗ್ 2 ಇದೆ, 6973.
2009 ನೋಡೋಣ ಏನಾಗುತ್ತೆ
Mother-in-law is expired, therefore he did not come to.
I'll adjourn it when the matter
Should memo for posting, I apologize. There's urgency in the matter because their
fresh matter B group what
notice has been gone, my lord. It's
B
admission
group which year
last year, my lord, 24.
they'll post it
Because they're conducting resurvey, that's why I'm
you have an interim order or not
no interim order also. For interim order, I'm pressing.
what is it?
Serial number 16.
60
16.
Sir, sir.
There is a civil suit pending, my lord, so order will be sustained, subject to the civil suit. Lord, the DC has remanded it to the Tahsildar to restore the original entries. Page number 17, my.
the request for mutation of the revenue entries on the basis of the will was entertained by the Tahsildar and affirmed by the Assistant Commissioner. Over the Deputy Commissioner, in excess of his original power, has set aside the said order and has observed that the parties were required to approach the civil court and the entries would thereafter abide by the result of the civil suit. It is not in dispute that the parties are before the civil court in OS number. That I couldn't, they are already before the civil court. And a suit regarding the bequest is pending consideration. It is therefore unnecessary to entertain this writ petition, and this writ petition is dismissed with an observation that the revenue entries shall abide by the result of the suit that is said to be pending between the parties.
Seal number 2, Shri Rajesh Gowda.
My lord, here, my lord, even civil suit pending.
Authority matter.
My lord, say civil suit pending. I have no jurisdiction until to DC as it is.
Also,
My
Seal
lord,
number 3, Shri Kumar JC.
Lord, there is an interim order. Only fix the date for final hearing. My lord.
interim order fix the date for hearing. And matter in LA.
My lord, regarding the acre of land, my lord, the government is claiming that, my lord, attached to the Diwali land.
What is the prayer here?
There, and the without notice, my lord, they are allotted the land.
What is annexure A?
Next day is passed by the deputy commissioner for allotment of the land in favor of the, my lord, the Manya Pradeshika Ayuktaru Bengaluru Vibaga. It is in respect of survey number 75/1, my lord. Where the petitioner is concerned in respect of survey number 75/1.
How are you interested in this land?
Lord, we are the owner of the property in bearing survey number 75/1, total extent of 9 acre 36 guntas, my lord. Out of which, my lord, 2 acre 9 guntas Sidwali land. 2 acre 9 guntas is Sidwali land. We are acquired under the registered will. It's an ancestral property of the petitioner, my lord. So attached to the Sidwali land, you are on 7 acre 27, it's a Karab land.
What kind of Karab?
But Karab, it is in the A Karab land. A Karab land.
The A Karab and A.
We have produced the document, my lord.
What is the kind of Karab?
Karab, my lord, subsequently, my lord, defined as a
Lord,
B
Lord
Karab.
is-
What is the
Earlier, my lord, there is a gap. My lord, A Karab, it is not defined in the Akar Band. A Karab or B Karab, my lord. Subsequently, my lord, after due inquiry has conducted, my lord, it is
What
defined
was
as
that?
B Karab.
What was the land being used for?
Please, my lord.
That Karab land, was it being used for a communal purpose like a tank or any such thing?
No, my lord, it is not cultivable.
It does not become your property.
My lord, when the cultivable land, my lord, it is A Karab, my lord. The uncultivable land, my lord, it is B Karab. It is after due inquiry,
I have rendered a judgment in which I have said
My lord,
the Karab portion would always belong to the owner.
please. My lord,
It is being used for.
where, my lord, in the Akar Band, it is not defined. Therefore, my lord, after due consideration,
Either way, it does not become your property for you to allot it to yourself.
my lord, therefore, my lord, after verification only, my lord, the allotment has been made.
ನಿಮ್ ಜಮೀನ್ ಆಗದೇ ಇಲ್ವಲ್ಲ?
ಅಲ್ಲ, ನಮ್ ಜಮೀನು ಅಂತ ವೆರಿಫಿಕೇಶನ್ ತಿಳಿದ ಮೇಲೆ ಅಲಾಟ್ಮೆಂಟ್ ಮಾಡಿರೋ.
ಜಮೀನ್ ಹೆಂಗಾಗುತ್ತೆ? ನೀವು ಟ್ಯಾಕ್ಸ್ ಹಾಕಲ್ಲ ಅಂದ್ರೆ
ಬಿ ಖರಾಬ್ ಅಂತ ಡಿಫೈನ್ ಮಾಡಿ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾದ್ಮೇಲೆ ಅಲಾಟ್ಮೆಂಟ್ ಮಾಡಿ.
have it in the B group, please go through my judgment. Your argument is against my judgment. Therefore, I have held that.
Fix a date for hearing, my lord.
Lords, in this matter, my lords, I appear for the state. My lords,
Yes.
in terms of the present records, my lords, it is actually shown as a B Karab. Now, my lords are saying there is a judgment rendered by my lords. My lords, we'll have a look at it. My lords, will make our submissions.
What I have held, Ruben, is that was in the context of paying compensation.
Please, my
I
lords.
have held that Karab portion only means it is not fit for cultivation, that is non-arable land.
Please, my lords.
You grant them an exemption from paying land revenue.
Please,
It never becomes your property.
please.
It is only because you exempt it from paying revenue, they can't make any productive use of that particular land. You say, I will not levy a tax. Therefore, you use the word Karab. Karab means unfit for cultivation.
Please.
Merely because it is unfit, does not become, it's your property. The only difference on the manual is that those areas are reserved for communal purpose, like a tank, a pathway, or some other purpose where the entire villagers use that particular land.
Please.
Then he cannot make use of it for his own purpose.
Please.
That is the only restriction of is the right to use with exclusivity. Apart from that, I don't think government ever gets any power over that land.
Please, my lords. We'll have a look at the judgment. My lords. It may be taken up.
Give a number.
Interim order.
Interim order continue.
My lord,
My lord, with
Let's-
respect to this honorable court, my lord, I'm sorry to interrupt the court, my lord. Condition number 67, my lord, I appeal to the petitioner. My senior mother has passed away, my lord. So we wouldn't be able to,
You should not make a mention in the middle.
I'm sorry, my lord.
Whose mother has passed away?
Miss V.V. Nidhishri, my lord. Miss V.V. Nidhishri for the petitioner.
69.
67, my lord.
Don't make a mention in the middle.
My lord, it may be posted on 18th, my lord. Then file a joint.
Don't fix a date. Once you want to take time, just take time and go.
Seal number 4.
My lord, appear for the petitioner. My lord, this court had directed. What happens is, in spite of a judgment being delivered by civil court against which there is an appeal, respondent 6 and 7 that the military then get an order from the deputy commissioner and also move simultaneous proceedings before the assistant commissioner. May I just point out, in fact, this court had passed an order to produce the civil court records. I mean, the judgment which I have done. My lord, what happens is, in my grandmother,
What is a prayer in the writ petition?
my lord, prayer is to set aside the orders, quash the proceedings before the AC and the order passed by the DC. I'll just explain a few facts. What happens is, in 1941-42, my grandmother was temporarily given this land, 2 acres in Savar lines. The total area being about 328 acres, 33 guntas. 54 grant was made, Sagoli cheat was issued up to 2000. My grandmother's name appears. She passed away. The mutation was made in the name of my mother, Jayamma. Thereafter, in the family, there was some partition, and the portion, these 2 acres, came to the share of my father, third petitioner. He gifted it to me, of which a portion I have leased out to Indian Oil Corporation. It is there. We are in possession even till today. What happens is, in 2010 or thereabouts, 6th and 7th respondents claimed that on their military records, this land belongs to them and we had encroached upon it. So what they did was, they challenged the long-standing entries before the Tahsildar. The Tahsildar then says these are long-standing entries, refers it to the deputy commissioner. The deputy commissioner then says, listen, this is a matter of title, you have to go before a civil court. In the meanwhile, directs the Tahsildar to conduct a complete inquiry to find about the veracity of the revenue entries. Tahsildar gives a report saying entries are valid, the genuine grant, they have been in possession for so many years. Maybe by then it was about 50 years. Then what happens is that meanwhile, in 2011, because of the continued interference of the 6th and 7th respondents, I filed a suit in OS 2000-001 of 2011 for declaration and injunction. The court in 2016-17 passed a judgment, did not reject my prayer for declaration, but never said anything about it, but granted a permanent injunction against 6 and 7, saying that you will not interfere until you go and have your title declared in a civil court and then take possession in accordance with law. In the meanwhile, what they do is they make one more application to the Assistant Commissioner 136-2 in respect to the same property. Then they also persuade the Deputy Commissioner, third respondent, to suo motu take up proceedings. And the Deputy Commissioner says proceedings against 2 and 3, there were 2 and 3 in those proceedings, are dropped. What was dropped? There was nothing against them. It was all time the 6 and 7 were kept on initiating proceedings. Now, Assistant Commissioner, in face of the civil court order which was brought to him, has kept the matter posted for orders. He says, I'll pass some order. Deputy Commissioner, in spite of being told that there's a civil court order, in 23 you cannot pass it, the parties are in appeal. I have also filed an appeal. The defense has also filed an appeal. He passes an order in 23. It is these two I'm challenging. The reason is, my lord, what is happening is the military record as of that date shows 328 acres, 33 guntas. Now the military claims it's 378 acres, 33 guntas. Now the Deputy Commissioner the second time, when the impugned order reopens the case in which the deputy commissioner had earlier passed an order in June of 2014. And in that passes an order.
So basically saying that you will have to await the decision of the RFA.
RFA. One more submission is, last time I had sought for stay of proceedings before the Assistant Commissioner because he's threatening to pass an order. A submission was made that already a stay has been granted. I verified. It was not in respect of this property. It was respect of some other village, some other property.
Fact that so appeal is pending against this particular property.
Yes.
In which the title is being determined.
Lord,
I have
it is
produced.
mentioned in the order, my lord. Deputy Commissioner's order, it is mentioned. my
No,
lord.
that refers
It
to
is
some
the-
other appeal, my lord. It's not this
Therefore,
appeal.
my
at
lord,
all.
last vacation, my lord, the defense has taken a time to give the number.
Lordship's ASG is appearing in this matter. Seek for an accommodation. Kindly have this matter on 17th.
My lord, there is, he will pass an order, my lord. That is the problem. And again, it will multiplicity of proceedings.
No, if what senior counsel said was right.
I have produced
And
the
the-
copy, my lord. Judgment copy.
Title to the property is subject matter of an appeal. I will simply say that it will abide by the result of the appeal.
No, but
And-
ASG will appear in this matter. He
Ask
will
him to
assist.
appear at 2:30.
Because the difficulties, my lord, is not available. That is why seeking for. an
Is what?
Is not available. That is why seeking for an accommodation.
Tomorrow. Verify RFA ಇದೆಯಾ ಅಂತ ನೋಡಿ.
Please.
Error RFA ಇದೆ. ನಾವು ಹಾಕ್ತಿದ್ದೀವಿ, ಅವ್ರು
Let him verify. If
I
he
have
have-
produced the
No.
judgment copy.
if he has a copy, give it.
I will
copy.
give it also.
Because if there is a question of the title pending consideration, whatever the status prior to it, it will prevail
Please,
till the appeal is decided.
please, my lord. Because
Tell
last-
that to your ASG and ask him, please tomorrow.
Seal number 5.
ಲಾಯರ್ ಇಟ್ಟಿದ್ರೆ ನೀವು ಹೆಸರು
ವಕಾಲತ್ ಹಾಕಿದ್ರೆ
ಶ್ರೀ ನಂಜುಂಡ ಸ್ವಾಮಿ.
ಕೇಸ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಮೊನ್ನೆ.
Appearance on
Friday
behalf of
ಕೊಟ್ಟಿದ್ದೀನಿ.
the petitioner. Hence his name be printed in the cause list and relist on
18th.
18th.
18th. Seal number 6. Shri H.C. Sundaresh.
Petition is the matter pertaining to regularization of another
Lord, in this
cultivation.
matter, my lord, my instructions are, my lord, their application is forwarded to the deputy commissioner to reject their claim. DC has to take decision, my lord, to reject their application because land is not available, my lord. My instruction.
Let the committee to decide the matter.
Committee ಮುಂದೆ ಇಡ್ತಾ ಇಲ್ಲ. The recommendation is to reject his application.
That still has to be done only by the committee ತಾನೆ.
Committee has to,
ಇಲ್ಲ,
committee has
rejection
to
ಆದ್ರೆ
take a
DC ಗೆ
decision.
ಹೋಗುತ್ತೆ.
ಇಲ್ಲಿ ರೂಲ್ಸ್ ಕಾರ್ಡ್ ಹಂಗಿದ್ಯಾ?
ಹೌದು, ಇದು ಕನ್ಸಿಡರ್ ಮಾಡ್ತೀವಿ ಅನ್ನಂಗಿದ್ರೆ ಮಾತ್ರ ಕಮಿಟಿಗೆ ಹೋಗುತ್ತೆ.
ರೂಲ್ಸ್ ಕೊಡಿ.
Books ತಂದಿಲ್ಲ.
ಕೊಡೋದು ಬಿಡೋದು ಎರಡು ಅವ್ರಿಗೆ ತಾನೇ ಬಿಟ್ಟಿದ್ದು. DC ಗೆ ಕೊಡೋದು
ಈಗ ರಿಜೆಕ್ಟ್ ಮಾಡ್ಬೇಕು ಅಂದ್ರೆ ಡೆಪ್ಯೂಟಿ ಕಮಿಷನರ್ ಹೋಗುತ್ತೆ ಈಗ.
ಯಾವ ರೂಲ್?
108.
They forward the ineligible application to deputy commissioner. 2020 amendment, huh?
Oh.
Then you'll have to probably wait the decision.
Yes. Within 2 weeks, my lord, the order will be passed by the.
Shall I record a submission and close this process so that you can go after the deputy commissioner's order?
After issuing endorsement, please, my lord, your lordship may dispose the matter.
The petition is filed. Seeking for issuance of a direction to the respondents to consider the representation dated 24/2/2023, wherein the petitioner was requesting for his unauthorized occupation to be regularized as per his form number 53. Learned AG on instruction submit that the Tahsildar on an inquiry has come to the conclusion that the petitioner would be ineligible for consideration of his application, and therefore it has been forwarded to the Deputy Commissioner. And in all probability, the orders will be passed within a period of 2 or 3 weeks. Next, date of the above submissions, it is clear that the case of the petition has been considered, and the matter is the stage of passing of the orders on his application. That will matter the player in this petition would not survive for consideration. However, it is made clear that in the event the Deputy Commissioner accepts the recommendation of the Tahsildar and holds that the petition is ineligible, the petitioner will always have the liberty to challenge the said action.
Say number 7, Shri Uma Shankar MN.
Petitioner. Petitions, writ of mandamus, page 34, your lordship. Civil court decree.
Manjunath,
My lord, I will take notice. My lord. Fresh matter.
close madla, bedwa.
As per the judgment and decree, my lord, 7/10/2020, they are seeking to effect the kata. I will get instructions.
Two representations are made. One sorry, contempt action initiate madake letter ಬರ್ದಿದ್ದಾರೆ. Page 41.
ಒಂದು ವಾರದಲ್ಲಿ ಹೇಳ್ತಾರೆ.
Page 40, lordship, page 41. ಎರಡು
ನಾವು
ಸಾರಿ.
ಹೇಳ್ಬಿಟ್ಟು if he says yes, I'll accept it.
Please.
AG accepts notice for respondents, relist in preliminary hearing on. Please.
Next week, minute.
18th.
Please.
Number 8, Shri Pradeep C. Yadav.
Petitioner in this case, Your Lordship.
In this matter, my lord, they are seeking for formal conversion order, my lord. Fresh matter, my lord, I will take notice, my lord. Because that land is reserved for some other purpose, my lord, it cannot be granted. Earlier, it was converted to residential purpose, my lord. Now they are seeking for conversion from residential to industrial purpose.
Master plan ಅಲ್ಲಿ ಅಂತ ಇದೆ.
Master plan residential anta.
Your Lordship, according to the master plan, where my property is, surrounding my property, all others are industries, Your Lordship. Everything around my property is covered with industries, and hence it is completely inhabited.
The surrounding lands have been converted or have they been earmarked as industrial?
They have been converted
My
as
dear,
industrial.
Page 49, my lord, annexure the report given by the authority, my lord.
Page?
Page 49, my lord, annexure here. Hoskote Yojana Pradhikara. Page 49, my lord. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖ ನಮ್ಮ ಕಚೇರಿ ಪತ್ರದಲ್ಲಿ ಬೆಂಗಳೂರು ಗ್ರಾಮಾಂತರ ಜಿಲ್ಲೆ ಹೊಸಕೋಟೆ ತಾಲೂಕು ಸರ್ವೆ ನಂಬರ್ ವಸತಿ ಉದ್ದೇಶಕ್ಕಾಗಿ ಭೂ ಪರಿವರ್ತನೆಯಾಗಿದ್ದು ಸದರಿ ಜಮೀನನ್ನು ವಸತಿ ವಲಯದಿಂದ ಕೈಗಾರಿಕಾ ಉದ್ದೇಶಕ್ಕೆ ಭೂ ಬದಲಾವಣೆ ಮಾಡುವ ಸಂಬಂಧ ಈ ಪ್ರಾಧಿಕಾರ ಅಭಿಪ್ರಾಯವನ್ನು ನೀಡಲು ಕೋರಲಾಗಿದೆ. ಪರಿಶೀಲಿಸಲಾಗಿ ಹೊಸಕೋಟೆ ಸ್ಥಳೀಯ ಯೋಜನಾ ಪ್ರದೇಶಕ್ಕೆ ಸರ್ಕಾರದಿಂದ ಅನುಮೋದನೆಯಾಗಿರುವ ಮಹಾಯೋಜನೆಯಲ್ಲಿ ಪ್ರಸ್ತಾಪಿತ ದಾಸರ ತಿಮ್ಮನಹಳ್ಳಿ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ ಸೋನ್ಸೋ ವಿಸ್ತೀರ್ಣ ಜಮೀನನ್ನು ವಸತಿ ವಲಯದಲ್ಲಿ ಮತ್ತು ಹಾಲಿ ರಾಜ್ಯ ಹೆದ್ದಾರಿ ಸಂಖ್ಯೆ 82 ರಸ್ತೆಯನ್ನು 8 ಮೀಟರ್ ಅಗಲಕ್ಕೆ ಅಗಲೀಕರಿಸಲು ಕಾಯ್ದಿರಿಸಲಾಗಿರುತ್ತದೆ. ಅನುಮೋದಿತ ಮಹಾಯೋಜನೆಯು ವಲಯ ನಿಯಮಾವಳಿಗಳಂತೆ ವಸತಿ ವಲಯದಲ್ಲಿ ಕಾಯ್ದಿರಿಸಲಾದ ಪ್ರದೇಶದಲ್ಲಿ ಕೈಗಾರಿಕಾ ಉದ್ದೇಶಕ್ಕಾಗಿ ಪರಿಗಣಿಸಲು ಅವಕಾಶವಿರಲಿಲ್ಲ. ಹಾಗಾಗಿ ಸದರಿ ಪ್ರಸ್ತಾವನೆಯನ್ನು ತಿರಸ್ಕರಿಸಬಹುದೆಂದು ಅಭಿಪ್ರಾಯವನ್ನು ಗಿವನ್ ಬೈ ದಿ ಅಥಾರಿಟಿ.
ಇಲ್ಲ, ಅವ್ರು ರಾತ್ರಿ ಹೇಳಕ್ ಬರುತ್ತೆ.
But they have given, my lord, it cannot be converted to industrial purpose. I will take notice, my lord, this is the fresh matter. I will get instruction.
Have you made a planning authority a party here?
Yes, my lord.
Yes, Your Lordship.
AG accepts
Respondent number
notice
3.
for,
Respondent number 3, Your Lordship.
response 1 and 2.
It's a deemed
Yes, Naik,
conversion
To
under.
take notice for response number 3. Free list in B group 1.
9, Shri.
What is challenged is the impugned order. It's an order passed under 136(3) by a special DC of KS Kedam. In fact, there is a GO dated 10th of October 2014. And in fact, matter is covered by decision.
Can be
And
remanded.
why did the Tahsildar refer it to him?
He, on suo moto, he takes up the proceedings by quoting the circular, very same circular which the state says that special DC of KS cadres cannot deal with 136 proceedings. Lordship kindly takes the first decision, my lord, the division.
So who will appear now for the first respondent?
My lord, both the respondents can appear before the, if matter
Actually-
remanded, my lord. Both the respondents.
Matter has been remanded. Lordship kindly sees the covered by decisions, my lord.
But still I have to issue notice to the other side.
To
But
them
who
and then, yes.
will take notice for R1 now?
Private parties.
Lord, it has to be, somebody has to represent him.
Represent.
They'll only have
So
to.
she'll be opposing you in this writ
No,
petition.
we'll only have to know, my lord, since two government advocates cannot appear for two different departments.
Now, what should I do now? Should I say,
Notice can be ordered for, my lord. Then we'll figure out how it should be. Because previously, my lord, if lordship kindly sees.
no, but let me hear the
No,
others.
not, yes. My lord, 53
Why
and
don't you make
50
an application to the special DC, ask him to recall the order? It's after all your special DC.
But power to recall, I'll examine that aspect. Lord, serial number 53 and 54 is also
Similar matters.
similar matter.
ಮೂರು ಒಟ್ಟಿಗೆ ಹಾಕಿ ಸೇಮ್ ನೋಟಿಸ್ ಪೋಸ್ಟ್ ಮೂರು ಒಟ್ಟಿಗೆ ಕ್ಲಬ್ ಮಾಡಿಸ್ಬೇಕು.
Great.
Till number 10, Janardana ji.
Covered by judgment, my lordship.
In prayer ಏನು
Annexed to F, my lordship.
ನೋಡಿದ್ದೀರಾ?
But instructions are not received, my lord, last. There was a day,
DC
instructions,
accepts notice for respondents 1 to 4. List and preliminary on.
next week, my lord.
List and preliminary on.
17.
Okay.
Till number 11, Shri Pradeep C. Yadav.
Petitioner. Not, it's the third time I've approached this honorable court for 4D. This is the third time I've approached this honorable court for 4D work, my lord. Last time directions were issued to conduct 4D. It's been 10 years, my lord, the respondents have refused. They file an affidavit before the contempt.
See what means. ಏನ್ ಮಾಡ್ಲಿ?
Body will be conducted, my lord.
ಯಾವಾಗ?
There was a direction, my lord, earlier occasion. This honorable court has directed to conduct the body, my lord. Still not completed, my lord.
ಯಾವಾಗ ಮಾಡ್ತೀರಾ?
3
Get an
months,
affidavit filed by the Tahsildar as to when he will complete it.
3 months, my lord, by court order.
And let him give an undertaking. Because the third round of litigation, isn't it?
Yes. Understood.
I'll have it Friday. Ask him to file an affidavit.
Within 3 months, my lord, by court
ಮಾಡಲ್ಲ,
order.
affidavit ಹಾಕಿದ್ರೆ at least ಒಂದು.
I'll make sure that, my lord, I will ask him to.
Let him file an affidavit then. Why is he scared? Release Friday.
14. Till number 12, Shri Chandrakant or Gowde.
My lord, it is on your lordship have heard regarding GP order filing the writ petition.
Lords, we are withdrawing the writ petition, my lord.
Withdraw. And comes the petitioner seeks permission to withdraw the writ petition. Writ petition dismissed as.
Liberty may be reserved to file a fresh writ petition.
My lords, I will oppose for it, my lords, because no locus standi at all.
ಇಲ್ಲ ಇವರಲ್ಲ ಅವ್ರ ಕೈಲ ಹಾಕ್ಸಲ್ಲ ನೀವೇ
Original grant.
ಇವ್ರು ಹೆಂಗ್ ಲಿಬರ್ಟಿ ಕ್ಲೇಮ್ ಮಾಡ್ತಾರೆ? ಅವ್ರಿಗೆ ಲಿಬರ್ಟಿ ಇದ್ದೇ ಇದೆ.
clarify because this has been filed by the GPA order.
ಹೌದು.
Clarify that does not come in the way of the owner filing a writ
ಅಲ್ಲ,
petition.
he has not come and sought for
No.
anything.
No, Bhagat, you should not tomorrow say that the GPA order had filed. It is dismissed without liberty, therefore he can't file.
GP order independent, principal SMG independent right, my lords.
ಅದನ್ನೇ ಹೇಳ್ತೀನಿ ನಾನು, I'll just clarify that.
ಆಗ್ಬೋದು.
The withdrawal of this petition will not come in the way of the principle of the petitioner approaching this court if so advised.
Much.
Till number 13, Shri Pradeep Nayak.
And for the
So,
petitioner,
Not in
of mandamus, he made an application under Sakala scheme. 2.5 ವರ್ಷ ಆಯ್ತು.
ಏನ್ ಮಂಜುನಾ?
My lord, in this matter, my lord, annexed, they are seeking for certified copy of the grant order, my lord. My lord, this court, my lord, in writ appeal number 1004 of 2022, has directed, my lord, to send entire records to the FSL department, my lord. Same has been sent, my lord. In that, therefore, my lord, after obtaining that records, my lord, we will furnish the copy of the grant certificate.
ದಿನ?
My lord, this order is came to be passed on 28/11/2024. We have written a letter to the FSL, my lord. It is not yet completed, my lord. I require another 2 to 3 weeks, my lord, time in this matter.
No, can't you give them the certificate copy?
Entire
The
register
last
extract
occasion they made it, sorry.
entire register ne ಕಳಿಸ್ತೀವಿ. Our register they our certificate copy ಕೇಳಿ.
ಇಲ್ಲ, ಅವ್ರು let them take their time. Why can't you go get a copy and certify it and give it to them?
Please.
It should not come in your way, isn't it?
Yes, my lord. Because
ಹೇಳಿ, ಅಷ್ಟೇ ತಾನೇ ಮಾಡೋದು ನೀವು ಅಲ್ಲಿ ಹೋಗ್ಬಿಟ್ಟು
ಹೌದು, ಅದು ರೆಕಾರ್ಡ್ಸ್ ಬರ್ತಿದಂಗೆನೆ ನಾವು ಸರ್ಟಿಫಿಕೇಟ್
ರೆಕಾರ್ಡ್ ಬೇಡ, ನೀವೇ ಹೋಗಿ ಒಂದು ಜೆರಾಕ್ಸ್ ಮಾಡಿಸ್ಕೊಂಡು ಸರ್ಟಿಫೈ ಮಾಡಿಸಿ ಕೊಟ್ಬಿಡಿ ಅದನ್ನು.
ಆಯ್ತು.
Next week.
Please.
You list.
17. Till number 14, Shri Narayan Reddy M.
I'm for the petitioner in this case. The petitioner is the owner of survey number 52, an extent of 4 acres of land. She had inherited this land.
What is annexure A?
Annexure A is the endorsement issued by the third respondent stating that they have no records to make entries of the name of the petitioner in place of her husband. Your Lordship may kindly see that she had inherited an extent of 4 acres of land.
Kata was standing in the name of your husband?
Pardon?
The Kata was standing in the name of your husband?
Yes, my lord.
He is no more?
He is no more. After his death, she had approached. They have not made necessary entries in the revenue records. Consequently, she had approached this honorable court by filing a writ
When did he
petition.
die?
Pardon?
When did he die?
He died in 2004, my lord. She has been continuously approaching the third respondent.
Where is the Kata standing in his name?
I have produced annexure F, my lord. Annexure F and G, page number 31, my lord.
No, you don't have an RTC or an MR standing in his name?
Yes, my lord.
Where is the RTC standing in his name?
RTCs I have not produced it. I will produce it on the next of it.
Produce it. If it is there, I'll direct you to come.
Please,
But the endorsement says, my lord, it is an forest land, my lord, as per the notification.
If the Kata is standing in the name of the husband, change it. If it's forest land, you know what to do. How can you sit on title whenever you come in on inheritance proceedings? So you will say his grandfather didn't have a title.
Because as per the direction of the honorable court, my lord, in writ petition number 8.
Until her husband's name is cancelled from the revenue records, how can you deny that? Produce the RTC of your husband's.
Refreshment, my lord, I will take.
AJ accept notice for sounds. Realist and preliminary on.
17. Number 15, Shri Samir SN.
Lord, petitioner was the owner of 1 acre 29 guntas of land in 7/1 of the Boragonda.
136.3.
My lord,
136.3 proceedings.
136.3, my lord. What has happened is, in fact, he has executed sale deed, my lord.
Who was executed sale deed?
The petitioner has executed sale deed in favor of his elder sister, who is the respondent number 4 in this case, in the year 2006 itself. And thereafter, she has applied for change of Kata, and that was rejected at, there is a page 51, page 22, my lord. That was rejected on the ground that she was unable to show that she is an agriculturist, because that was the rule then. So subsequently, she executes the release deed in my favor, my lord. And thereupon, she comes and files an appeal before the assistant commissioner, where the
release deed is a registered release deed?
It registered release deed, my lord.
What is the meaning of release deed if she owns the property?
Yes, my lord.
Pursuant to a sale deed?
Yes, my lord.
How can she release it in your favor?
Oh, no, that is the document that she has executed, my lord. Because her rights.
Release is a joint right that you have, which you release in favor of the other joint owner.
Yes.
Where is the question of releasing the property? Is it a conveyance?
It amounts to reconveyance, my lord. That's all, my lord. The intention was to reconvey the land.
Then she filed an appeal. What happened?
Next, the appeal is allowed, my lord. The appeal is allowed because the only duty of the revenue inspector is to then the Kata if there is a registered document. That is the reason given by the land AC. Thereafter, I file an appeal, my lord, before the DC, and that is rejected, my lord.
How can you ask for Kata on the basis of release deed? If you can get a declaration that release deed is a reconveyance deed, then it will bind them. But how can they do?
No, in fact, I have challenged the order of the assistant commissioner, my lord, because
how can you
the
challenge
appeal
the
before
order
the assistant commissioner was made by the respondent number 4, elder sister, challenging the MR that was rejected. Correct. That I have challenged.
She has a sale deed in her favor.
Yes, ma'am.
The assistant commissioner was right when he said that go according to the sale deed.
Yes, my lord.
If you are claiming under release deed,
yes,
how can that amount to reconveyance?
Because that was the intention between the parties, my lord.
Ivagilvala, intention has changed now.
No, now the intention is changed.
File a civil suit. That is all that can be done. The petitioner had executed the registered sale deed in favor of his elder sister, that is a 4th respondent. Or the Tahsildar had rejected a request for mutating her name on the ground that she was ineligible to hold agricultural land. Being aggrieved, the 4th respondent preferred an appeal. to the Assistant Commissioner, and the Assistant Commissioner accepted the appeal and held that the revenue entries would have to abide by a registered instrument, and since the fourth respondent had assailed in her favor, the entries were required to be changed. However, in the meanwhile, it appears that the fourth respondent had executed a registered release deed in favor of the petitioner. And this, according to the petitioner, amounted to a reconveyance in his favor. The petitioner approached the Deputy Commissioner by filing a revision against the order of the Assistant Commissioner. But the Deputy Commissioner has rejected this revision, and hence the petitioner is before this court. As rightly held by the Assistant Commissioner.
In fact, one more thing is
The revenue entries are bound to be changed if there is a registered instrument executed by the khatedar. And in this instant case, it is not in dispute that the petitioner was the khatedar and had executed sealed in favor of his sister. Therefore, the order of the Assistant Commissioner as well as that of the Deputy Commissioner cannot be found fault with it. If, however, the petitioner claims that he has another registered instrument which is styled as a registered release deed, and under this deed there is a conveyance in his favor, liberty would be available to the petitioner to approach the civil court and seek for an appropriate declaratory decree to that effect. And if the petitioner is able to obtain such a declaratory decree in respect of this registered release deed executed by his fourth sister, it is needless to say that the revenue entries will have to accordingly be mitigated, subject to the above observation. The petition is dismissed.
Number 16, Shri S.V. Prakash.
ಇದ್ರಲ್ಲಿ connected matter ಅಲ್ಲಿ ಒಂದ್ ಎರಡು ಆಫೀಸ್ ಸಬ್ಜೆಕ್ಷನ್ ಇದೆ ಮೆಂಬರ್ಶಿಪ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್
In
ಕನೆಕ್ಟೆಡ್
matter, no? In Majna?
Mutation proceedings.
ಮಿಟೇಷನ್ ಜಾಯಿಂಟ್ ನೇಮ್
Mutation proceedings has been channeled. The assistant commissioners, two orders came to be passed.
ಎರಡು matter, ಎರಡು reputation ಯಾಕೆ ಮಾಡೋಣ?
ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್
Last occasion,
ಅಲ್ಲ ಕನೆಕ್ಟ್ ಗೊತ್ತಾಯ್ತು ಏನಕ್ಕೆ? ಕನೆಕ್ಟೆಡ್ ಏನು ನೋಡಿ?
ನೆಕ್ಸ್ಟ್ ವೀಕ್
ಮೇಡಮ್ ನೀವು ಶುರು ಮಾಡ್ಬೇಕು, ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಕ್ಕೆ.
earlier revenue entries confirm ಮಾಡಿದೆ.
Madam has taken a decision that she will not argue before me. So she will come only ask for time. Next time in the ಕೊಡಲ್ಲ time ನಿಮ್ಗೆ.
Number 17, Shri Ajit Kalyan.
Also appear for the petitioner members. Sought for a writ of mandamus members to furnish me the survey records.
And I need some time, my lord, to get instructions.
He accepts notice for
Already notices.
that is already list. ಇಲ್ಲಿ ತೋರಿಸಿಲ್ಲ ಮತ್ತೆ release to me.
17. Number 18, Shri Manikanta HB.
Speaking mandamus, my lords.
In this matter, my lord, last occasion I took time, my lord. Akar bandal kere anta torti. Therefore, the case of petition cannot be considered, my lord. Therefore, I seek for some time, my lord, secure records, my lord.
Let them not dispossess us, my lords, from the land, my lords.
ನೋಟಿಸ್ ರೆಕಾರ್ಡ್ ಮಾಡ್ಬೇಕು ತಾನೆ, ಹಂಗೆ ಮಾಡಲ್ಲ.
My lords, but
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಮುಗಿಸ್ತೀನಿ.
can.
17. Shri number 19, Shri Sandeep Lahiri.
Millets, in this matter, I appeal for the petitioner Millets. Millets, the brief facts are this Millets, the petitioner has purchased 20 guntas of land Millets. In respect to this, Khata was not mutated. He has purchased in the year 2023. Since they were dilly-dallying, we had approached this honorable court Millets. On the last date.
1 minute, madam, 1 minute.
Please, Millets.
The process has been completed, my lord. AC has to give some, my lord, to complete the process, my lord. It takes some other weeks time, my lord.
List.
17.
Millets, may I request for 20th Millets? Grateful,
Number
Millets.
20, Shri Manikanta.
So it's seeking mandamus, my lords, wherein the extent of land has been reduced without there being any proceedings and notice, my lords.
This matter, my lord, last occasion I took time, my lord. As per the instructions, my lord, along with application, my lord, the petitioner has given not given any supporting documents, my lord. Therefore, notice has been issued. They have received the notice, my lord. When they have undertaken that, they will furnish the documents. Now,
Okay,
the state, my lord. If the documents are furnished, my lord, we will
What is annexure J?
Annexure J is the representation, my lords. Earlier, the lands, my lords, were.
ಇದಾದ್ಮೇಲೆ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ರು ಅವರು.
ಇದಾದ್ಮೇಲೆ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ವಿ. ನಾನು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಸೇರಿದಾಗ ಅವಾಗ ನೋಡಿ.
The prayer in this petition is to issue a direction to the respondent to consider the representation dated 26/7/2024, a copy of which is produced as annexure J. J on instruction submits that pursuant to the said representation, the Tahsildar had issued a notice to the petitioner calling upon him to produce certain documents. And the petitioner has also undertaken to produce the said documents. He submits that as soon as the documents are produced, the Tahsildar will consider the petition and pass separate orders within a period of 2 months from the date of receipt of the documents. According to the said submission, the petition is disposed of.
Great. Till number 21.
I appear for the petition. I'm seeking writ of mandamus. I purchased in the property in court action when I made the application for Kata.
Instructions are required, my lord, in this matter.
The list.
Weeks time.
17th. Till number 22.
Date maybe.
27.
ಗ್ರಾಂಟ್ ಮಾಡಿದ್ದಾರೆ. ಸಾಗುವಳಿ ಚಟ್ ಇಶ್ಯೂ ಮಾಡ್ಬೇಕು. RI
Take
ರಿಪೋರ್ಟ್ ಫೈಲ್
notice.
ಮಾಡಿದ್ದಾರೆ.
The prayer in this petition was for issuance of direction to issue a Sagoli chit. And consider the petition submits that in pendency of this petition, the Sagoli chit has indeed been issued to the petition. In the light of this said statement, the prayer in the
ಸಾಗುವಳಿ
petition.
ಚಟ್ ಇಶ್ಯೂ ಮಾಡ್ಬೇಕು. ಸುಮ್ಮನೆ ಇಶ್ಯೂ ಮಾಡ್ಬೇಕು ಅಂತ.
ಮಾಡಿದ್ರು ಅಂತ.
ಮಾಡ್ಬೇಕು ಅಂತ ರಿಪೋರ್ಟ್ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ ರೆವಿನ್ಯೂ ಇನ್ಸ್ಪೆಕ್ಟರ್, ಇನ್ನ ಮಾಡಿಲ್ಲ ಸರ್.
I will take notice, my lord. Start for issuance of Sagoli chit, my lord.
Kindly see annexure C, your lordship, the report filed by the
Assistant Preliminary.
24th. Till number 23. Sri Subramani.
Taking for a mandamus, my case for conversion is not considered for 2 years. Taking for a deemed conversion.
I will take notice in this. Start for conversion. Lord, I will take notice, my lord.
AJ accepts notice for respondents. Relisting preliminary.
24th. Till number 24. Shrikant NV.
In this matter, my lord, the 31 farmers were granted with the land, my lord. Lord, it was situated in the forest land. Hence, my
What is
lord,
annexure A?
annexure is, my lord, is a government order directing, my lord, for alternative land, my lord, to the 31 farmers. Actually, my lord, the 31 farmers had sold the property which was granted before, my lord, 15 years of that period, my lord. And my lord, subsequently, there is the principal secretary has directed the DC even to conduct, my lord, the inquiry.
Read page number 11.
Number 11. Please. ಆದೇಶ ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸಿರುವ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ರಿಟ್ ಅರ್ಜಿ ಸೋ ಪ್ರಕರಣ ನೀಡಿದ ನಿರ್ದೇಶನ್ವಯ ಸರ್ಕಾರದ ಆದೇಶ
Challenging an order by which alternative land is granted to you.
my lord, before that itself, my lord, the land was granted, my lord, there was direction for grant of alternative land, my lord, in survey number 110. My lord, as land was not available, my lord, to the extent of grant, the alternative land, they have come before this honorable court, and my lord, in terms of this honorable order of this honorable court, my lord, several in lands in several survey numbers were granted for my lord, alternative grant. But my lord, the thing is, my lord, suppression of fact, as my lord, farmers who have been granted with the forest land had sold it in the year 1999 itself, my lord, before, my lord, within the period of 15 years. And my lord, they kindly see, my lord, annexure.
No, I don't seem to understand. You wanted certain extent of land.
No, my lord. I'm seeking for inquiry into the, my lord, the grant.
You are not interested in the
No,
land.
no, my lord.
Annexure D, my lord.
I'm seeking for the, my lord, the inquiry into the grant.
Public interest ತರ ಇದೆ.
Public interest.
Please, authorized.
Annexure D is the, my lord, representative. Victims, my lord, is the
Annexure
Karnataka
D.
Pradesh Congress Committee.
Cancel the alternative land. For whom was this alternative land granted?
My lord, the 31 farmers, my lord, who have been granted with the forest land.
And you have not made them parties. And you're challenging an order in their favor.
my lord, I'm challenging, my lord, the government order.
What is the effect of me
Please.
quashing this order?
I will make them party.
But I'll dismiss it.
My lord, because, my lord, because kindly see, my lord, the annexure D has also. It's a letter written by the principal secretary. He went to inquire into the grant.
You gave it in next year, you gave this complaint in 2024. You are challenging a government order of the year 2020.
20 million.
Inge-
Lord, Lord, it has come to my knowledge as, Lord, because it is false, my lord. It is playing fraud on the government itself.
Where is the order passed by this court earlier?
Lord, first order
It is in, my lord,
next year. B, my lord.
annexure
Page
B,
13,
B, page number 13, my lord. Total 21 acres, 38 guntas of land was, my lord, alternatively granted. In survey number 110.
Dismissing your petition. I can't allow you to challenge it 5 years after the order is passed.
Lord, kindly see, my lord, the annexure, at least, my lord, annexure E, my lord.
No,
Annexure
that,
E.
that may be so, but you cannot come whenever you want and then ask an order passed in 2020 to be quashed.
Lord, or else I may be
You have
permitted
no
to, my lord,
interest.
file, my lord, PIL
Withdraw this petition into whatever you want to do.
with liberty to.
And consider the petitioner seeks permission to withdraw this writ petition and contends that he would file a public interest litigation. In view of the above, writ petition dismissed withdrawn, subject to the above.
Till number 25.
This matter, my lord, I seek for pass over.
Yes, sir.
Yes, sir. Pass over.
Sir.
Till number 26, Shri Chakrareddy.
License surveyor, my the petitioner has notified as the adjacent owner of the property, my lord. The respondent, private respondent has applied the survey for the Adbus, my lord. And without issuing the notice, my lord, without recording the statement of the
What is
petitioner.
annexure A?
My lord,
What is annexure A?
annexure A, my lord, the notice prepared by the license surveyor for conducting the Adbus. We are the adjacent owners, 20% has made as adjacent owners. We are in possession of the property, madam. Without the proper notice for number C, after the 46 rule H has applied the adverse sketch, he has to issue the interested persons to the notice for calling the documents or if any the rights in the properties, madam. He has not at all issued the notice. Next one, madam, 46 H rule 4 has to record the statements of the adjacent owners.
Has he passed any order now?
Madam,
It is only a notice, isn't it?
but he has not at all issued the notice and record the statements and prepare the sketch. But based on that sketch,
Under the notice, has he passed any order?
he has prepared the sketch, my lord. Prepare based on the sketch. Kindly see these documents.
Then challenge it separately. Now that this notice become infructuous.
My lord, he
If
has,
after this notice, he has in fact conducted a survey and prepared a sketch, then what is the point in quashing this notice?
my lord, he has to approve the sketch by the ADLR. Till now that the
This
sketch was not approved by the
this-
ADLR.
This notice has spent itself. If the DDLR or ADLR approves the sketch, challenge it by way of an appeal. How can I?
He has not approved the sketch. My the grievance, my lord. Still the sketch was not approved by the ADLR.
Correct.
My lord, now the
Pursuant to the notice, he has conducted some survey. He has prepared a sketch. Suppose the ADLR does not accept it and upholds your contention.
yes, my lord,
Then the matter
my lord, before that, my lord, they kindly see the rule 46H, my lord.
Why should I examine it now?
My lord, the entire the natural of justice for hearing the parties for the adjacent owners.
Suppose
and mandatory the
I do.
notice.
Suppose I give a finding that you have in fact been served. Then your right in the appeal will go.
But after the
Are you
finality of the sketch appeal provision is there,
Are you
can
prepared
file
to
the appeal.
take? Are you prepared to take that risk of me stating that
Well,
notice was served on you?
my lord, before that, we are filing the objections. Kindly see my petition.
ನೀವು appeal ಅಲ್ಲಿ
52, my lord,
ರೆಡ್ಡಿ ಅವರೇ ನೀವು appeal ಅಲ್ಲಿ ಇದ್ರ ದಯವಿಟ್ಟು ರಿಸರ್ವ್ ಮಾಡ್ಕೊಳ್ಳಿ.
my lord,
Don't invite a finding here.
my lord, one submission. Before the sketch, my lord, the date was fixed 19. We have filed the objections 15-2 and 18-2, 17-2. My lord, the license surveyor has no jurisdiction to hear the rights of the parties. The ADLR and the taluk surveyor has to hear my objections before the passing the any order. My lord, 15-2, we have filed the objection.
Have you filed objection to the ADLR?
Yes, my lord. That is
Consider and pass orders.
15-2.
And direct the ADLR to consider your objection and pass orders.
Yes, my lord. That is annexure H, my lord. Matter having stood thus, my lord, they provide the respondents. This is the
petitioner
applicant.
is seeking for quashing of the notice issue by the license surveyor, contending that the procedural requirements have not been complied with by the licensed surveyor. It is not in dispute that the license surveyor has prepared a sketch and sent the same for approval to the ADLR. It is also not in dispute that the petitioner has filed objections to the
Yes, my lord.
action taken by the license surveyor as per the representation dated 17/2/2025, a copy which is produced on Annexure H
H1.
and H1. Consider the petitioner does not dispute the fact that the sketch would become effective only on its approval being granted by the DDLR. So, in the light of the fact that objections have been filed by the petitioner on 17/2 and 18/2/2025, but annexes H and H1 before the ADLR and DDLR, and it would be appropriate to dispose of the petition directing the ADLR and DDLR to consider the objections filed by the petitioner before considering the sketch prepared by the license surveyor for approval. So, writ petitions are going to be disposed of.
My lord, until that, my lord, should not evict the petitioners. This is
ಅಪ್ರೂವ್
the-
ಆಗೋವರೆಗೂ ಏನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ ಇಲ್ಲ ಚಕ್ರೆಡ್ಡಿ ಅವ್ರು, ನೀವು ತುಂಬಾ ಬೇಗ ಬಂದ್ಬಿಟ್ಟಿದ್ದೀರಾ.
They are the
ಹೆಂಗಾಗತ್ತೆ ನಾವು
JSTP and all these things. And but based on this is,
ರೆಡ್ಡಿ ಅವ್ರು ನೀವು ಹೇಳ್ದಂಗ್ ಮಾಡಕ್ಕಾಗಲ್ಲ, ನೀವು ಅವ್ರು ಇನ್ನೂ ಅಪ್ರೂವ್ ಮಾಡಿಲ್ಲ, ನೀವು ಆಗ್ಲೇ ಇಂಜೆಕ್ಷನ್ ಕೇಳ್ತಾ ಇದ್ದೀರಾ.
my lord,
That means you are telling me that you are not in unauthorized possession.
no, my lord, in this position, my position was notified by the license surveyor also.
Number 27, Shri.
And time may be fixed for the disposal of.
ಬಿಡಿ, ನೀವು ಸ್ವಾಧೀನದಲ್ಲಿ ಸುಮ್ಮನೆ ಯಾಕೆ ಅದನ್ನ ಇದು ಮಾಡ್ಕೊಳ್ತೀರಾ?
Yeah, for the petitioner, my lord.
What is annexure A?
Annexure A is an order passed by the Tehsildar summarily evicting me under 104 without providing any opportunity, my lord, more particularly.
ಏನ್
This
ಮಾಡ್ತಾರೆ?
may be treated as notice, my lord. Pass.
Well, objection to this. I'll ask him to consider this as a show cause notice.
Might I just take my lord to annexure B and C for 1 second? 1 second. My lord, they claim there is a Kaludari, but annexure B is the RTC in which there is no B Karab at all.
Raise that objection. Why do you want to invite a finding from me? The petitioner is challenging a notice dated 27/1/2025, a copy of which produces annexure A. By the said notice, the Tahsildar has stated that the petitioner has encroached upon a pathway and he would have to be evicted from that encroachment. And we have stated that the encroachment should be cleared. A perusal of annexure A would indicate that this notice was not preceded by any show cause notice. And unilaterally, the Tahsildar has come to the conclusion that the petitioner has encroached upon the pathway. The petitioner strongly contends that he has not encroached upon any pathway, and the RTC maintained by the revenue authorities itself belies this assertion, BELIES. Since there was no show cause notice issued prior to the issuance of annexure A, in my view, it would be appropriate to dispose of the petition by directing the petitioner to treat annexure A as a show cause notice and file its objections within a period of 3 weeks from the date of receipt of copy of this order. On such objections being filed, the Tahsildar shall consider the objections raised by the petitioner and pass appropriate orders after hearing the petitioner. And until then, no course of action shall be taken by the Tahsildar. That petitioner could not disposed of.
Deeply obliged.
Still but 28. Petitioner in this case. Made a mention with regard to the office subjections. He says the order of the learned deputy commissioner in the cost title mistaken name was.
Who's R4 and R6?
R4.
That's point number 5, my lord.
This one contesting.
R4 here.
R4 and 6 are, one is the Balaraj. He claims to be the one of the legal heir of Arogya Swami. That's the petitioner's father.
One of the legal heirs of Arogya Swami.
Not one of the other. He is the legal heir. That's what he's saying. He has nothing to do with this land at all. He's not related to Arogya Swami at all.
But party ಮಾಡಿದ್ರೆ ಅವ್ರನ್ನ
ನಾವು ಪಾರ್ಟಿ ಮಾಡಿದ್ರೆ ಅವರಲ್ಲಿ ಕೆಳಗಡೆ ಪಾರ್ಟಿ ಮಾಡಿದ್ರೆ ನಾವು we have party made him as a party. However, they are all
takes notice for R4 and R6.
R4.
No, my lord, we are not concerned about R4 and R4.
R4 ಗೆ
R4 is the
ಕೆಳಗೆ
seller of the property, my lord.
ಯಾರಿಗೂ ನೋಟಿಸ್ ಆಗಿಲ್ಲ. ನೋಟಿಸ್ ಆಗದೆ ಪಿಟಿಷನ್ ಫೈಲ್ ಮಾಡಿದ ದಿವಸನೇ ಆರ್ಡರ್ ಆಗಿದೆ. 7/2/2005, this report number 5 filed a revision petition. Same day order was passed without holding any conducting any inquiry. And 2 prayers were sought. One for quashing the order of the learned assistant commissioner. Second, in directing the entry to be made in the revenue records regarding the civil suit between the respondent number 4 and 5. Order passed in the same.
What is the civil suit about?
That is a specific performance according to them he has filed.
We have filed a respondent number 5, filed a SP suit.
An interim order is.
You have filed the super.
Please, my lord.
Until you get a decree, how can you?
No, interim, there is the interim order, my lord. We are approaching the respondent number 1 to enter the interim order in RTC because there was some transaction happened in that place.
What was the order that was challenged for the DC?
We have challenged the AC order for Potitrata. Legal heirs Potitrata.
You are for Indrama, correct?
May I make a
We
suggestion?
are for Indrama.
Please, my lord.
Indrama is challenging the order passed by the assistant commissioner.
Assistant Commissioner.
What was the order of the assistant commissioner?
Assistant Commissioner made by order that Potitrata direct the Tahsildar to inquire the file and made a party enter to Potitrata. Legal heirs of the legal heirs of the Arogya Swami, the petitioner.
That is R4.
They are claiming Arogya Swami, my lord. We are Arogya Swami. We are claiming Arogya Swami.
You challenge the order of the assistant commissioner.
Please, my lord. Howdu.
Entries were ordered to mutated in favor of the LRs of Arogya Swami.
Howdu.
What is your right?
We are rights to they have not made a party. Balraj. Balraj is the legal one of the legal heir of the. Now purchaser of the
Is there a registered
sale agreement? A registered sale agreement.
Registered sale agreement, registered sale difference ಇದೆ ಅಲ್ವಾ?
ಹೌದು.
ನಿಮ್ಗೆ ಸೇಲ್ ಇಟ್ ಬರೋವರೆಗೂ ನಿಮ್ಗೆ ಏನು ಅಧಿಕಾರ ಇದೆಯಾ?
ಎಂಟ್ರಿ ಮಾಡ್ರ ಆಗಿದೆ ಮೇಡಮ್, ನಾಟ್ ಟು ಎಲಿನೇಟ್ ದ ಪ್ರಾಪರ್ಟಿ ಅಂತ. ದೇ ಮೇಡ್ ಎ ಅಗ್ರಿಮೆಂಟ್ ಬಿಫೋರ್ ಅನದರ್ ಪಾರ್ಟಿ.
If you have secured an interim order, that's a separate application you need to make.
In that petition we have made that order also.
ನೀವು ಅಪೀಲ್ ರಿವಿಷನ್ ಹಾಕಿರೋದು.
ರಿವಿಷನ್ ಎರಡು ಪ್ರೇಯರ್ ಕೇಳಿದ್ದು ಸ್ವಾಮಿ. ಕ್ವಾಷನ್ ಆಫ್ ದಿ ಎಸಿ ಆರ್ಡರ್.
ಡಿಸಿ ಮುಂದೆ ಇರೋದು ವ್ಯಾಲಿಡಿಟಿ ಆಫ್ ದಟ್ ಆರ್ಡರ್ ದಿ ಎಸಿ ಅಷ್ಟೇ. ಜೊತೆಲಿ ನಿಮ್ದು ಎಕ್ಸ್ಟ್ರಾ ಪ್ರೇಯರ್ ಹೆಂಗ್ ಸೇರ್ಸಕ್ಕಾಗತ್ತೆ?
ಎಂಟ್ರಿ ಮಾಡ್ರೆ RTC ಅವರು
ಅದು ತಹಸೀಲ್ದಾರ್ಗೆ ಹೋಗ್ಬೇಕು, ಅಲ್ಲಿ ಅರ್ಜಿ ಕೊಡ್ಬೇಕು, ಅದಾದ್ಮೇಲೆ ಕೊಡ್ಲಿಲ್ಲ.
They have not entered ಮಾಡಲ್ಲ. We have given that copy.
So ಅದು ಸಪರೇಟ್ ಆಗಿ ಹಾಕೊಳ್ಳಿ. But how can this order be passed at your instance? How can the revision have been entertained at your request? You don't have a title as of now.
We are not title, madam, but a title owner not made a party in AC, my lord.
ನಿಮ್ಮನ್ನ ಯಾಕೆ ಪಾರ್ಟಿ ಮಾಡೋದು ನಂಗೆ ಅರ್ಥ ಆಗ್ತಿಲ್ಲ.
ಅಲ್ಲ ನಮ್ಮನ್ನಲ್ಲ, ನಮ್ಮ ಸೆಲ್ಲರ್ನ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ.
ನೀವ್ ಹೆಂಗ್ ಬರ್ತೀರಾ ಇದಕ್ಕೆ?
ಅವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ. ಇದು ಆರೋಗ್ಯ ಸ್ವಾಮಿ ಲೀಗಲ್ ಏರ್ಸ್ ಅಂತ ಯಾರ್ಯಾರೋ ಬರ್ತಾ ಇದಾರೆ, ಅದಕ್ಕೆ ನಾವು ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿ.
ನಿಮ್ಗೆ ಆರೋಗ್ಯ ಸ್ವಾಮಿ ಎಲ್ಲಾರು ಯಾರು ನಿಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ, ನೀವ್ ಆಮೇಲೆ ಬಂದಿರೋರು.
ಹೌದು.
ಸೊ ನೀವೇನ್ ಹೇಳ್ತೀರಿ, ಯಾರು ಅವ್ರು ವಾರಸ್ದಾರು ಅಂತ?
ಅದಕ್ಕೆ ನಾವು ಅದಕ್ಕೆ ಸಪರೇಟ್ ಸೂಟ್ ಫೈಲ್ ಮಾಡ್ತೀವಿ. ಟಿಲ್ ದಿ ಡಿಸ್ಪೋಸಲ್ ಆಫ್ ದಿ ಸೂಟ್ ನಾವು RTC ಎಂಟ್ರಿ ನಾವು ಕೇಳ್ತಾ ಇದೀನಿ.
ಪ್ರಿಯಂಟಿವ್ ಮಾಡ್ಬೋದಾ? ನಾನು ದಾವಾ ಹಾಕ್ತೀನಿ, ದಾವಾ ಹಾಕೋರ್ಗು ನೀವು ಖಾತೆ ಹಿಂಗಿಟ್ಕೊಡಿ ಹಂಗಿಟ್ಕೊಡಿ.
ಇಲ್ಲ ನಾವು ಅದಕ್ಕೆ ನಾವು ಲೀಗಲ್ ಏರ್ಸ್ ಯಾರು ಹುಡ್ತಿದ್ದಾರೆ, ಅದರಿಂದ ಟಿಲ್ ದಿ ಡಿಸ್ಪೋಸಲ್ ಆಫ್ ದಿ ಸೂಟ್
ಅವ್ರು ಹುಡ್ತಾನೆ ಇರ್ತಾರೆ. ನಿಮ್ಗೆ ಹೆಂಗ್ ಬರ್ತೀರಾ ಇದ್ರ ಮೇಲೆ? ನಿಮ್ಗಿನ್ ಕ್ರಯಪತ್ರನೇ ಬಂದಿಲ್ಲ.
ಕ್ರಯಪತ್ರ ಬಂದಿಲ್ಲ.
ಕ್ರಯಪತ್ರ ಬರೋರ್ಗು ನಿಮ್ ಅಧಿಕಾರ ಇಲ್ಲ ಈ ಮ್ಯಾಟರ್ ಬರಕ್ಕೆ.
Please kindly day after tomorrow, my lord, we will file detailed objection.
Can detailed objection?
Day after tomorrow. Please, ma'am.
I'm allowing the revision.
Please, sir, day after tomorrow.
Then in the event you succeed in the suit and the decree is registered, only then you will get a right.
Kindly have day after tomorrow, ma'am.
Day after tomorrow.
Much obliged.
ಅಷ್ಟೆಲ್ಲ ಅವ್ರನ್ನ ಕರ್ಕೊಂಡ್ ಸರ್ವ್ ಮಾಡಿಸಿಲ್ಲ ಅಂದ್ರೆ ನಿಮ್ಗೆ ತೊಂದರೆ ಆಗುತ್ತೆ.
ನಮ್ದು ಸಿಗ್ತಾ ಇಲ್ಲ ಮೇಡಮ್. ಅವ್ರು R6 ಇಲ್ಲ R4ಗೆ ನಾವು ಇದು ಮಾಡ್ತೀವಿ.
ನಾವು ನಿಮ್ಮವ್ರ ಹತ್ರನೇ R4 ನಿಮ್ಮವ್ರ ಹತ್ರನೇ
R4 ನಮ್ಮ.
ಅವ್ರ ಕರ್ಕೊಂಡ್ ಸರಿ ಮಾಡಿಸ್ಕೊಡಿ, ಇಲ್ಲಾಂದ್ರೆ ನೀವು ಅವ್ರ ಆಬ್ಸೆನ್ಸ್ ಅಲ್ಲಿ ಆರ್ಡರ್ ಮಾಡ್ಬಿಡ್ತೀನಿ ನಾನು. ನನ್ನ ಪ್ರಕಾರ ನಿಮ್ ರಿವಿಷನ್ ಮೇಂಟೈನಬಲ್ ಅಲ್ಲ.
Much obliged.
Number 29, Narsimraj.
Serial number 2930, my lord. These are for mandamus direction for consideration of Form 53 and 57.
Serial number 29, my lord, 6 for another week's time, my lord. Serial number 30, my lord, the Tahsildar has recommended, my lord, to the deputy commissioner to take this application, my lord, because it comes under the forest land.
They have made a represent, it is Form 53 has been made in the year 1999.
He's saying that the recommendation has been made to reject the application.
Because it is.
So once they reject the application, file a writ petition. Don't keep this petition pending. I'll record a statement that matter is referred to the DC, holding that you're ineligible. If you were to accept the recommendation and pass an order, then you can challenge that order. The prayer in this petition is to direct the third respondent to place the claim of the petitioner for regularization before the committee constituted for considering the applications for regularization of unauthorized occupation. AGA on instruction submits that the Tahsildar on inquiry has come to the conclusion that the petitioner was ineligible for being considered as an unauthorized occupant, and as therefore forwarded the papers along with his recommendation to the deputy commissioner for rejection of the petitioner's claim. In the light of the said statement, it is clear that the claim of the petitioner has been considered and steps have been taken with the concerned Tahsildar, and therefore the prayer of the petitioner would not survive consideration. However, it is made clear that in the event the deputy commissioner accepts the recommendation of the Tahsildar and holds that the petitioner was ineligible to be considered as an unauthorized occupant and that his unauthorized occupation was to be regularized, petitioner would be at liberty to challenge the said order of the deputy commissioner.
Serial number 31, Shri Venkata Subbarao.
Petition pass on, the engaging quarter 8, my lord. Pass on.
ನೋಡಿದ್ದೀರಾ?
Total 10 matters is there.
Lord, the where, my lord, it is functioning, my lord. The grievance, my lord, it by granting an interim order with liberty, my lord, to file an appeal before the RERA.
What is the next area?
Chairman function ಮಾಡ್ತೀನಿ my lord. ಹೇಳೋದಿಲ್ಲ.
Next area, my lord, that is recovery certificate. Attachment orders has been issued, my lord, in all these matters, my lord.
My lord,
Earlier.
my lord, one small, just to assist the lordship, my lord. In this section 40 and 25 of 40 of RERA Act, my lord, and RERA rules 25, my lord. For this recovery of arrears of land revenue, my lord, it should be done through the government only, my lord. It's not appeal.
ನೀವ್ ಯಾರಿಗಿದ್ರಲ್ಲಿ?
ನಾನು ರೇರಾಗೆ ಮಾಡಿ ಮೀನ್ಸ್ ಐ ನಾಟ್ ಟೇಕನ್ ನೋಟಿಸ್, ಜಸ್ಟ್ ಮಂಜುನಾಥ್ ಅವರು ನನಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ರು. ಐ ಜಸ್ಟ್ ವಾಂಟ್ ಟು ಟೆಲ್.
There is an order of this honorable court, my lord, annexure P, my lord, in writ petition number 6380, because
Annexure
6380, my lord, may I request, my lord, to take petition number 6380 of 25.
380
plus MC. Because ಎಲ್ಲಾದ್ರಲ್ಲೂ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿ ನಮ್ಗೆ ಯಾವ ಕಾಪಿ ಸರ್ವ್ ಆಗಿದೆ ಅದ್ರ
ಎಲ್ಲ ಒಂದೇ ಮ್ಯಾಟರ್ ಇದು.
ಎಲ್ಲ ಒಂದೇ ಮ್ಯಾಟರ್. ಪಾಸ್ ಆನ್ engaging 8 ಮೇಲೆ
annexure P, the order passed by this honorable court, my lord, in WP number 14473 of 24.
Annexure D na.
Annexure P, my lord, page 124. Wherein the challenge at the award passed by the authority, my lord, and this court, my lord, paragraph 3, my lord, therefore till the appellate tribunal takes up the appeals of the petitioners for a period of 12 weeks, whichever is earlier, the respondent shall not precipitate the matter against the petitioners with the.
Serial number 39 urgana?
39 and 57 also.
39 and
57.
Give him the copies of the writ petition. Yella copies.
Serial number 40. For the
petitioners, my lord, the elders of the original grantees by the land tribunal.
Respondent in this case.
Uh,
Cavator, respondent file number 5.
Ready na?
So, my annexer AB has been challenged by the petition number 3 and 4 and got obtained stay from the Deputy Commissioner Tumkur. This petition is not maintained.
No, you ready na eno?
Well, not ready. For objection, 2 weeks may be granted. Detailed objection.
Lord, I sought the injunction. If your lordship can grant me some 3 to 5 minutes, I will make out.
I don't mind granting you 10 minutes. But if he takes time for filing objections, then
Until then, my lord, he doesn't have any right. The land belonging to the tenants is being invaded by them. There is a threat of disposition.
What
I have
is-
prayed for temporary injunction also.
who are you?
My lord, I am the tenant, LR of the tenant. May I take your lordship only for 2 minutes.
What is the order that you are challenging here?
My lord, the order passed by 4th Assistant Commissioner, when there is no land remaining at all, with the,
Ask not about which section.
my lord, 25, 26 of Land Revenue Act. And there are 4 impugned orders.
Where is the order of the Assistant Commissioner?
My lord,
Where is the order of the Assistant Commissioner? Where is the order of the
my lord,
Assistant Commissioner?
my lord, volume 3, volume 2,
Volume 3, 5.
annexer, my lord, AQ,
Page number?
my lord, 559.
Volume 3.
The relevant page, my lord. Before that, my lord, this is his appeal. For a minute, I want to take your lordships to annexer AN. The relevant page is
This
556.
is the order that you are challenging now?
Please,
2024 order?
there are 4 orders. And for which I was not a party at all. And such a glaring mistake when there no land is available for entering his name, and he seeks entry of his name to the extent of 36 guntas, whereas the Assistant Commissioner orders to enter the name for 1 acre 5 guntas.
This was an appeal filed by one Ananta.
Ananta, he is a respondent number 5 here. So he's in his appeal memo at page 556, he requests to enter his name to the extent of only 36 guntas if it is available. Whereas, my lord, he suppresses for a minute 556. 2 of the lands measuring 21 guntas each have been sold by the owner in title, his predecessor, to wide annexes G and H to the elders of the petitioner's hearing. When no land is remaining for entering his name, the Assistant Commissioner orders to enter his name to the extent of 1 acre 5 guntas. Instead of 36 guntas, he seeks. Even that too is not available. And for a minute, I want to take your lordships. Only for 1 minute, I want to take your lordships to annexer K.
You said you are the tenant. You said you are the tenant.
I am the tenant.
Of whom?
My lord, under the predecessor.
So your name will never come in the revenue records.
My name came in the record of rights in this certain period. And after that, my lord, for no reason, 2 bogus entries continued.
How are you concerned about this entry in column number 9? You are a tenant.
I am a tenant.
Did you file a form number 7?
Yes.
Was it granted?
Granted. I take your lordships to page 131.
Was it granted?
Yeah, granted.
Form number 10 is issued.
Issued.
Now, pursuant to form number 10, your name is entered.
Yes.
Then if your name is entered by virtue of annexure AB, has your name been deleted now?
Yeah, it is deleted.
Where?
My lord, may take your lordships to.
Show me from the order that your name is to be deleted.
Nay. For a minute, I want to make out a case, my lord, but before that, I want to take your lordships to annexer K, the order of the land tribunal.
Show me from this order that your name is to be removed from the revenue records.
Records that has been removed.
From this order.
Sir, annexure R.
Next,
Page number 268.
ನಿಮ್ಮ ಹೆಸರೇನು?
My lord, in tenancy, my lord, my name is Chikkannappa, son of Tumkuraya, and Chikkamma, wife of Doddaya, Narsiyappa, son
What
of
is the total extent of
Chikkannappa.
the survey number 239? What is the extent of the survey number 239?
Total extent 8 acre 23 guntas.
8 acre?
23 guntas.
And how much are you claiming as a tenant?
My lord, as a tenant, I am claiming 19 guntas
plus 18
Totally,
guntas plus
totally,
20,
total.
totally around 2 acre 20 guntas.
So out of 8 acres, you're
Yes.
only claiming 2
Yes,
acres.
yes. So,
Sorry.
good.
Sir, 5
No,
Three-
no, she's giving you a different.
One minute, my lord. Out of 8 acre 23 guntas, 5 acre 12 guntas have been granted by the land tribunal to us and other tenants. There are 12 tenants.
Total 5 acres.
5 acres 12 guntas granted by land tribunal.
So roughly about 3 acres are not remain.
No, 2 acre 2 guntas has been sold by the present title to one Ramaya and 3 of the tenants by sale deeds. So that comes to 2 acre 2 guntas. So actually, my lord, the extent that remains is around 4 to 12 guntas. That too has been.
Now come to the operative portion 563. Operative portion, read that order.
Please. Yes. ಕರ್ನಾಟಕ ಭೂಕಂಪ ಅಧಿನಿಯಮ 64 ಸೆಕ್ಷನ್ 22 ಪ್ರದತ್ತ ಅಧಿಕಾರವನ್ನು ಚಲಾಯಿಸಿ ಮೇಲುವೆಯನ್ನು ಭಾಗಶಃ ಅಂಗೀಕರಿಸಿದೆ. ಪ್ರಕರಣದಲ್ಲಿ ತುಮಕೂರು ತಾಲೂಕು ಕಸಬಾ ಉತ್ತರ ಹೋಬಳಿ ತುಮಕೂರು ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 239 ದುರಸ್ತಾಗಿ ಪರಿವರ್ತನೆಗೆ ಸರ್ವೆ ನಂಬರ್ ಪರಿಶೀಲಿಸಿಕೊಂಡು ಸರ್ವೆ ನಂಬರ್ 231 1B/1 ವಿಸ್ತೀರ್ಣ 1 ಎಕರೆ 27 ಗುಂಟೆ ಜಮೀನಿನಲ್ಲಿ ವಹಿವಾಟು ನಡೆಸುವ ವಿಸ್ತೀರ್ಣವನ್ನು ಕಳೆದು ತಾಲೂಕು ಮೊದಲ ನಿಖರವಾದ ಸ್ಕೆಚ್ ವರದಿ ಪಡೆದುಕೊಂಡು ಪರಿಶೀಲಿಸಿ ಸುಬ್ಬಮ್ಮನ ಆರ್ಟಿಸಿ ನಮೂದಿಸಿಕೊಂಡು ಸುಬ್ಬಮ್ಮನ ಕುಟುಂಬದವರು ಮಾಡಿಕೊಂಡು ರಿಲೀಸ್ ಹಕ್ಕು ಪತ್ರದ ದಸ್ತಾವೇಜು ಸಂಖ್ಯೆ 7 ಮೇರೆಗೆ ಕರ್ನಾಟಕ ಭೂಕಂಪ ನಿಯಮ ಸೆಕ್ಷನ್ 170 ಕ್ರಮ ಜರುಗಿಸಿ ವಹಿವಾಟು ದಾಖಲೆ ಮಾಡಿ ವೀರಭದ್ರಯ್ಯನ ಹೆಸರು ನಮೂದಿಸುವ ಆರ್ಟಿಸಿಯಿಂದ ಕೈ ಬಿಡಲು ಸಂಬಂಧಪಟ್ಟ ಆರ್ಟಿಸಿ ಹಕ್ಕುದಾರರು ಹೊಂದಿರುವ ಅಧಿಕೃತ ಆದೇಶದಂತೆ ಹೊಂದಿರುವ ಹೆಸರನ್ನು ನಮೂದು ಮಾಡಿ ತಾಳೆ ಮಾಡಲು ನಿಯಮಾನುಸಾರ ಕ್ರಮ ಜರುಗಿಸಲು ತುಮಕೂರು ಅವರಿಗೆ ಆದೇಶಿಸಲಾಗಿದೆ.
Yes, he has directed a survey to be conducted after taking into consideration the transactions are already done by Subbamma, and then consider the claim.
Yes.
In what way are you saying that you'll be affected?
Well, here, how
this is in respect of 1 acre 27 guntas only.
My lord,
this order is confined only to 1 acre 27 guntas. The other extent is not touched.
Not touched. But how?
Why?
Pursuant to this order, wrongly interpreting respond of the 4th Tahsildar creates another impugned order at annex EQ. For a minute, may I take your lordships? Here.
Page number?
My lord, 564. Before that, my lord, I want to take your lordships to page 556.
No. This is, what is the date of this order?
My lord, this is dated 16/12/2021.
20, and you are filing it in 2025.
Please, my lord, I was not a made a party. When they came to dispossess me from the land, I came and I have put.
Let him file objections.
I mean, until then, not to alienate. One nimsham, my lord. I want to make out a case.
Next Monday. You are still objections, I'll consider as claim for interim.
For a minute. 21st May.
ನೀವು ಡೇಟ್ ಹೇಳಿ ಯಾವ ಡೇಟ್ ಬೇಕು ಹೇಳಿ.
21st. And if given some little more time, my lord, I will make out a case.
You're challenging an order of the year 21.
No.
He's filed caveat. Should I not grant him at least some reasonable time?
ಅವ್ರು ಏನ್ ಮಾಡಿದಾರೆ ಅಂದ್ರೆ ಯಾರಿಗೋ ರೆಂಟ್ ಅಗ್ರಿಮೆಂಟ್ ಮಾಡ್ಕೊಟ್ಟು ಅಲ್ಲಿ ಬಂದು ಗಲಾಟೆ ಮಾಡಿ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಹೋಗಿದೆ.
ಏನ್ ಮಾಡಕ್ಕಾಗುತ್ತಾ? ನೀವ್ ಗೆಲ್ತಿರಲ್ಲ, ಗೆದ್ದಾಗ ಎಲ್ಲ ಹೋಗುತ್ತಲ್ಲ. ನೀವ್ಯಾಕೆ ತಲೆ ಕೆಡ್ಸ್ಕೊಳ್ತಾರ?
ಅಲ್ಲ, ವೇರ್ ಇನ್ ಪೊಸಿಷನ್.
41.
21st for preliminary hearing, my lord.
Same stage. Same stage.
Same stage.
Sir.
Who's for the petitioner?
Saji P. John.
Appearing for the petitioner, my lord. My lord, in this matter, Annexure A came to be issued, my lord, based on a letter issued by the second respondent. Official liquidator had issued a communication to the Tahsildar, my lord. It is furnished at Annexure H.
What is Annexure A?
Annexure A is the MR or mutation order passed, whereby Runagalu has been created in respect of the RTC, in respect of the property which is in my custody and possession. I've been in ownership and custody from 2005 onwards, and my predecessors in title are there in possession from past 50 years. It is nowhere related to the company in liquidation. Whatever transaction which...
Don't you have an appeal against this order?
My lord, without any notice or any information, out of the blue,
appeal idyo illo?
Appeal is had they been followed up with the proceedings, obviously I had to be before the assistant commissioner challenging that, my lord, without any knowledge of, without informing me. I'm totally unaware about any of the transaction. Out of the blue, the charge has been created
in the Government of Ministry of Corporate Affairs, OLB, based on a letter
an
issue.
appeal. Why do you want to invite an order here? Once something is decided here, all your rights come to an end. AC ಇದೆ, DC ಇದೆ, ಆಮೇಲೆ ಇಲ್ಲಿ ಬನ್ನಿ, ಇಷ್ಟು ಬೇಗ ಅವಸರ ಮಾಡ್ಕೊಂಡು ಯಾಕೆ ಬರ್ತೀರಾ?
My lord, without any information, our OL
Suppose I were to
letter
hold-
ಕಳ್ಸಿದ್ದಾರೆ ಅಂದ್ಬಿಟ್ಟು charges create ಮಾಡಿದ್ದಾರೆ. So I have been in free position and no charges is been there. That is the reason I
Only a charge is created ಅಂತ ಬರ್ದಿದ್ದಾರೆ. You can go and tell them that no charge can be created. Go file an appeal. Why do you want to come and litigate here? Suppose I were to say that yes, charge is created, then what is your remedy? ಮುಗಿದೋಗುತ್ತೆ ಇಲ್ಲ ನಿಮ್ಗೆ? ಅಲ್ಲಿ ಹೋಗಿ ದಯವಿಟ್ಟು. As the order impugned is an order of mutation passed with Tahsildar. In the light of the fact that there is a statutory appeal provided under 136(2) to the Assistant Commissioner against an order of mutation passed by Tahsildar, it would be inappropriate to entertain this writ petition. Writ petition is therefore dismissed, reserving liberty to the petitioner to approach the Assistant Commissioner as against the impugned order.
Number 42, Shri Dayalu KN.
The response 6 to 7 had filed the suit for declaration.
Respondents?
6 to 7, 4 to 7, 6.
Ah.
Had filed the suit for the declaration to declare the gift deed which had been executed by the mother of the petitioner, and also the sale deeds which had been executed prior to this property which had been sold to the mother of the petitioner, my lord. And all the sale deeds and gift deed were declared to be null and void. Then, my lord, immediately, my lord, I approached this honorable court in appeal, wherein the judgment and decree was stayed. By judgment, by order dated 13th April.
They had filed a suit which is now decreed.
Please, my lord.
They had filed a suit which was decreed. ಅವ್ರ ದಾವ ಡಿಕ್ರಿ ಆಯ್ತಲ್ವಾ?
ಹೌದು.
ಅದ್ರ ಮೇಲೆ ಅಪೀಲ್ ಹಾಕಿ.
ಅದ್ರ ಮೇಲೆ ಅಪೀಲ್ ಹಾಕಿ, ಅಪೀಲ್ ಅಲ್ಲಿ ಜಡ್ಜ್ಮೆಂಟ್ ಅಂಡ್ ಡಿಕ್ರಿ ವಾಸ್ ಸ್ಟೇಡ್ dated 13th April 2023. When the judgment and decree was stayed, ignoring the order of this honorable court, the Tahsildar, despite the fact it was brought to the notice of Tahsildar as to judgment stay of the judgment and decree, muted the property in the name of the father of 4 to 7, 4 to 6. Then after the death of the father,
ನಿಮ್ಗೇನ್ ಇಂಟ್ರೆಸ್ಟ್ ಇದರಲ್ಲಿ?
we are the owners of the property. I am the owner.
Mother of the petitioner.
I am the owner. Pandyan RTC, which had been mutated from the year 2013, it was still in my name till 2023-24.
ಕೆಲವ್ರೆ, ನಿಮ್ಮ ಹೆಸರು ಶಾಂತಪ್ಪ ಅಂತ
ಹೌದು.
ಅಲ್ವಾ? ನೀವೇನೋ ನಿಮ್ ಮದರ್ಗೆ ಅಂದ್ರಲ್ಲ, ನಂಗೆ ಅರ್ಥ ಆಗ್ಲಿಲ್ಲ.
Mother had gifted the property to me. How I became the owner of the property.
Your mother had gifted the property to you.
She had purchased the property and gifted the property to my name.
So who are respondents 4 to 7? They related to you.
They claim to be all the earlier owners. All sale deeds they seek for cancellation of sale deeds and the gift deed. The court declares it as null and void.
They challenge the sale deed that they had executed in favor of your mother.
Please, gift deed. Gift deed and all sale deeds of my predecessor in title. All documents were declared to be null and void.
ಇಲ್ಲ, ನಿಮ್ ತಾಯಿ ತಗೊಂಡಿದ್ ಕ್ರಯಪತ್ರ ಮುಖಾಂತರ ತಾನೆ
ಅದು null and void.
ಆಮೇಲೆ ನಿಮ್ಗೆ ಗಿಫ್ಟ್ ಡೀಡ್ ಮಾಡಿದ್ದು.
ಹೌದು.
ಆ ಕ್ರಯಪತ್ರಗಳು ಅಸಿಂಧು ಮಾಡಿದ್ದಾರೆ ಈಗ
ಮಾಡಿದ್ದಾರೆ
ಅಲ್ವಾ?
ಆವಾಗ this was stayed in this judgment, I mean appeal.
Where is the stay granted?
My lord, at page annexure G, page number 22.
Where is the order of mutation passed?
My lord, annexure J and K.
When was that?
My lord, this was on 2/12/23. 2/12/23. Ignoring the order.
Lord, annexure N, my lord, page number 36.
Annexure J and K.
The endorsement has been issued by the my lord deputy commissioner, stating that my lord, since the
J ಬಂದ್ಬಿಟ್ಟು 2/12 ನಲ್ಲಿ mutate ಮಾಡಿದ್ದಾರೆ. And appeal, my lord, I preferred appeal.
This case is that his name was in the revenue records
this
and the decree has been stayed and afterwards it has been changed. Get instructions. AJ to take notice for response 1 to 3. Issue notice to respondents.
J and K to be stayed.
ಈ ಅದು 23ನೇ ಇಸ್ವಿಯಲ್ಲಿ ಚೇಂಜ್ ಆಗಿದೆ.
ಆ?
23ನೇ ಇಸ್ವಿಯಲ್ಲಿ ಚೇಂಜ್ ಆಗಿದೆ ಅವ್ರ ಹೆಸರಲ್ಲಿ.
My lord.
23ನೇ ಇಸ್ವಿಯಲ್ಲಿ ಚೇಂಜ್ ಆಗಿದೆ ಅವ್ರ ಹೆಸರಲ್ಲಿ.
ಹೌದು.
ಇವಾಗ ನಾನು ಸ್ಟೇ ಮಾಡಲ್ಲ ಫಸ್ಟ್ ಟೈಮ್.
ಅಲ್ಲ, ನಾನು ಹೇಳ್ತಿರೋದು ಏನದು? ಅಲ್ಲ, ಹೇಳ್ತಾ ಇರೋದು. This was challenged in the revision petition.
ಅರ್ಥ ಆಯ್ತು. 2 ವರ್ಷ ಆದ್ಮೇಲೆ ಸ್ಟೇ ಕೊಟ್ಟಿಲ್ಲ ನಿಮ್ಗೆ?
ಅಲ್ಲ, ಒಂದು ನಿಮಿಷ ಹೇಳ್ತಾರೆ. J&K, my lord, this was done in 23. I preferred appeal before the assistant commissioner.
23 ಲ್ಯಾಗರ್ ಆರ್ಡರ್ ಇವಾಗ ಎಫೆಕ್ಟ್
Appeal commission, appeal ಹಾಕಿದ್ದೀನಿ. Assistant commissioner rejected.
ರಿಲೀಸ್ಟ್
ಅದ್ರ ಮೇಲೆ ಡೆಪ್ಟಿ ಕಮಿಷನರ್ will not interfere.
ಅವ್ರಿಗೆ ಸರ್ವಿಸ್ ಮಾಡಿಸಿ ನಾನು
Submission.
ನಾನು ಇವಾಗ ಸ್ಟೇ ಕೊಡಕ್ ಆಗೋದಿಲ್ಲ.
ಕೊಡಿ ಸ್ವಾಮಿ.
ಅಲ್ಲಿ RF ಏನಿದೆ ನಂಗೆ ಗೊತ್ತಿಲ್ಲ.
ಇಲ್ಲ, ಇದು ಪೆಂಡಿಂಗ್ ಅಂತ ಹೇಳಿದಿರಲ್ಲ.
ಹಂಗಾರೆ ಇದನ್ನ ಜೊತೆ ಕಳಿಸ್ಬಿಡ್ತೀನಿ.
ಯಾವ್ದು?
ಇದನ್ನ ರಿಟ್ ಪಿಟಿಷನ್ ದಯವಿಟ್ಟು ಕಾಯ್ರಿ, ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಸರ್ವ್ ಮಾಡಿ ಬನ್ನಿ, ಆಮೇಲೆ ಅಲ್ಲಿ ಅಲೋ ದ ರಿಟ್ ಪಿಟಿಷನ್. I'll satisfy this order and state be pending subject to the result in RF.
ಈಗ ಪಾರ್ಟಿ ಆರ್ಟಿಸ್ಟ್ ಎಲ್ಲ ಮಾಡ್ಕೊಂಡಿದಾರಲ್ಲ.
ಈಗ 2 ವರ್ಷದಿಂದ ನೀವು ಸುಮ್ನೆ ಕೂತಿದ್ರ.
ಅಲ್ಲ, ಇಲ್ಲ, ಅಪೀಲ್ ಹಾಕಿದ್ದೀನಿ.
ಇವಾಗ 2 ವರ್ಷ ಆಗೋಯ್ತಾನೆ ಎಂಟ್ರಿ ಆಗಿ.
ಅಲ್ಲ, ಅಪೀಲ್ ಹಾಕಿದ್ದೀನಿ.
Date.
kindly.
If you want to reject your prayer. If you want to reject your prayer.
ಅಲ್ಲ,
or else you ensure.
ನಾನು submission ಸ್ವಲ್ಪ ಕೇಳಿ. ಅಪೀಲ್ ಹಾಕಿ ನಂತರ I have not kept quiet. I preferred appeal before the assistant commissioner. Assistant commissioner will not interfere. Then I preferred revision before the deputy commissioner. Deputy commissioner says, no, the appeal is pending, I don't interfere. So I have not kept quiet from 23.
I'm asking you a question. I can grant you a stay of an executable order. The order has been already executed. The kata has already been changed 2 years ago. What is the stay that I can grant?
What is one minute? I preferred appeal, my lord. I have not
But what is the stay that I can grant? The order is already implemented. Therefore, I said, let them come and allow the writ petition. Service, sir, mad bani or bega. If you want, I'll take out personal service on them.
So the advocate on record.
ನಿಮ್ ಪರ ಹೇಳಿದ್ರು ನೀವು ನನ್ನ ಜಗಳ ಆಡ್ತೀರಾ.
ಇಲ್ಲ. ಅಡ್ವೊಕೇಟ್ ಆನ್ ರೆಕಾರ್ಡಿಗೆ ಇದರಲ್ಲಿ ಫೋರ್ಟ್ ಅಲ್ಲಿ
ದಿ ಅಪೆಲೆಂಟ್ಸ್
ಅಡ್ವೊಕೇಟ್ ಆನ್ ರೆಕಾರ್ಡ್ ಬೇರೆ
ಆನ್ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಪೋಸ್ಟ್ ಮಾಡಿ
were represented through a council in RFA 767/2023. List.
ಡೇಟ್ ಮೇ ಬಿ ಫಿಕ್ಸ್ ಮೈ ಲಾರ್ಡ್.
ಸರ್ ಮಾಡಿ ಬನ್ನಿ, ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ. ಸರ್ ಮಾಡಿ ಬನ್ನಿ.
ಯಾವ ಡೇಟ್?
7.
ಅಲ್ಲ
43.
ಸೌರಭ್ ಅಡ್ವೊಕೇಟ್ ಅಂತ ಒಂದು
ಮಾಡಿದೆ.
Section 4 and 5 of the Karnataka Epidemic Disease Act. Your lordships have quashed with respect to other accused, my lords. Page number 61, annexure D. Present accused are accused number 3 and 8, 14, 15, 16, 17.
ನೋಡಿದರೆ ಯಾರಾದ್ರು? Please. HA to take notice for respondent number 1.
My lords, respondent number 2 as well, my lords, can be disposed of. Both the respondents AGM, my lords.
In his absence, I can dispose it of.
No, my lords, both the respondents are represented by AGA. It is the Assistant Commissioner of the Hindu.
Reject notice for respondent 1 and 2. Relist all. Nobody held in next week.
Until then, my lords, interim order. Very well.
17. For order, seal number 44. Based on the memo filed by the respondent number 3, death certificate, my lord, is not available. Therefore, my lord, production of death certificate may be dispensed with.
Who's R3?
R3 is private respondent, contesting respondent. The other side, R3 filed a memo.
This 9/1/24.
Office objection
is also permitted to take out notice either personally or through courier as provided under the new rules.
Please.
Ariga or ತೊಗೊಳ್ಳೋದಂತ notice.
Lord, I may permitted to serve on him also.
ಇಲ್ಲ ತಗೊಳ್ತಾರೆ
ತಗೊಳ್ಬೋದು.
In case Shri Ariga has instructions to appear on the proposed LRs, copy be served on him also.
Please, great. Number 45.
This case, I'm appearing for petitioner. In this case, the petitioner.
As requested in the memo. Petitioner is treated as LR of the blood disease second.
Blood, I have objection.
So far as R for you, I have filed an application to
There
bring
is a-
LR.
There is a serious dispute with regard to bringing the blood. Basically, their application is concerned that may be allowed, we may be permitted to come on record as a LRs of respondent number 5, please. That is one, blood. But the second thing is, blood, the first petitioner, blood, is claiming under second petitioner, right under second petitioner, blood. He is neither son nor adopted son. Not by
the memo filed requesting the deceased second petitioner shall be heard along with the main writ petition. Here 1, 2, 3 of 2024 is since the right to sue survives on the applicants mentioned therein, must have to be amended.
We are, my lord, one submission.
To be treated along with the main writ petition, the
Please, please.
Maybe, my lord, the issue is very simple, please, my lord. Now they are.
ready?
I am already know. Now they have claiming on the basis of the relinquishment.
What is the order that you are
The
challenging?
order, kindly see, the order passed by, now I have challenged the order passed by the deputy commissioner under 136(3). The assistant commissioner under 136(2) has passed in my favor.
No, the property was standing in whose?
In Chintalappa, who is died now. I am claiming
Name of?
inheritance. Chintalappa.
Tintalappa.
Chintalappa. I am claiming by inheritance. My wife and a foster son. Mine.
When did Tintalappa die?
Chintalappa died
19/2007.
19/2007.
Thereafter, what happened?
Thereafter, Pauti Kata is made in favor of a foster son and a wife.
In favor of?
In favor of
Muniamma.
petitioners, my lord. Muniamma and Chandrappa.
Claiming.
And Chandrappa.
Please. That has been challenged before the assistant, the Pauti Kata is
Who's
challenged. before
R4? Who's R4?
R4 is the deputy petitioner.
No, who's R5?
R5 is claiming to be the interested of in respect of property on the ground of a relinquishment.
Claiming to be the?
Interested in that property on the basis of a relinquishment deed executed by Chintalappa. Relinquishment deed illa ಏನು?
By whom? By whom?
By Chintalappa.
Tintalappa.
One affidavit ಹಾಕಿದ್ದಾರೆ. One affidavit, that's all.
One brother, please.
Please, all you are good.
Madi.
When was this relinquishment date executed?
It is, there is no relinquishment, my lord, under natural succession.
If Chintalappa died, you have no right to come on record as a Khatedar. You can only go in the name of Muniamma.
Yes, my lord.
Now Muniamma is also dead.
Dead.
According to you are the class 2 heir.
Yes, please.
To give declaration.
Lord, now what has happened, please, my lord?
Muniamma during her lifetime.
But during the lifetime of
Muniamma
Chintalappa.
during her lifetime admitted that Chandrappa was the foster son.
No,
Please, yes,
no,
yes.
my lord.
It
If
is
that
a-
is the case, my
It is
lord,
a joint request given by Muniamma and her foster son
Please.
for changing the kata.
Lord, what has happened, my lord?
ನಾನು ಹೇಳಿದ್ನಿ first yes or
No, no, Lord, that is partly incorrect. For the reason, Lord, before the deputy commissioner, Lord, this
show
Chintal,
me the order of the Tahsildar.
Lord, only one moment, Lord, I am permitted to make answer.
ನಾನು ಹೇಳಿದ ಕ್ವಶನ್ ಕೇಳಿ ಆಮೇಲೆ ನಿಮ್ ಕೇಳ್ತೀನಲ್ಲ ನಾನು. ನನ್ನ ಡೌಟ್ ಕ್ಲಿಯರ್ ಆಗೋನು ಮುಂದಕ್ಕೆ ಹೋಗಲ್ಲ ನಾನು. Where is the order of Tahsildar? Show me that.
Tahsildar order is not placed on record, please.
Where is the order of mutation? In your favor and your mother's favor. Next sir, E na?
Next email. Next
So it was jointly in their name.
Please.
Annexary.
That affidavit, my contention is that affidavit itself is forged because the reason is.
Please
Yes,
go,
Lord.
please go to the civil court, get it.
But what has happened? May one second. Now, what is the right of Chandrappa? He is claiming that he is a foster son, not the very same Muniamma, not. It is undisputed fact that Chikkuvira Nagappa, that is the fifth respondent, and Chintalappa are the brothers. The second aspect is, my lord, during the lifetime of Chintalappa and Muniamma, with the consent of Muniamma and Chintalappa, the kata is transferred in my name.
When?
Not previously, my lord, the RTC is not that I'll.
Give me the MR. This MR is which year?
Of
2008,
2008-9.
2008, 2009. MR 35/0809. When was your name entered?
2008. But 2000, not much prior to death of Chintalappa and Muniamma, my name is entered with the consent of Chintalappa and Muniamma.
Then give me the date. Was it on the basis of a registered instrument?
Lord, it's based on the statement given by Chintalappa and.
It's not on the basis of a registered instrument.
No. Lord, what has happened? Then they have created an affidavit.
2008, 2009 ನಲ್ಲಿ it was transferred from Chintalappa to his wife and his alleged son.
Please, Lord.
So prior to that, the name of Chintalappa was in the records.
ನಮ್ಮ ಹೆಸರು ಇದ್ದಿದ್ದು.
ತೋರಿಸಿ RTC ನ.
So that is not placed. Lord,
ನೀ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ.
I'll place it on record. Lord, my date may kindly be.
And one more thing, my lord.
Today was the date.
One more thing, my
But
lord.
in fact,
The Muniamma,
very Muniamma as.
the Muniamma has
Deputy
Date
Commissioner, she has given a statement saying that my signature has been forged by the.
You have no right to have your name in the kata on the basis that you are the brother of the deceased. You are not related to Muniamma, except that she is your brother's wife.
But now.
On her death, we don't know what she has
But
done.
now, but it is only the case of the petitioner is that he's a fostering son.
That is not his case. Your sister,
It is his case.
your sister-in-law agreed.
No, blood.
Or your sister-in-law agreed for this and it was joint kata.
Now,
Not for you to say
blood,
that.
now the only case now what they are blood after the death of Muniamma, according to them, he is a foster son, neither adopted son nor natural son. We are being the class.
Joint kata agide ಅವ್ರ ಇಬ್ಬರಲ್ಲೇ.
ಹೌದು.
ಮುನಿಯಮ್ಮ ಒಪ್ಕೊಂಡು ನನ್ನ ಮಗ ಇವನು ಅಂತ.
ಅದೇ ಅದನ್ನೇ ಮುನಿಯಮ್ಮ ಡೆಪ್ಯೂಟಿ ಕಮಿಷನರ್
RTC ಅಲ್ಲಿ
ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಟ್ಬಿಟ್ಟು ನನ್ನ ಸಿಗ್ನೇಚರ್ ಫೋರ್ಜರಿ ಮಾಡಿ ಈ ತರ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು
ಮುನಿಯಮ್ಮ ಅಪೀಲ್ ಹಾಕಿದ ಆರ್ಡರ್ ಮೇಲೆ.
ಡೆಪ್ಯೂಟಿ ಕಮಿಷನರ್ ಮುಂದೆ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿರೋದು.
ಹೇಳಿದ್ ನೀವು ಗೊತ್ತು ಅರ್ಥ ಆಗದ ಕ್ವಶನ್ ಯಾರು ಆನ್ಸರ್ ಕೊಡಲ್ಲ. 2008 ಇಸ್ವಿಯಲ್ಲಿ ಮುನಿಯಮ್ಮ ಈ ಆರ್ಡರ್ ತಪ್ಪು, ಇವನ ಹೆಸರು ಬರ್ಬೋದಾಗಿತ್ತು, ನನ್ನ ಹೆಸರು ಮಾತ್ರ ಬರ್ಬೇಕಿತ್ತು ಅಂತ ಅಪೀಲ್ ಹಾಕದ್ಲ.
No.
So she has accepted the joint kata.
That's what. Not before the assistant commissioner, she has not appeared. Before the deputy commissioner.
Did she challenge the order? No.
Not independently, she has not
And
challenged.
if she has not challenged the order, she has accepted it.
Not accepted. Not before the deputy commissioner, she specific category.
ಮತ್ತೆ ಈಗಲೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರೆ WP ಅಲ್ಲ ಆಗುತ್ತೆ.
I'll place the documents on record.
17.
Next, 8,
18. 46.
In this case, my lord, I am appearing for petitioner. This is, my lord, the one application has been filed. I have filed statement of objection for impleading. That is, my lord, one application. ಇದರಲ್ಲಿ ಒಂದು ಪಡ regularization this honorable court directed and has not been.
What is annexure Q?
Please, my lord.
Annexure Q.
Annexure Q is, my lord, the endorsement issued subsequent to the order passed by this honorable court.
Page number?
Page number 88, my lord. Sri Sayyid Nadeem.
88.
Sri Sayyid Nadeem bin Sayyid Kaleem Achalu Grama Satanur Hubli ಆದ ನೀವು ಉಲ್ಲೇಖದ ನೀವು ಮಾಹಿತಿ ಹಕ್ಕು ಅಧಿನಿಯಮ 2000 ಅಡಿಯಲ್ಲಿ ಮನವಿ ಅಚ್ಚಲು ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ ನಂಬರ್ 8198/287 ಜಮೀನುಗಳು ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ರಿಟರ್ಜಿ ಸಂಖ್ಯೆ 4498 ಆದೇಶ ಪ್ರತಿಯಂತೆ ಖಾತೆ ಮಾಡಲು ಕೊಟ್ಟಿರುವ ಅರ್ಜಿ ತೀರ್ಮಾನದ ಕಾಪಿಗೊಳಿಸಿಕೊಡುವ ಕೋರಿರುತ್ತೀರಿ. ತತ್ಸಂಬಂಧವಾಗಿ ಈ ಬಗ್ಗೆ
ರಿಪ್ಲೈ given to an RTA application.
ಅಲ್ಲ ಅದರಲ್ಲಿ ಐ ವಿಲ್ ಕಮ್ because kindly see, my lord, that has not been given. Kindly see the order passed by this court. Kindly see, my lord, annexure A, page number 63. There is a notification issued to regularization of Pada land, and accordingly, my lord, that I have made application, and Tahsildar has passed order. Memorandum came to be passed. I have deposited amount. Thereafterwards, not implemented. Then I have approached this honorable court. This honorable court directed to consider the application. The deputy commissioner ಕಳಿಸ್ಕೊಂಡು ಕೂತಿದ್ದಾರೆ ಈ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ನ.
Why are you challenging annexure Q?
Annexure Q, my lord, kindly see.
Simply sought for direction to implement the order.
Please, my lord.
You should simply sought for direction to implement the
No,
order.
my lord, that ವಿಲೇಡಲಾಗಿದೆ ಎಂದು ತಿಳಿಯುತ್ತದೆ. ಅವರು ವಿಲೇ ಇಡ್ತಾರೆ. ಈ ಜಿಲ್ಲಾಧಿಕಾರಿ ಪತ್ರ
My lord, instructions below internal communication.
Tahsildar has passed an order.
ಇಲ್ಲ ಡೈರೆಕ್ಷನ್ ದಿಸ್ honorable court.
ಅವರಿಗೆ ಪತ್ರ ಬರೆಯಲಾಗಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ.
ಅವ್ರೇನು there's already an order. He has only has to implement it, isn't it?
But he has no locus standi because deputy commissioner.
ನಿಮ್ದು ಆಯ್ತಲ್ಲ ಇರ್ರಿ ಅವ್ರನ್ನ ಕೇಳೋಣ ಏನ್ ಹೇಳ್ತಾರೆ.
ಆಯ್ತು.
What are you challenging? For what?
Here is very limited extent. Written the nature of mandamus directing the respondents to consider take a decision on my representation and keeping the observation made by the tribunal in the earlier occasion in 1993 and also on the direction issued by the Assam Court in the year of 2006. But I'm the blood,
ಅಲ್ಲ ಇವ್ರು ಹೇಳ್ತಾರೆ ಈ ಜಮೀನ್ ಪಡ ಬಿದ್ದಿತ್ತು ಅಂತ.
ಹೌದು.
So ಅದಕ್ಕೆ they are seeking for restoration of the land in their favor. What is your interest in this land?
For application grant.
But I'm cultivating the land, I'm the cultivator.
On what basis?
But as a tenant,
Under whom?
him,
ಅಲ್ಲ ಪಡ ಬಿದ್ದರೆ ನೀವ್ ಹೆಂಗ್ ಮಾಡ್ತೀರಾ?
that is the reason, my lord, the committee, my lord, which was annexure A, page number 4 made.
ಹಾ.
That's it. ಆದೇಶ.
ಅಲ್ಲ ನೀವು you are claiming to be the tenant under the government? If the government has land is.
That is the reason my claim was transmitted to the land grant committee, since because the land was forfeited, the grant cannot be made. You have to approach the land grant committee. Therefore, your claim is transferred to the land grant committee. That is what the.
ಏನ್ ಅಲ್ಲೇನಾಗಿದೆ ಅಲ್ಲ ಲ್ಯಾಂಡ್ ಗ್ರಾಂಟ್ ಕಂಪನಿ ಮುಂದೆ ಏನಾಗಿದೆ?
ಏನು ಆಗಿಲ್ಲ ಅಂತಾನೆ ನಾನು ಮ್ಯಾಂಡಮಸ್ ಆಗಿರೋದು.
Reject ಆಗಿದೆ.
No, it has not been rejected.
Kindly see, my lord. It is rejected. All deputy commissioner has passed order rejecting all their claim. Their name is also there. I have produced that.
ಎಲ್ಲಿದೆ?
And produce ಮಾಡಿದ್ದೀನಿ.
ಯಾವಾಗ?
20th September 2022. ಸಾಹೇಬ್ರಿಗೆ ಕೊಡಿ.
ಅವ್ರು ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದೀವಿ.
ನಮ್ಗೊಂದು ಕಾಪಿ ಕೊಡಿ.
We have produced every. ಅಲ್ಲ ಇವತ್ತಿಲ್ಲ ಅವತ್ತು. ಆಯ್ತಾಯ್ತು ಕೊಡಿ ಸರ್.
Sir,
ಕೊಡಿ, copy ಕೊಡಿ.
ನಮ್
Copy.
government ಗೆ.
ಕೊಡಿ.
Petitioner to furnish copies of the memo along with documents dated 29/2022 to the respondent 6 to 8. List of.
ಒಂದು ಡೇಟ್ ಕೊಟ್ಟರೆ.
ನೋಡಿ ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಹೋಯ್ತು ನಿಮ್ದು. Your petition become infructuous.
Number 47.
Date.
25th. Number 47, government advocate.
My lord, in this matter, my lord, amended first title has been filed, my lord, and also constant.
Sir, ಅದನ್ನ ಕಾಪಿ ಕೊಡಿ ನನಗೆ. ಅಲ್ಲ.
In the first matter, my lord.
On
The
filing
matter
of
where
order.
the finding is recorded, that the government is in an encroachment of about 14,000 square feet.
What is the order that they are
There is
challenging?
another
Appellate tribunal order.
pending, my lord, in WP number 3333 of 24, it may be called along.
I don't know what.
How is it related?
Because my instructions are, my lord, arising out of the same orders, my lord, another writ petition is also pending. Because
No, there is no other writ petition. What section? This is the section 67(2) proceedings, where we filed the proceedings not for their eviction because they were admittedly in what's possession of about 14,000 square feet.
You are
Land
saying again
belonging
same
to-
order of the KAT and writ petition is pending?
arising out of same deputy commissioner's orders.
No,
Deputy commissioner order.
Deputy commissioner order.
but there is no other matter. My learned friends, government advocate cannot simply make some submission. There is some other matter.
I'll get the records and then verify. Post along with WP number so and so, since it is stated that this was very same land in question. Another writ petition is pending. Date of.
ಯಾವ writ petition?
3333 of.
24th.
Please.
Bill number 48.
Lord, I appear for the petitioner, my lord. I am for the second response.
R3, my lord. R3 filed an IA for extension of time for to comply the order of this honorable court, my lord. Honorable direct me R3 to execute the order finding the name of the petitioner Kata in there. For the reason, my lord,
Writ petition.
some dispute.
I had said if the Kata is not registered by then, respondent number 3 shall be personally present.
Please, my lord, for the reason I filed an application for extension of time to execute the Kata. For the reason I conduct the survey and then I have to report the.
Did I grant you permission to conduct a survey?
Sorry, my lord, last occasion I am not present.
Did I, in the final order, did I permit you to conduct a survey?
No, my lord. No, my lord.
I'll issue a non-bailable warrant against her.
Please, my lord. ಅಲ್ಲಿ ಸರ್ವೆ ಮಾಡ್ಲಿಕ್ಕೆ ನನ್ಗೆ ಆಧಾರ ಇಲ್ಲ.
You are not given the option to get over the order.
Please, my lord, for the reason I conduct the survey and then I have to.
It is not for
comply
you
the
to,
order of the honorable court.
it is not for you to conduct the survey. I had not granted you liberty to conduct the survey. Did I grant you liberty?
But it is not given, my lord, in the meanwhile. I is seeking time to comply the order of the honorable court. Limited period of. I am
If
the
you
in
give
charge
an
of the.
if you give an undertaking that you will register the Kata by next date, I will grant you time. Or else I will issue a non-bailable warrant right now.
Please, please, please.
ಶ್ರೀ ಇಬ್ಬರಿದ್ರಲ್ಲ ಯಾರಿಗೆ ಅಪ್ಪೀಲ್ ಆಗ್ತೀರ ನೀವು?
For R3, my lord.
ಅಲ್ಲಿ ಎರಡು ಹೆಸರು ಇದೆಯಲ್ಲ.
ಬರ್ಲಿಲ್ಲ.
Jairaj. My name is Yachrajan. My senior colleague. My name is Yachrajan. I am also record.
Keep the PDO present tomorrow. Keep the PDO present tomorrow. There are two councils. Whom do I accept?
G. Jairaj authority. I am colleague of the Mr. Jairaj.
ಇವ್ರು ಯಾರಂಗಾರ RS Prasanna Kumar ಯಾರು?
Rajana, my name.
RS Prasanna Kumar ಯಾರು?
Prasanna Kumar, 2 years council not filed a memo.
Keep the PDO present tomorrow.
PDS present.
PDO present is present. In charge.
Tell him, if he gives an undertaking that the Katil will be done by next week,
Please.
I'll adjourn the matter. Get his instructions.
Please. We can do Tata.
This is the reason why I said I'll order him to, I'll issue contempt against him.
On 15 days time.
If I file an affidavit of undertaking,
15 days.
I'll pass it over, I'll call it 2:30, file an affidavit of undertaking. 2:30.
Bill number 49. Vipaksha PH.
The petitioners. An application is filed, my lord, seeking to amend the writ petition. And that's in fact, there are 3 survey numbers, my lord, which are subject matter of the order passed by the deputy commissioner. However, in the writ,
Stone office objection ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ?
lords,
I will file
Initially-
my objections, your lords.
What?
Respondent, main petition.
objection, my lords, only amendment I have sought for, my lords, is there were 3 survey numbers, my lords, which were part of the order of.
Certificate of office objection on amended cost rate.
My lords, amended cost rate, I have, my lords.
What is the office objection on that?
My lords, what had happened, my lords, one, respondent number 6, Kariyama, my lords, who is the mother of the petitioners, my lord, was responded before the deputy commissioner. My lord, she is no more, my lords, as such, my lord, I had not made party, my lords.
Copy not served.
My lords, Kariyama, my lords. Amended cost rate, my lords, is filed on 27/5/2000.
Why did you delete R6?
My lord, she is no more, my lords. She was, my lord, she was a party before the deputy commissioner. The petitioners, my lords, are the children of Kariyama, my lords, who is respondent number 6.
Were you parties in the DC?
I was a party, my lord, before the deputy.
You should not delete them. Make an entry.
My lord, she is no more. This honorable court directed me to include her, and then, my lords, an order, if your lordship kindly peruse the interim order, my lords, passed on 30th of April, my lord.
Can't delete them from the cost rate.
My lords, I had filed a memo, my lords. Lordship may kindly peruse the order dated 30th of April, my lord. Lord, learned counsel, may read, my lord. Learned counsel for the petitioner submit that respondent number 6 is no more, none other than the mother of the petitioners, and she is no more, and seeks leave of this honorable to delete the name of respondent number 6. The same is permitted. To that effect, my lords, I have filed and my lords, a amended cost rate. My lords, initially when the writ petition was filed, she was not included. That was the objection, my lords, raised by the office to make her a party, my lords, in the writ petition. I made her a party, my lords, and
Where is the order of the DC?
my lords, before the deputy commissioner, my lords,
Where is the order?
my lords, annexure E, my lord. 1A, my lords, Kariyama is a party, my lord. She is no more, my lord. 1B and C, my lords, are the petitioners now.
But you had not made them as a.
In the writ petition, my lords, I did not make her a party because she was no more, my lord.
Why did you implead her then?
My lords, there was an office objection raised by the office. Since she has not been arrayed as a petitioner, he ought to have been arrayed as a respondent. My lords, on
The amended cost rate is accepted since R6 was the mother of the petitioner and had been arrayed as R1A before the deputy commissioner. So, since she passed away, our LRs have continued our LRs, that is the petitions have continued the proceedings. Therefore, deletion of Kariyama from the cost rate is accepted. Next, Inam.
lords, one application I have filed, my lord, seeking to amend the writ petition.
Copy ಕೊಟ್ಟಿದ್ದಾರೆ ಅವ್ರಿಗೆ.
I have served a copy, my lord. My lord, only amendment I have sought for, my lord.
File objections, your lords.
ಏನ್ amendment ಏನ್ ಹಾಕಿದ್ದಾರೆ?
Copy in ಬಂದಿಲ್ಲ, your lords.
Look, lords, in the writ petition, subject
Survey
matter
number
before the
include
deputy commissioner, my lords, there were 3 survey numbers. However, my lord, in the writ petition, my lords, by inadvertence, only 1 survey number, my lords, was mentioned. I have sought to, my lords,
ಅಲೋ ಮಾಡ್ಲಾ?
We have not received any copies, your lords.
ಕಾಪಿ ಕೊಡಿ.
my lords, I have served a copy, my lords.
ಇಲ್ಲ, AG ಆಫೀಸ್ ಮಾತ್ರ.
29.
AG
Nagesh, my lords, 2/9/2024, I have served.
ಇಲ್ಲ, sir.
My lords, writ petition, let them file objections, my lord. Now, my
ಏನ್
lords,
ಮ್ಯಾಟರ್ಗೆ ಯಾಕೆ ಅಬ್ಜೆಕ್ಷನ್ಸ್? The
Copy.
application for amendment. The Lord, since stated,
that the survey numbers, all the survey numbers,
Not sir, please.
all the survey numbers were not included in the original petition. Petition to file an amended petition. ಈಗಲೂ ಕರೆಕ್ಟ್ ಆಗಿ amended petition.
Please.
ಮಿತ್ರರಿಗೆ ಅವರನ್ನ ಸೇರಿಸಬೇಡಿ.
Interim order ಬೇಕಾಗಿದೆ.
Promoter continue.
Great.
Bill number 50, Sri Narayan Swami.
For petitioner, sir. ಅನಕ್ಷರ ಎನ್ನ ಸೆಟಿಸ್ಫೈ ಮಾಡ್ಲಿಕ್ಕೆ ಇದು ಮಾಡಿದ್ವಿ.
ಏನು ಅನಕ್ಷರ ಏನು?
ಅನಕ್ಷರ ಎ DC ಆರ್ಡರ್ಸ್ ಅದನ್ನ 19/2/2024 ಅಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿತ್ತು. ಅದನ್ನು ಸೆಟಿಸ್ಫೈಡ್ ಮಾಡ್ಲಿಕ್ಕೆ ನಾನು ರಿಟ್ ಆಫ್ ಸೆಷನ್ ಹಾಕೊಂಡಿದ್ದೀನಿ. ಇದರಲ್ಲಿ ಈ DC ಆರ್ಡರು ನಮಗೆ ಜಂಟಿಯಾಗಿ ಅವ್ರಿಗೆ ಇದು ಮಾಡಿದ್ರು ಸ್ವಾಮಿ. ಇರೋದು ಆಕ್ಚುಲಿ ಫ್ಯಾಕ್ಟ್ ಇರೋದು ಅವ್ರಿಗೆ ಬರೋದು ಅನಕ್ಷರ ಜಿ ಪ್ರಕಾರವಾದ್ರೆ
ಆರ್ಡರ್ ಎಲ್ಲಿದೆ?
ಅನಕ್ಷರ ಜಿ ಸ್ವಾಮಿ 46 ಪೇಜ್ ನಂಬರ್. ಅದ್ರಲ್ಲಿ ಆಕಾರ ಬಂದ ಪ್ರಕಾರ
ಅನಕ್ಷರ ಜಿನ
ಅನಕ್ಷರ ಜಿ ಲಾಸ್ಟ್
ಅಲ್ಲ, ತಹಸೀಲ್ದಾರ್ ಆರ್ಡರ್ ಎಲ್ಲಿದೆ?
ಸ್ವಾಮಿ ತಹಶೀಲ್ದಾರ್ ಆರ್ಡರ್ ಇದೆ ಸ್ವಾಮಿ. ಅನಕ್ಷರ ಅನಕ್ಷರ ಬಿ ಬಂದು ಇದು ಅನಕ್ಷರ ಬಿ ಬಂದು AC ಆರ್ಡರ್ ಸ್ವಾಮಿ. ಅನಕ್ಷರ ಸಿ ಬಂದು ತಹಶೀಲ್ದಾರ್ ಕಡೆಯಿಂದ ಇದು ಬರುತ್ತೆ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಬರುತ್ತೆ.
ಅನಕ್ಷರ
ಅನಕ್ಷರ ಸಿ ಡೇಟೆಡ್ 12/4 ಏನಿದೆ ಸರ್ 2020 ಅಲ್ಲಿ ಅನಕ್ಷರ ಸಿ ಬರುತ್ತೆ. ಅದು ತಹಶೀಲ್ದಾರ್ ಕಡೆಯಿಂದ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಬರುತ್ತೆ. ನಮಗೆ ಮುಟೇಶನ್ ಎಲ್ಲ ನಮ್ಮ ಹೆಸರಿಗೆ ಬರುತ್ತೆ ಸರ್. 2021 2001-2 ಅಲ್ಲೇ ನಮಗೆ ಮುಟೇಶನ್ ಎಲ್ಲ ಬರುತ್ತೆ ಸರ್.
ಓದಿ ಅದ್ರನ್ನ. ಅನಕ್ಷರ ಸಿ ಓದಿ.
ಅನಕ್ಷರ ಸಿ ಬೇಲೂರು ತಾಲೂಕು ಹಳೆಬೀಡು ಹೋಬಳಿ ಘಟ್ಟ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ ಏನು ಸರಿಯಾಗಿ ಕೇಳ ಸರ್ ಕನ್ಸಲ್ಸ್ ಅದರಲ್ಲಿ 5 ಎಕರೆ 10 ಗುಂಟೆ ಎಕರೆ ಹಾಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಮಾನ್ಯ ವಿಶೇಷ ತಹಶೀಲ್ದಾರರುಗಳು ಹಾಸನ ಅವರ ಇನಾಮ್ ರದ್ದಿಯಾತಿ ಸಂಖ್ಯೆ MR 5121/1962-65 ದಿನಾಂಕ 20/1/1963 ಆದೇಶದಂತೆ ಪಹಣಿ ದಾಖಲಿಸಲು ಕೋರಿದ್ದು ನಿಮ್ಮ ಮನವಿಯನ್ನು ಪರಿಶೀಲಿಸಲಾಯಿತು. ಈಗಾಗಲೇ ಪ್ರಸ್ತುತ ಪಹಣಿಯಲ್ಲಿ 5 ಎಕರೆ 10 ಗುಂಟೆಯ ಜಮೀನಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ MR 89/2001-2 ಅಂತೆ ರಾಜೇಗೌಡ ಬಿನ್ ಮಂಜೇಗೌಡ ಅವರ 3 ಎಕರೆ ಮತ್ತು ಶಿವೇಗೌಡ ಬಿನ್ ಮಂಜೇಗೌಡರವರಿಗೆ 2 ಎಕರೆ 12 ಗುಂಟೆ ಜಮೀನು ಹಕ್ಕು ದಾಖಲಾಗಿರೋದ್ರಿಂದ ಈ ಹಂತದಲ್ಲಿ ಹಕ್ಕು ದಾಖಲಿಸಲು ಅರ್ಹವಿಲ್ಲದಾದ್ದರಿಂದ ಸಮಕ್ಷಮ ಪ್ರಾಧಿಕಾರ ಮೇಲ್ಮನವಿ ಸಲ್ಲಿಸಿ ಪರಿಹಾರ ಕೊಂಡುಕೊಳ್ಳಲು ಕೋರಿರುತ್ತದೆ.
ನೀವು 63ನೇ ಇಸ್ವಿ ಆರ್ಡರ್ ಪ್ರಕಾರ ಖಾತೆ ಮಾಡ್ಕೊಡಿ ಅಂತ ಕೇಳಿದ್ರಿ.
ಹೌದು ಸರ್.
ಅವ್ರಾಗ್ಲೇ 2001ನೇ ಇಸ್ವಿಲಿ 5 ಎಕರೆಗೆ ಮಾಡ್ಬಿಟ್ಟಿದೀವಿ ನಾವು ಖಾತಾ ಅಂತ.
ಹೌದು ಸರ್.
ನೀವು ಈ ಆರ್ಡರ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರಾ?
ಹೌದು ಸರ್.
ಎಲ್ಲಿ ಮಾಡಿದ್ರಿ? MR 81/2001-2002 ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರಾ?
ಇದನ್ನ ನಾವು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ವಿ.
ಈ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರೆ ನಿಮ್ಮ ಹೆಸರು ಹೆಂಗ್ ಮಾಡ್ತಾರೆ?
ಇದ್ರ ಪ್ರಕಾರ ನಮ್ಗೆ ಎಲ್ಲ ದಾಖಲಾತಿಗಳು ಬಂದಿದೆ ಸ್ವಾಮಿ.
ಇಲ್ಲ ರೈಟ್ ರಾಂಗು MR 89/2001-2012 ಪ್ರಕಾರ 5 ಎಕರೆ 10 ಗುಂಟೆಗೆ ಖಾತೆ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. ನೀವು ಇದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ
ನಮ್ಮ ಹೆಸರು ಖಾತೆ ಬಂದ್ಬಿಟ್ಟು ಸರ್. ಪಿಟಿಷನರ್ಸ್ ಹೆಸರಿಗೆ ಖಾತೆ ಬಂದ್ಬಿಟ್ಟು ಸರ್.
ಬಂದಿದ್ಯಾ ಖಾತೆ?
ಹೌದು ಸ್ವಾಮಿ, ಅದೇ ಅಲ್ಲ ಸ್ವಾಮಿ ನಾನು ಹೇಳ್ತಾರೆ. ಇದ್ರ ಪ್ರಕಾರ ನೋಡಿ ಇವಾಗ ಇದು ನಮ್ಗೆ
ನಿಮ್ಮ ಹೆಸರು ಹೇಳಿ. ನಿಮ್ಮ ಹೆಸರು ರಾಜೇಗೌಡ?
ರಾಜೇಗೌಡ, ಶಿವೇಗೌಡ ಮತ್ತೆ ನಿಂಗೇಗೌಡ ಪಿಟಿಷನರ್ಸ್.
ಇದ್ಯಾರು ಕೊಟ್ಟಿದ್ದು? ಬ್ಯಾಟ್ರಂಗೇಗೌಡ ಕೊಟ್ಟಿದೆ ಇದು?
ಹೌದು ಸರ್.
ಇದ್ಯಾರು ಬ್ಯಾಟ್ರಂಗೇಗೌಡ? ಯಾರು?
ಬ್ಯಾಟ್ರಂಗೇಗೌಡ ಅವ್ರ ಇವ್ರು ಸ್ವಾಮಿ. ಯಾರು?
ನಿಮ್ಮ ಎದುರು ಪಾರ್ಟಿ?
ಎದುರು ಪಾರ್ಟಿ.
ಅವ್ರ ಅಪೀಲ್ ಹಾಕಿದ್ರ?
ಅವ್ರ ಅಪೀಲ್ ಹಾಕಿದ್ರು. ನಮ್ಗೆ ತಹಶೀಲ್ದಾರ್ ಕೋರ್ಟಲ್ ನಮ್ಮ ಪರವಾಗಾಯ್ತು, AC ಕೋರ್ಟಲ್ ನಮ್ಮ ಪರವಾಗಾಯ್ತು, DC ಮೇಲೆ ಅವರು ಇದು ಮಾಡಿದ್ರು. ಅನಕ್ಷರ F ಪ್ರಕಾರ ನಮ್ಗೆ ಬಂದಿದೆ ಸ್ವಾಮಿ. 2024-25 ಅಲ್ಲಿ ನಮ್ಮ ಹೆಸರೆಲ್ಲ ಇದೆ ಸ್ವಾಮಿ. ಅನಕ್ಷರ F ಪ್ರಕಾರನುವೆ ಪಾಣಿ ಅಲ್ಲ. ರಾಜೇಗೌಡ ಬಿನ್ ಮಂಜೇಗೌಡಗೆ 3 ಎಕರೆ ಬಂದಿದೆ. ಶಿವೇಗೌಡ ಬಿನ್ ಮಂಜೇಗೌಡಗೆ 2 ಎಕರೆ 18 ಗುಂಟೆ. ಮತ್ತೆ ಇವಾಗ
ಈ ಡಿ ಸಿ ಆರ್ಡರ್ ಆದ್ಮೇಲೆ
DC order ಇದೆ?
ಸರ್ ಡಿ ಸಿ ಆರ್ಡರ್ ಬಂದ್ಮೇಲೆ ಅವ್ರಿಗೆ ಇದು ಮಾಡಿದ್ರು ಒಂದು ಕಾಪಿಯನ್ನು ಕೊಡಿ ರೆಫರೆನ್ಸ್.
Without that order being challenged, how can the deputy commissioner pass this order?
But page 18.
Huh.
But
He goes on the 68 order,
please.
but in the year 2001, 2002, it has been already muted in his favor. And the AC says their earlier claim for registration on the basis of sale was rejected.
Yes.
How is he considering that?
But the 16/6/1973.
AG
But
accepts
from that
notice.
day onwards, my lord.
No, ಅದ್ರ ಮೇಲೆ ರಿಜೆಕ್ಟ್ ಆಗಿತ್ತು ಅಂತ ಅಂದಿದಾರಲ್ಲ.
ಹೌದು.
Then AG accepts notice for respondents 1 to 4. Issue notice to
Kindly grant this
status quo as regards revenue increase to be maintained.
ಸ್ವಾಮಿ ಇವಾಗ
ಏನ್ರಿ ರೆಕಾರ್ಡ್ ಮಾಡ್ತಿದಾರೆ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ನ? ಅದಕ್ಕೆ ನೀವು ಕೋರ್ಟ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ರೆಕಾರ್ಡ್ ಮಾಡ್ಕೋಬೋದಾ?
ಹಂಗೆಲ್ಲ ಮಾಡಬಾರ್ದು. ಇಲ್ಲಿಂದ ಬರ್ತೀವಿ.
ನಿಮ್ಮ ಹೆಸರೇನು?
ಪಿಟಿಷನರ್ ಕಡೆ
ನೀವೆಲ್ಲ ಪಾರ್ಟಿ ಇದ್ದೀರಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಪಾರ್ಟಿ ಇಲ್ಲ, ಪಿಟಿಷನರ್ ಕಡೆಯವರು. ಅವ್ರು ಬಂದ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಏನ್ರಿ ನೀವು?
ಗೊತ್ತ ಹೇಳೋದು ಬೇಡ್ರಿ ಸರ್, ಇದು ಮಾಡ್ತೀವಿ. ನಂಗೆ ಗೊತ್ತೇ ಇಲ್ಲ ಸ್ವಾಮಿ ಅವ್ರು ಬಂದಿರೋದು. ಅಪಾಲಜಿ ನಂಗೆ ಗೊತ್ತೇ ಇಲ್ಲ ಅವ್ರ ಬಗ್ಗೆ.
ಅವ್ರು ರೆಕಾರ್ಡ್ ಮಾಡಿ ನಿಮ್ಮ ಮೇಲೆ ಬಾರ್ ಕೌನ್ಸಿಲ್ ಕೊಡ್ತಾರೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಸರಿ ಮಾಡ್ಲಿಲ್ಲ ಅಂತ.
ಇಲ್ಲ ಆಯ್ತು, ಇದು ಮಾಡ್ತೀವಿ. ಎಲ್ಲ ಮಾಡಬಾರ್ದು ಕೋರ್ಟ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್. ಸ್ವಾಮಿ ಒಂದು ಆರ್ಡರ್ ಅವ್ರಿಗೆ ಆಗಿರೋದು ಅಂತ ಇದು ಕೊಟ್ಟು ನೋಡ್ಬೋದು ಸರ್. ಅವ್ರಿಗೆ ಇವಾಗ
ಸ್ಟೇಟಸ್ ಕೋ ಮಾಡಿದೆ.
ಆಯ್ತು ಸರ್.
Number 51, P. Rajshekar S.
I paid the process insofar as respondent number 9 to 13 is concerned. Today, my lords, paid the process.
Lord, I appear for
Who's arraigned
respondent
for-
number 8 in this matter. This matter may be called along with another writ petition, my lord, WP number 20.
Who's R9 to R13?
Are the private parties, my lords.
Lord,
Are they parties in the
they are the
They are-
petitioners in the other writ petition.
Other writ.
Are they represented by counsel there?
Yes, my lord. Shri Muniraju M is the counsel for the petitioners there.
They stated that in the connected matter, response 9 to 13 are represented by Shri M.
Muniraju.
Petitioner is ready to take out notice on the said
Phone
Shri
number.
Muniraj and post along with.
Interim order to continue. Great.
Lord, 52, kindly pass over the matter, Lord, dear. Lord, kindly pass over the matter, Lord, to the day. Your lordship had directed me to my last occasion to file some documents, my lord. It is ready, my lord, 2:30, obliged.
53 and 54 adjourned. Seal number 55, Shri P.V. Badrinath.
R6 के PF already paid.
Here R6 here.
R6 is Assistant Director, Youth Service and Sports Department.
ನೀವು ತಗೋಬೋದಲ್ವ ನೋಟಿಸ್ ಮಂಗಡ? ನಿಮ್ಮ ಗವರ್ಮೆಂಟ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಅಲ್ವಾ? Assistant Director, Youth Service and Sports Department, Ramnagar.
Government, government, I will take.
Do not accept notice for R6.
No.
Promoted to continue to the next date of it. In instruction ಇದೆಯಾ?
ಇಲ್ಲ, I will secure instructions. Not to specify. Number 56, Shri Mahabaleshwar Rao.
For the petitioner, ಇದರಲ್ಲಿ ನಾವು we have sent the caveat copy along with the letter by RPAD. ನಮಗ್ ಬಂದಿರೋ ಕವರ್ ನಲ್ಲಿ ನೋ ಕಾಂಟ್ಯಾಕ್ಟ್ ನಂಬರ್ ಅಂಡ್ ಇಮೇಲ್ ನಥಿಂಗ್.
ಸಂಜಯ್ ನಗರ್ ಸಿಗ್ಲಿಲ್ವಾ?
ಇರ್ಲಿಲ್ಲ, ರೆಸ್ಪಾಂಡೆಂಟ್ ಸಿಗ್ಲಿಲ್ಲ. ಅದೇ ಸ್ವಲ್ಪ ವಾಟ್ ಹ್ಯಾಸ್ ಹ್ಯಾಪನ್ಡ್ ಬಂದ್ರೆ
ಇದೆಯಾ? ಅಕ್ನಾಲೇಜ್ಮೆಂಟ್ ಇದೆಯಾ? ರಿಕ್ಲೈರ್ಮೆಂಟ್ ಲಾಸ್ಟ್ ಮೊನ್ನೆ ಬಂದಿಲ್ಲ ಏನು ಪೋಸ್ಟ್
ಫೋನ್ ನಂಬರ್ ಇದೆ ನೋಡಿ, ಫೋನ್ ನಂಬರ್ ಇದೆ, ಕಾಂಟ್ಯಾಕ್ಟ್ ಮಾಡಿ ಕಾಪಿ ಸರ್ ಮಾಡು.
ಮೇಬಿ ಟೇಕನ್ ಆನ್ ಫ್ರೈಡೆ ನಾನು
ಲಿಸ್ಟ್
14. Seal number 57 passed over. For hearing on A, seal number 58.
Very short. Petition. File applications for Milord, bringing LRs of petition number 1. And to recall the order dated Milord 27/3/24.
Petition.
You appear for?
Lord, petition number 1, legal aids of petition number 1.
And P2?
3, Lord,
P2 is reported to have died.
yes,
Then P3?
is not in station, is
EVRಗೆ?
P1. Legal
But P2
legal
and
aids
P3.
of P1. Lord. I'm
What about P2 and P3?
P2 and P3 are good.
What is the order that is challenged?
Milord, it is Milord, the
Order passed by the
Date,
deputy commissioner as well as the assistant commissioner, my lord, is under challenge.
the Inam land, they have filed application for Inam land.
ನೀವೆಲ್ಲ ಕೆಂಪನಾಗ
ಅದೊಂದು ರಿಜೆಕ್ಟ್ ಆಗಿದೆ ಅಂತ ಗೌರ್ಮೆಂಟ್ ನಮಗೆ ಕಮ್ಯುನಿಕೇಟ್
I will permit him to continue because he's one of the LRs.
Please.
Please.
Since there was no representation on behalf of the petitioners, and taking notice of the fact that the court notice was served on petitions 1 and 3, this court dismissed the writ petition for non-prosecution. Applications have thereafter been filed by the LRs of the first petitioner, seeking not only for recalling the order but also for permitting them to come on record as the LRs of deceased P1. There is however no order, no applications made by the other two petitioners or their LRs. It is over noticed that petitions 1 to 3 were legal representatives of one Campanagaya, who was the third respondent before the appellate tribunal. Since the estate of Campanagaya has been adequately represented by the deceased, was being represented effectively by the deceased first respondent, and thereafter by the present applicants, it would be unnecessary to hold that the petition is awaited because steps have not been taken in respect of petitioners 2 and 3. So consequently, IF4/24 is allowed, and the LRs of the deceased first petitioner are permitted to come on record. So they shall be entitled to prosecute the writ petition as the LRs of Campanagaya. Post in B group, hearing idea.
Nagaraj.
B group.
Post in B group.
Milord, matter may be connected along with Milord, writ petition number 25905.
Post along
Of
with
2017.
Barcode HT.
Barcode.
Seal number 59, Shri Prakash T. Abba.
Yes. 59.
I'm for the petitioner. Requesting for a short accommodation.
Senior out of vacancy this time.
Realist.
Respondent number 9.
ನೀವು ಯಾರಿಗೆ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 9 ಗ ಚಂದ್ರಶೇಖರಯ್ಯ.
Respondent number 9.
Then who is appearing for R4? Mohammed Jafar Hussain. Realist.
17th. Seal number 60.
For the pleading applicant.
Friday, we received the brief, my lord. I have not yet filed the wakalat. I may be permitted to file the
This
wakalat.
matter, there is a inquiry conducted by the police regarding impersonation of my party. My lord, a sale deed has been executed in respect of the property in question during pendency of the proceeding by impersonating the dead person. My lord, inquiry has been conducted by the
They are
jurist.
for the impleading.
Who are the impersonated persons, my lord?
Wakalat
No, I am not for the impersonation. I am the purchaser of the property.
List.
17.
My lord,
Much
the
okay.
interim order is there, my lord, so it may be
More to continue.
much. Okay.
Bill number 61, Shri B.M. Sidappa.
Yes, appear for the respondent. my lord.
Senior Elder, kindly pass.
Inundate ಅದು.
List.
17. Interim order may be extended.
Last time extend ಆಗಿದೆ.
ಈ ಸಲ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ.
Number 62. Syed Akbar Pasha.
Petitioner has died. An application since right to sue survives, the IA 1/24 is allowed. Petition to amend the cost rate. Matter ನೋಡಿದಿರಾ?
Sir, but been granted land of 4 acre 24 gunta.
ರೆಡ್ಡಿ ಅವರೇ?
ಇಲ್ಲ, I need some request. I will
Cost
take
rate-
notice.
cost
my
rate
lord.
amendment.
Yes, my lord.
Amend the cost rate.
ಮಾಡ್ತೀನಿ. Short date may be given.
Number 63, Shri Chandrasekhar H.P.
Not them. Seeking for a direction to restore the name, my lord, which was appearing, my lord, in the record. of rights.
Lord, they made an application for additional documents, my lord, application. That application is not served, my lord.
Give him a copy.
IA 1 of 25.
Copy as well as the notification also.
ಇಲ್ಲ ಬಂದಿಲ್ಲ. ಯಾವ?
ಇನ್ನೊಂದು ಕಾಪಿ ಕೊಡಿ. List.
Right, it's only to indicate, my lord, that this land is not part of it.
ಕೊಟ್ಬಿಡಿ ಅವ್ರು ಒಂದ್ಸಲ ನೋಡ್ಲಿ ಅವ್ರು. If you rely upon that, he also has to look at that then.
It's only for, my lord, to satisfy this.
I'll have it next week. Give a copy. Let him see. And then
17.
My lord, they say, my lord, it is a deemed forest.
give him the
Your
copy.
lordships have noticed, my lord, there is no question of a deemed forest. Even a notification issued saying it is a deemed forest. My land is not there in that.
Let him go through the papers.
Please.
17. Seal number 64.
Same, huh?
Same, 60.
Kannada. Club ಮಾಡಿಸ್ಬಿಡಿ.
Seal number 65.
Who are they? Who has filed the application?
Filed the application.
For impeding, my lord.
Have filed an
Pray
application
for
for
2
impeding.
weeks time objections, my lord.
ಒಂದು ಬಿಡಿ.
Connected case ಅಲ್ಲಿ ಒಂದು ರೆಡ್ ಡಿಸ್ಪೋಸ್ ಮಾಡಿ ಫ್ರಾಡ್ ಮಾಡಿರೋದಕ್ಕೆಲ್ಲ 65,000 rupees ಕಾಸ್ಟ್ ಎಲ್ಲ ಹಾಕಿದ್ದಾರೆ. Now they have filed a.
How are you interested in this land?
Pardon me,
How are you interested in this land? Impeding application
we are the purchasers of one of the sites, madam.
in Sarnam 16/1. Allow the application then.
ಇಲ್ಲ ಇಲ್ಲ ಯಾಕಂದ್ರೆ ಫೈಲ್ ಅಬ್ಜೆಕ್ಷನ್ ಮಾಡಿ. I heard for the objection because FIR ಆಗಿದೆ ಅದು ವೆಂಕಟೇಶ್ ಅವರೇ. That's for this court, my lord.
Impeding application allow ಮಾಡ್ತೀನಿ ಅಷ್ಟೇ.
ಅಲ್ಲಲ್ಲ. I file objection, my lord. One week time also.
17.
Please.
For further consideration, seal number 66, Shri M. Shiva Prakash. Shri M. Shiva Prakash.
File number 66, I need some time, my lord.
That is the matter where, alert. Mandya Deputy Commissioner and
Today, my lord,
Secretary affidavits.
Need some time, my lord, in this.
ಒಂದ್ಸಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿತ್ತಲ್ವ?
Argument ಇದೆ, but the file is in place, my lord.
Last time ಇವರು.
ಅವ್ರು ಫಸ್ಟ್ ಟೈಮ್ ಬರ್ತಾರೆ ರೆಡ್ಡಿ ಅವರು. ರೆಡ್ಡಿ ಅವ್ರು ಫಸ್ಟ್ ಟೈಮ್ ಬರ್ತಾರೆ ಅದಕ್ಕೆ ಒಂದ್ಸಲ ಟೈಮ್
ಅದೇ ಲಾಸ್ಟ್ ಟೈಮ್ ಅವ್ರು ಅಪ್ಡೇಟ್ ಆಗಿರುತ್ತೆ ತಾವು ಓದಿದ್ದಾದ್ಮೇಲೆ ಸರಿ ಇಲ್ಲ ಅಂದಿದ್ದಕ್ಕೆ ಮತ್ತೆ ಹಾಕ್ತೀನಿ.
20. Seal number 67 urgent. For admission, seal number 68. For the petition. This is a matrimonial dispute. The matter will be settled in the trial court. That trial court order and along with joint. All the proceedings is quashed against the petitioner and family members in the trial court. Except this petition.
ಪೂರ್ತಿ ಕಾಸು ಕೊಟ್ಟಿದ್ದೀರಾ?
ಆರು ಶೀಟ್ ಎಂಟು.
This petition is by the husband challenging the registration of a crime against him, which has culminated in the filing of a charge sheet in CC number 06385/2014. Tenant counsel points out that the dispute between the petitioner and his wife has been settled, and the petitioner has paid some rupees 17 lakhs. And the marriage itself is dissolved in MC 3387/2012. We confirm with this code in MF 6750/2016. We place this on record. The order sheet in criminal appeal number 288/2020, whereby the appellate court has taken note of the fact that the demand drafts of rupees 3 lakhs dated 8/2/2023 and 16/2/2023 have been paid, and has permitted the husband to withdraw the appeal that had been filed challenging an order passed under the DV Act. So in the light of the above, there is no justification to continue the proceedings against the petitioner, and the same shall accordingly stand quashed.
For final hearing, number 69.
List.
18. 18. ಅವರೇ 70. ಅವರು ಮ್ಯೂಟ್
I represent the petitioner with that.
Yes.
For 10 days time with that. Some documents have to be filed.
2010
days time.
It's a 15-year-old case.
ಗೊತ್ತು ಲಾಸ್ಟ್ ಟೈಮ್ ಆರ್ಡರ್ ಆಗಿದೆ. I seek the indulgence of the court for 10 days. ಮಾಡ್ತೀನಿ, I will go on with the matter. 10 days time. ಅದು ಯಾಕಂದ್ರೆ ನಾಟ್ ಜೆನ್ಯೂನ್ ಅಂತ ಹೇಳ್ತಾರೆ. I have applied for certified copies. I will produce the same. 10 days time.
2010, I am not inclined to grant an adjournment after.
Next time ಮಾಡ್ತೀನಿ, positively without seeking time. I personally argue the matter.
Monday.
Monday ಬೇಡ, 18th ಹಾಕೊಳ್ಳಿ. Monday some inconvenience.
Monday 2010 matter.
ಅಲ್ಲ, Friday ಹಾಕೋಬಹುದು.
Friday.
14. Number 71, Shri SV Bhatt. SV Bhatt.
Even today, there is no representation. Left with no other alternative. Petition is dismissed on non-prosecution.
Number 72. Shri M. Narayan Reddy.
4 and 5, Lordship. Last time also we wrote to our party for non-cooperation. We wrote the letter also for 32. One more opportunity. Retired. Respond number 4 and 5. Here letter ಬರ್ದಿದ್ವಿ last time. Retired ಆಗೋದಕ್ಕೆ one more opportunity may be given so that I can write to them and inform that they are not cooperating, Lordship.
13-year-old, I am not prepared to.
Otherwise next date ಅಲ್ಲಿ ನಾವು retirement ಮಾಡೋದು.
What is annexure A?
Now they are challenging land tribunal order, Lordship. Belatedly by making amendment.
ಒಂದ್ಸಲ ಬಂದಿದ್ರ?
Ten days time may be given.
There is no representative of the petitioner. Matter being of the year 2012, there is no justification to adjourn the matter.
Next time I'll write.
Petition is therefore dismissed on opposition. DNP ಮಾಡಿದ್ದೀನಿ.
Please.
Bill number 73. Kumar.
This may also taken up after
ಏನು KLR matter? ಏನ್ ಮ್ಯಾಟ್ರ್ ಏನು?
recent ವಕಾಲತ್ ಹಾಕಿ ಮೊನ್ನೆ
ಏನ್ ಮ್ಯಾಟ್ರ್?
ಒಂದ್ ವಾರ ಆಯ್ತು.
ಅಂತೆ. ನೋಡಿಲ್ಲ ನಾವು, ನೋಡ್ದಲ್ಲ ಏನ್ ಹೇಳೋಣ. ಸಾಹೇಬ್ರ ಹತ್ರ ನೋಡ್ಕೊಂಡ್ಬಿಡ್ತಾರೆ.
No representation on behalf of the petitioner. Matter being of the year 2013, there is no justification.
Bill number 74. Srimati Vasudha HR.
This was the,
Case of rival tenancy, my lord.
what tenancy?
Rival tenancy. Petitioner and respondent number 3, original respondent number 3, they were the rival tenant. That in the first round occupancy election was granted in favor of the petitioner and the original third respondent, my lord, to an extent of 25 gunta. The matter came to be demanded. After demand, my
What
lord,
is, where is the impugned order? Annexure C, na?
After C, my lord. Only last portion of the ID.
Page 30 over the ವಿಶ್ಲೇಷಣೆ.
May I read, my lord? Reason starts from Liquidation at page 30.
ವಿಶ್ಲೇಷಣೆ.
ಪಟ್ವಾಡಿಪುರ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 11ರಲ್ಲಿನ 2 ಎಕರೆ 10 ಗುಂಟೆ ಜಮೀನಿಗೆ 1ನೇ ಅರ್ಜಿದಾರರಾದ ನಾಗಪ್ಪನವರು ದಿನಾಂಕ 15/1/79ರಂದು 7ನೇ ನಂಬರ್ ಅರ್ಜಿಯನ್ನು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಅದೇ ರೀತಿ 2ನೇ ಅರ್ಜಿದಾರ ಸಿದ್ದಪ್ಪನವರು ತಮ್ಮ ತಾಯಿಯೊಂದಿಗೆ
ನಿಮ್ಮ ಹೆಸರೇನು? ನೀವು ಸಿದ್ದಪ್ಪನಾ?
ಹೌದು. ಅರ್ಜಿ ಈ ಸಂಬಂಧವಾಗಿ ಭೂಮಾಲೀಕರಾದ ಶಾರದಮ್ಮನವರು 7/1/2003ರಂದು ಭೂ ನ್ಯಾಯ ಮಂಡಳಿಗೆ ಖುದ್ದು ಹಾಜರಾಗಿ 1ನೇ ಅರ್ಜಿದಾರರಾದ ನಾಗಪ್ಪನವರು 11 ಸರ್ವೆ ನಂಬರ್ 11ರಲ್ಲಿ 1 ಎಕರೆ 10 ಗುಂಟೆ ಜಮೀನನ್ನು ಗುತ್ತಿಗೆ ಸಾಗುವಳಿ ಮಾಡುತ್ತಿದ್ದರು ಮತ್ತು ಹಾಗೂ ನಾಗಪ್ಪನವರನ್ನು ಅಧಿಭೋಗದಾರರನ್ನು ನೋಂದಾಯಿಸಲು ನನ್ನ ಅಭ್ಯಂತರವೇನು ಎಂದು ತಿಳಿಸಿರುತ್ತಾರೆ. ಈ ಬಗ್ಗೆ ಪಾಟಿ ಸವಾಲು ಮಾಡಿದಾಗ 2ನೇ ಅರ್ಜಿದಾರ ಸಿದ್ದಪ್ಪ ಎಂಬುದು ಯಾರು ಎಂಬುದೇ ತಿಳಿದಿಲ್ಲವೆಂದು ಉತ್ತರಿಸಿರುವುದು ದಾಖಲೆಯನ್ನು ತಗೋತೇವೆ. My lord, in this context, you lordship may kindly see, my lord, in the first round, my lord, she had admitted the tenancy of the petitioner, that is Siddhappa, and occupancy rights been granted in favor of both the rival tenants to an extent of 25 guntas. Now she has gone to the extent of saying she doesn't know at all. That the litigation has started because of the strange relationship between these petitioners, Siddhappa's parents.
Second paragraph ಓದ್ಬಿಡಿ. ಕತ್ವಾಡಿ ಪುರದ.
Then, my lord, the further, the tribunal has relied on ಅರ್ಜಿದಾರರಾದ ನಾಗಪ್ಪನ್ 77-76ರಲ್ಲಿ ಸ್ವಾಧೀನದಲ್ಲಿದ್ದರೆ ಎಂಬುದು ಹಾಗೂ ಅದಕ್ಕೆ ಹಿಂದೆ ಅವರ ತಾಯಿ ಮಲ್ಲಮ್ಮ ಸ್ವಾಧೀನದಲ್ಲಿದ್ದರೆ ಎಂಬುದು ರಬ್ಬರ್ ಆರ್ಟಿಸನ್ಸ್. In this case, RTC, my lord, as far as 73-74, my lord, it stands in the name of Mallamma, that is the foster mother of Nagappa, who is the sister of this Mallappa, who is the petitioner's father.
So your name was not there in the records. Your name is not there in the records.
Not in the record, but his name is also not there.
Then what is the meaning of para 2 here? Para 2.
Pardon, my lord,
ಕತ್ವಾಡಿ ಪುರ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 11ರಲ್ಲಿ
what
1
I'm
ಎಕರೆ.
submitting for the year, Nagappa's mother had purchased 1 acre of land from the owner, that is fourth respondent. To that extent, 1 acre, my lord, her name has been shown, and after her death, for the year 75-76, the son's name, that is Nagappa's name has.
73-74 there is nobody's name.
ಇಲ್ಲ.
ಏನ್ ಮೇಡಮ್?
prior to that ಅಂತ ಹೇಳ್ತಾರೆ
ಅಲ್ಲ, she is saying this on the basis of a sale deed. Survey number 11 was 2 acres 10 guntas.
Please,
She says that the mother of this gentleman, or no, Nagappana, she had purchased 1 acre 10 guntas on the basis of which her name was entered in 73-76.
please.
But 73-74 ಖಾಲಿ ಇದ್ದಾಗ ಏನ್ ಮಾಡ್ಬೇಕು? And landlady says on one occasion she says she's a tenant, and the other occasion she says
She disputes, my lord.
On
Clear
that
occasion
ground
she
only
admits,
the
my lord, she has given.
remanded, my lord. In the
But
earlier
ಇಲ್ಲಿ
room.
ಹೇಳ್ತಾರೆ 1 ಎಕರೆ ಹೊರತುಪಡಿಸಿ ಉಳಿದ 1 ಎಕರೆ 10 ಜಮೀನು 1-3-74 ಮತ್ತು ಅದಕ್ಕೆ ನಿಕಟ ಪೂರ್ವದಲ್ಲೇ ಗೇಣಿ ಸಾಗುವಳಿಗೆ ಒಳಪಟ್ಟಿರುವುದು ವಿಚಾರಣೆಯಿಂದ ದೃಢಪಟ್ಟಿರುತ್ತದೆ.
ಎಲ್ಲಿದೆ ರೆಕಾರ್ಡ್?
ಅಲ್ಲ, my lord, they say page 30 ಅಲ್ಲೇ ಮೇಡಮ್.
records ಇದೆ ನಿಮ್ಮ ಹತ್ರ?
Records received, my lord. I'll 30, my lord. Tomorrow I can send.
Tomorrow. ಪಾಸ್ ಓವರ್ ಮಾಡ್ಲಿ.
Tomorrow, my lord.
Tomorrow.
Please, my lord. I have.
Day after tomorrow.
Please. Madam, ನೋಡ್ಬೇಕಾ? ನೋಡಿದ್ದೀರಾ?
Well, number 75.
Waiting for respondent, my lord. This is covered by judgments, my lord. The tenant files application claiming occupancy right in respect of the granted land, my lord. Observing so, my lord, rejected the application filed by the petitioner. Producing the citation along with my.
Next year Gina.
ಹೌದು.
Yes, ma'am.
Then ಹೋಸಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿರಲಿಲ್ಲ.
Yeah, the Friday, this matter, which I made submission.
I produced the citations. I have also produced the citations on 28/9/2000. I have also produced.
ಅವರು ಭಟ್ರ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ದು. This is a conceding of tenancy. Come to page 33. ಅದೇ ತಾನೆ?
Yes, ma'am.
Page 33.
Annexure, yes.
Next year. ಅಲ್ಲ, ಅದನ್ನ they can't claim application seeking occupancy right in respect of the granted land.
What granted land?
ಅದು SC/ST ಲ್ಯಾಂಡ್ ಇದು.
ಆದ್ರೆ
ಕೊಡಕ್ ಬರಲ್ಲ ಅಂತ ಇದೆ ಡಿಸ್ಟೆನ್ಸ್.
ಅಲ್ಲ, ಟೆನೆಂಟ್ ಆಗಿದ್ರೆ ಅವರು ಇಲ್ವಾ?
Tenant ಆಗಿದ್ರು they can't claim file application for grant of occupancy. That is the distance I have produced, my lord.
Where is the when was the land granted?
ಗ್ರಾಂಟ್ ಆಗಿಲ್ಲ, ಗ್ರಾಂಟ್ ಹಾಕಿದ್ದಾಗೇನೆ ಅಪ್ಲಿಕೇಶನ್ ಮೇಂಟೈನ್ ಆಗಲ್ಲ ಅಂತ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ರು.
ನೀವ್ ಯಾರು?
I am the owner of the property.
When did you, how did you get the land?
But lordship penitent to ಪ್ಯಾರಾಗ್ರಾಫ್ ಕಡತದಲ್ಲಿ ಲಭ್ಯವಿರುವ ಫಣಿ ಕಾಲಂ 12 ರಂಗಪ್ಪನ ಹೆಸರು ದರಖಾಸ್ತು ಮೂಲಕ LND ಎಂಬುದಾಗಿ ನಮಗೆ ಮಲಕನಂಗ ಇತರ ಜನಕ್ಕೆ ಜಮೀನು ದರಖಾಸ್ತ ಮೂಲಕ ಮಂಜೂರಾಗಿರುವುದು RTC ಅಂತ ತಿಳಿದು ಬರುತ್ತೆ. So it is a granted land under the SC/ST. I have produced the records, my lord.
You admit that you have tenanted this land, granted land?
I have also denied. Moreover, my lord, the tribunal
Not
rejected.
denied. Come to page 33.
ಪ್ರತಿವಾದಿಗಳಾದ ರಂಗಯ್ಯ ಬಿನ್ ಉಭಯ ಜಮೀನು ಗೇಣಿ ಅರ್ಜಿ ಸಲ್ಲಿಸಿ ಎಂದು ಗೇಣಿ ನೀಡಿಲ್ಲ ಎಂದೂ ಗೇಣಿ ನೀಡಿಲ್ಲ. ಹಾಗೆ ತಾವೇ ಅಭಿವೃದ್ಧಿ ಮಾಡುವುದಾಗಿ ಹೇಳ್ತಾರೆ. ಹಾಗೆ ಸದರಿ ಜಮೀನು ತನಗೆ ದರಖಾಸ್ತು ಮೂಲಕ ಮಂಜೂರಾಗಿದ್ದು ತಾನು ಯಾರಿಗೂ ಗೇಣಿ ಕೊಟ್ಟಿರುವುದೆಂದು ಹೇಳಿಕೆ ನೀಡಿರ್ತಾರೆ. ಇಟ್ ಈಸ್ ಬೈಕ್
ನಿಮ್ಮ ಹತ್ರ ಯಾವ ಕಾಪಿ ಇರೋದು? ಏನು ಓದ್ತಿರೋದು ನೀವು?
ರೆಡಿ ಇದು ಪೇಜಿಂಗ್ ಹಾಕೊಟ್ಟಿಲ್ಲ. ಅನೆಕ್ಸೆಡ್ ಜಿ ನಲ್ಲಿ
ನೆಕ್ಸ್ಟ್ ಎಫ್.
ಇದ ನೆಕ್ಸ್ಟ್ ಪೇಜ್. ರಂಗಪ್ಪ ಏನು ಆಗ್ಬೇಕು, ನಿಮಗೆ ಏನು ಸಂಬಂಧ ಇಲ್ಲ. ರಂಗಪ್ಪ ಗೊತ್ತು. ಬಟ್ ದಿಸ್ ಈಸ್ ಬಿಕಾಸ್ ರಂಗಪ್ಪ ಅನ್ನೋರು ಇಬ್ರು ಇದ್ದಾರೆ. ಆ ತರ ಕನ್ಫ್ಯೂಸ್ ಮಾಡ್ಕೊಂಡು ಅದು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ ಅಂತ ದೇ ವಾಂಟ್ ಟು ಟೇಕ್ ಅಡ್ವಾಂಟೇಜ್ ಆಫ್ ದಟ್ ಫ್ಯಾಕ್ಟ್. ಮೇಲೆ
ಓದಿ ಪೂರ್ತಿ ಓದ್ರ
ರಂಗಪ್ಪ ನೀನು ಏನು ಇದ್ದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ರಂಗಪ್ಪನಿಗೆ ಹೌ ಮೆನಿ ಬ್ರದರ್ಸ್ ಡೋಂಟ್ ನೋ. ಕರಿಯಪ್ಪ
ಕ್ವೆಶ್ಚನ್, ಅರ್ಜಿದಾರ ರಂಗಪ್ಪರವರೇ ಸಾಗು ಮಾಡಿಕೊಂಡು ಬಂದಿರುತ್ತಾರೆ. ಹೌದು, ಅವರೇ ಸಾಗು ಮಾಡುತ್ತಿದ್ದಾರೆ. ಅನುಭವದಲ್ಲಿ
ಅಂತಂದ್ರೆ ನಾನೇ.
ಇನ್ನೊಂದ್ಸಲ ಓದಿ. ಅರ್ಜಿದಾರ ರಂಗಪ್ಪ, ನೀವು ಅರ್ಜಿದಾರ ಅಲ್ಲ ತಾನೆ?
ನಾನು ಅರ್ಜಿದಾರ ಅಲ್ಲ, ಹೌದು.
ಅದೇ ಕ್ವೆಶ್ಚನ್. ಅರ್ಜಿದಾರ ರಂಗಪ್ಪರವರೇ ಸಾಗು ಮಾಡಿಕೊಂಡು ಬಂದಿರುತ್ತಾರೆ. ಹೌದು, ಅವರೇ ಸಾಗು ಮಾಡುತ್ತಿದ್ದಾರೆ.
ದಿಸ್ ಇಸ್ ಬಿಕಾಸ್ ಮೆಲಾಡ್ ಸಿನ್ಸ್ ಐ ಆಮ್ ರಂಗಪ್ಪ ಮೆಲಾಡ್ ನಾನೇ ಮಾಡ್ತಿದ್ದೀನಿ ಅಂತ ಹೇಳಿ.
ಕ್ವೆಶ್ಚನ್ ಅನುಭವದಲ್ಲಿ. ನೆಕ್ಸ್ಟ್ ಕ್ವೆಶ್ಚನ್ ಓದಿ.
ನೆಕ್ಸ್ಟ್ ಕ್ವೆಶ್ಚನ್. ಗೇಣಿದಾರ ಮಾಡಲು ತಮ್ಮ ತಕರಾರು ಇಲ್ಲ, ವಾರವಿಲ್ಲ ಪಡೆದು ಕೊಡುತ್ತಿದ್ದವು ಮರಗಳನ್ನು
ಸೋಮಶೇಖರ
ಅವರ ಮೆಲಾಡ್. ದಿಸ್
ಸೆಕೆಂಡ್ ಕ್ವೆಶ್ಚನ್ ಇಸ್ ಅನುಭವದಲ್ಲಿ ಅವರೇ ಇದ್ದಾರೆ. ಗೇಣಿದಾರನಾಗಿ ಮಾಡಲು ತಮ್ಮದೇನು ತಕರಾರು ಇಲ್ಲ. ವಾರವಿಲ್ಲ ಪಡೆಯುತ್ತಿದ್ದೀರಾ, ಕೊಡುತ್ತಿದ್ದರು. ಮರಗಳನ್ನು ಅರ್ಜಿದಾರರೇ ಬೆಳೆಸಿದ್ದಾರೆ, ಅವರೇ ಬೆಳೆಸಿದ್ದಾರೆ. ಏನ್ ಕನ್ಫ್ಯೂಷನ್ ಇದೆ ಇದರಲ್ಲಿ?
Even if there is admission, my lord, the application for grant of occupancy right is not maintainable. That is the ground taken by the tribunal and rejected the application at this threshold.
What is the judgment?
Please, my lord. The statement of objection. Statement of objection 14/12/2015.
Yes.
Let annexure R2. M. Siddhojirao versus the state of Karnataka and others. Karnataka Scheduled Caste and Scheduled Tribes Prohibition of Transfer of Certain Lands Act 1978. Karnataka Act number 79, section 4 and 11. Alienation of land made by a member of a scheduled caste or a scheduled.
This is by the purchaser.
Please, my lord. In contravention of.
This is not by the grantee.
Please, my lord. ಅದು ಕೆಳಗಡೆ. Made by a member of scheduled caste in certain in contravention of the terms and grant. Petitioner claiming to be tenant under the alienee and acquiring occupancy right from the land tribunal. Order of land tribunal confirming occupancy right is non-existing in the provisions of the act shall have effect notwithstanding anything conclusion contained in any other law, decree or other court, tribunal or other. The act is a special act enacted to void the alienations of land granted to member of scheduled caste and scheduled tribes in contravention of the terms of grant made to them by the state. The act prevails over all other laws, contracts, decrees, orders, and awards made by the courts or tribunals under their laws. In dealing with the cases arising under this act, if an assistant commissioner finds that an alienation is in contravention of the terms of the grant made to a member of caste or scheduled tribe, he is bound to give effect to the state by ignoring the decree or order by a civil court, tribunal, or any other authority. Paragraph 10 and 16, madam. Actually, paragraph 10 and 16 of the order, madam. The act is special enacted to avoid alienations of land granted to a member.
More case, Somshekhar.
Please,
More case, it was a case of the purchaser inducting a tenant.
Innone judgment ಕೊಟ್ಟಿದ್ದೀನಿ. Next judgment.
Show me a judgment where it says if the grantee inducts a tenant, even then Land Reforms Act will not apply. ಈ ಮೂರು ಕೇಸಸ್
itself is clear. ಇದು ಲೀಸ್ಗೂ ಕೊಡಂಗಿಲ್ಲ ಅಂತ ಇದೆ. ಆಕ್ಟ್ ಇಟ್ ಸೆಲ್ಫ್ ಸೆಕ್ಷನ್ 4 and 5 ಇಟ್ ಇಸ್ ಕ್ಲಿಯರ್. ಮೇಲೆ
ಅದು 79 ಇಸ್ವಿ ಆದ್ಮೇಲೆ 79 ಇಸ್ವಿ 60ನೇ ಇಸ್ವಿಯಲ್ಲಿ ಅದು ನಿಮ್ ಗ್ರಾಂಟ್ ಆಗಿದ್ರೆ
ಅಲ್ಲ, ಇದು ಸೆಕ್ಷನ್ 4 and 5 ಅಲ್ಲಿ SC/ST ಆಕ್ಟ್ ಅಲ್ಲಿ ಇವನ್ ಲೀಸ್ಗೂ ಕೊಡಂಗಿಲ್ಲ ಅಂತ ಅಂತೆಲ್ಲ ಇರೋದು. ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿದೆ.
60ನೇ ಇಸ್ವಿಯಲ್ಲಿ ನೀವು ಅವ್ರಿಗೆ ಗೇಣಿ ಕೊಟ್ಟಾಗ ಅವಾಗೇನು ಕಾನೂನಲ್ಲಿ ಬಾರಿ ಇರ್ಲಿಲ್ಲ.
When the act in therefore, my lord, Act is overing effect ಅಂತ ಅಂದ್ಬಿಟ್ಟೆ ಬಂದಿರೋದು ಅದು. That is next judgment, my lord.
More judgment may not apply because in all the three judgments, it is the case of the purchaser having inducted the tenant. Therefore, they said, if the alienation is contrary to the terms of the grant, the land tribunal gets no jurisdiction. ಇದು alienation ಆಗಿಲ್ಲ.
Alienation ಆಗಿಲ್ಲ ಅಂತ ಅಲ್ಲ.
ಆಗಿಲ್ಲ. ನೀವೇ
The act itself is, my lord, clear. No granted land can be alienated or lease or to give ಬಾಡಿಗೆಗೂ ಕೊಡಂಗಿಲ್ಲ ಅಂತ ಇದೆ. That is the section, my lord.
alienation ಮಾಡಿದ್ರೆ ಬಾಡಿಗೆ ಕೊಟ್ಟು
Alienation ಅಲ್ಲ,
ಬಾಡಿಗೆ-
lease ಗೂ ಕೊಡಂಗಿಲ್ಲ.
ಬಾಡಿಗೆ ಕೊಟ್ಟರೆ alienation ಆಗಲ್ಲ.
ಅಲ್ಲ ಲೀಸ್ಗೂ ಕೊಡಂಗಿಲ್ಲ.
ತೋರಿಸಿ ಸೆಕ್ಷನ್ ತೋರಿಸಿ. Rented land, PDC.
ಇದೆಲ್ಲ SC
ಅಗ್ರಿಮೆಂಟ್ ಆಫ್ ಸೇಲ್, GPA ಎಲ್ಲ ಕರೆಕ್ಟ್ ನೀವು ಹೇಳೋದು.
ಹೌದು GPA
ಟೆನೆನ್ಸಿಗೆ ಆತರ ಬಾರಿಲ್ಲ.
ಅಲ್ಲ ಟೆನೆನ್ಸಿ ಇದು ಆಕ್ಟ್ ಹೇಳ್ತೈತೆ ಅದರಲ್ಲಿ.
ಆಕ್ಟ್ ತರದ್ರೆ ನಾವೊಂದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ಸಾರಿ ಮೇಲೆ ಡಿಸ್ಟೆನ್ಸ್ ಇತ್ತಲ್ಲ ಅದಕ್ಕೋಸ್ಕರ ನಾನು ಸಾರಿ ಮೇಲೆ.
ಟ್ರಾನ್ಸ್ಫರ್ ಮೀನಿಂಗ್ ನೋಡಿ.
Section 4 and 5.
4 and 5 ಅಲ್ಲ, ಟ್ರಾನ್ಸ್ಫರ್ ಡೆಫಿನೇಷನ್ ನೋಡಿ. ಫೀಸ್ ಅಂತ ಇದೆ. Then it is a transfer ಅಂದ್ಬಿಟ್ರೆ.
Here, the main question is whether granted and not to the SC/ST. He has produced R1 grant certificate. It's for upset price and it's not for any persons of SC/ST or nothing has been stated in this. Annexure R1 Milan. Your Lordship may kindly see. Granted to so and so on 31/8/25 as per number RD number so and so
Engage with
permanent.
Why do you say it's not a granted land?
It granted not to a person of SC/ST. That's
Then what is this grant?
This is a grant, ordinary grant for an upset price. Miller, you asked me, can you see that grant on 30/11/60? Permanent Sagwal sheet has been issued to crediting the upset price. Rent
Judgment annexure R4 ಮೇಲೆ.
Rent so and so, and in also it is further state is a sale.
No, do you have a copy of this order which is indicated in the top? 4 acres of land out of so and so granted by the Special Assistant
Special
Commissioner
Deputy Commissioner, Tumkur, in favor of.
On 31/8/59.
31/8/59, as per GO number RD number so and so.
Madam, then granted land is.
30/11/1960.
What is the order of grant? It only says Darkast. Is it a land granted to scheduled caste, scheduled trade?
It was for upset price also.
Is it a land granted to a person belonging to scheduled caste?
I am belonging to a scheduled caste.
What is there to show that?
Tribunal itself has held.
No. It's not stated so in order.
I'll have a day after tomorrow, find out whether it is a land granted to a person belonging to scheduled caste, scheduled trade.
If you let's query Malad annexure
If it's a regular,
R4.
if it's a regular grant and
Leads to know that I have produced the judgment annexure R4.
ನೀವು ಫಸ್ಟ್ ಶೆಡ್ಯೂಲ್ ಕಾಸ್ಟ್ ಶೆಡ್ಯೂಲ್ ಟ್ರೈಬ್ ಬೆಲೆ ಹಾಕ್ತೀರಾ ನೀವು?
ಹೌದು, ನಾನು I am belonging to scheduled caste.
Our grant ಅಲ್ಲಿ if it's not land granted to you on the ground that you schedule caste schedule tribe, this argument goes.
Yes, sir, ನಾನು scheduled caste ಗೆ ಸೇರಿಲ್ಲ ಅಂತ.
ಅವ್ರು ಕೊಡ್ಬೇಕಾರೆ ಕೊಟ್ಟಿರ್ಬೇಕಲ್ಲ. ನೀವು SC/ST ಗೆ ಸೇರಿದ್ರ ಅಂತ ಗ್ರಾಂಟ್ ಮಾಡಿದ್ರೆ ನೀವು ಹೇಳೋದು ಕರೆಕ್ಟ್.
This is a land granted to the, they have to produce the records.
You will have to produce.
I will produce the record to show that I am belonging to
tomorrow
scheduled caste. It is granted
Day
to
after
scheduled caste person. Malad, with regard to that query, Malad, lease ಇದಕ್ಕೆ annexure R4.
Definition ಇದೆ.
Definition ಇದೆ. That is clearly.
Bill number 76, DM Sitapa. Bill number 77, Bill K. Naresh. 77. For hearing B group, Silver 78, became Prakash.
Appear for the appellate, my lords. I had filed this writ petition seeking to quash the order dated 31/2007 and 24/10/2013. These were the orders that was passed by the Assistant Commissioner and Deputy Commissioner.
Which one is annexure E?
Annexure E and F. I purchased 21 guntas in survey number 124 of Uduvegere village on 26.
Where is the order of the Tahsildar? You produced it?
No, your lordship.
No.
Tahsildar's orders were not in our custody, because we were not made parties to that.
What is annexure E?
Annexure E is Assistant Commissioner's order. That was, Tahsildar's order was challenged by respondent number 3. And that also came to be dismissed.
What was his claim before the AC?
No, he has filed an application to come on record as additional respondent in the revision petition. The 1 Rule 10 application ಹಾಕೊಂಡು ಬಂದಿರೋದು. That is a paid number. Operative portion ಮೇಲ್ಗಡೆ. ಈ ಅರ್ಜಿಯ ವಿಚಾರಣಾ ಹಂತದಲ್ಲಿ ಮರಿಗಂಗಯ್ಯ, that is the present petitioner, wants to come on record as additional respondent in the revision petition. Stating that he has got interest. Revision petition has been dismissed. Now, as that now the present writ petition has been filed.
No, what was the order of the Tahsildar?
Tahsildar mutation has been effected in the name
Whose
of
favor?
in favor of these
Respondent number 1 and
respondents.
2.
In favor of?
In favor of this respondent number 2 and 3.
Yes, sir.
Ganga Basvaya and Revan Siddhaya. Their claim has been negatived by in the previous civil suit.
No, let go. Khata was standing name of which person?
ಯಾರು?
It was in the name of,
ಮುಂಚೆ ಅವರು ಹೆಸರಿನಲ್ಲಿ ಇತ್ತು ಅಂತ ಇದ್ ಮಾಡಿದ್ರು. Then court decree ಆಯ್ತು. Court decree ಆದ್ಮೇಲೆ ಅವ್ರ that their claim has been negative and this sale deed has been considered in the previous judgment. So thereafterwards now Mari Basvaya, one of the person who claims to be the interested person, files an appeal before the assistant commissioner. Mari Basvaya and
AC, he preferred an appeal before the AC challenged the registration of Khata in favor of
this present respond number 1 and 2.
Revan Siddhaya.
That is not
Ganga
Revan
Basvaya and
Siddhaya.
Revana
That is respondent
Next week, there are two, only one, Ganga Basvaya.
Ganga Basvaya and Revan Siddhaya.
So there were two respondents.
Yes.
He was agreed with the registration of the Khata in favor of Ganga Basvaya and Revan Siddhaya.
Our is Mari Basvaya challenge. He has not challenged.
Now, the appeal was filed challenging registration of Khata in whose favor?
In favor of this respond number 1 and 2.
That is Ganga Basvaya and Revan Siddhaya.
Revan Siddhaya.
That appeal was dismissed.
That appeal was dismissed. Then revision petition was filed by Mari Basvaya. In that revision petition, this present petitioner wants to come on record as the additional respondent and he files an application on R 1 Rule 10. That
You
is also
have not
rejected.
challenged the order of registering Khata in their favor.
in Tahsildar's order. Your Lordship, I was not given notice. I was not made a party to that.
Then you should prefer an appeal itself. Somebody else files a revision. How can you go implicate yourself as a petitioner there?
My extent is reduced to 7 guntas, my lordship. The problem was that I have purchased 21 guntas. I would have not been aggrieved if in case the 21 extent guntas that I purchased, if it was not reduced to 7 guntas after the
Are
Tahsildar
you saying that under the order of the Tahsildar it was
it was
reduced?
reduced.
Show me the order of the Tahsildar.
Your Lordships, that is not,
Then you don't challenge the order of the Tahsildar. Somebody challenges the order of the Tahsildar. That appeal is dismissed. Then that matter, that gentleman carries it in revision. In that you want to challenge of what? On what basis? What does the DC say about you in this case?
Civil court ಹೋಗಿ ಅಂತ ಇದ್ ಮಾಡಿದ್ರೆ. Reduce the only thing is finding has been recorded as per page number 88.
Where is your application on Road 1 Rule 10?
They are not placed.
Your Lordships have not annexed it to this petition.
And go to the civil court.
I
You don't even know
I may
what
be
is.
permitted
There are
to
88
file,
packets.
I may be permitted to file the,
What have you said in your writ petition?
No, may I make one submission, Lord? 88, page number 88, kindly be seen. The judgment copy at paragraph 14. This sale deed they have relayed that has been negative. Because this present petitioner is none other than the son of second defendant in the original suit.
Don't invite a finding from me. At least he is granted to liberty. Go to the civil court and litigate.
my Lordships, a date may be given.
Father was party in the previous proceedings.
An
And
order of mutation.
finding has been recorded.
Was passed in favor of respondents.
One and
Respondent 1 and 2. This led to the filing of appeal by the third respondent. However, the appeal of the third respondent was dismissed. Next, as against the dismissal of the appeal, the Mari Basvaya, the third respondent who had preferred the appeal of the assistant commissioner, filed a revision. This revision has been dismissed. However, in pendency of this revision, the present petitioner made an application seeking to implead himself
additional response.
in those revision petition, in that revision petition as a co-petitioner.
Not copied, additional response.
Additional.
ಅಲ್ಲ ನೋಡಿ ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್
ಇದ್ರಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ. ಅವ್ರು
Like that.
ಅಪ್ಲಿಕೇಶನ್ ಇಲ್ಲೇ ಹೇಳಿದ್ರು.
ತನ್ನನ್ನು ಅವಶ್ಯಕ ಪಕ್ಷಕರನ್ನಾಗಿ ಸೇರಿಸಿಕೊಂಡು
ಅದ್ರಲ್ಲಿ ಅವ್ರು ಅಬ್ಸರ್ವ್ ಮಾಡಿರೋದು. ಇದರಲ್ಲಿ grounds
seeking to implead himself on the ground that he also had a right in the said property. Insofar as this contention was concerned, the deputy commissioner has held that if the petitioner claimed that he had any rights over the said property, comma, it would be open for him to approach the civil court and the revenue interest would ultimately abide by the decision of the civil court. In my view, since the petitioner had not challenged the order of mutation passed in favor of the respondents hearing, the view taken by the deputy commissioner cannot be found fault with. I find no reason to entertain the petition.
Para
Writ petition
7
is
ಅಲ್ಲಿ
therefore dismissed.
Your lordships,
As
liberty may be given. Liberty may be given to.
He's already claiming that liberty.
para number 7 ಅಲ್ಲಿ they have stated respondent ಅಂತ.
Number 79, Raghunandan. Raghunandan MS.
Lordship, in this case, Lordship has directed the government to take the stand with respect to the status of the petitioners, because I had made a submission that they have not filed the application respect to regularization of unauthorized occupancy.
Yen madam?
They have this matter on Friday, madam.
2014 matter, madam.
My lord, please, madam. My colleague, just to give me.
ಏನಿಲ್ಲ ರಿಪೋರ್ಟ್ ಏನೂ ಇಲ್ಲ ರಿಪೋರ್ಟ್ ಅಲ್ಲ
Silver 80?
ಅನ್ಆಥರೈಸ್ಡ್ ಆಕ್ಯುಪೆಂಟ್ಸ್
Status.
ಸುಮ್ಮನೆ
Madhusudan Rao?
ಅಲ್ಲಿ ಆ document-
Senior is on his legs, my lords. Kindly pass it over, my lord. We'll address his arguments today.
Number 81, Shri Anand. Shri Anand.
Then my lord, remanded to the DC and create the order, my lord.
What has happened to the other matter?
Even that has also been held against this appellant. The club matter there, my lord. They have appealed against that particular order also.
1.1.
81.1. Against that also they have appealed before this court.
I'll give him one chance. If he does not come next time, I'll dismiss.
Achha.
It's the last chance.
Yes, ma'am.
17. Number 82.
Here for the respondent, 3 to 5 lakhs. 1976 land tribunal has been challenged now. Belatedly, Lordship, stating that application for number 7 has been not signed by the party.
The last chance, the list.
17.
Please.
Seal number 83. To be Vachan. The petitioner, I request for a passover, my lord. Senior is held in another court. Seal number 84. And for the Ravindra BS.
Serial number 84.
Sir. 84.
I appear for the petitioner, Lord. Lord, the petitioner is the owner of the land bearing survey number 154, measuring 2 acres of land. He got the revenue records transferred in his name as per on 10/12/2014.
What is the impugned order?
Lord, the cancellation of revenue entries in the RTC and entering the name of the government by virtue of order passed by the deputy commissioner, that is respondent number 1.
Annexure F,
Yes, my lord. Annexure E, my lord. Annexure E is the order. And there is already this court has passed a detailed order, my lord. Coordinate bench, sir. On the same issue.
Without notice to you now.
Please, my lord.
Without notice to you, this order has been passed?
Yes, my lord.
My lord, I have to see this judgment, my lord, without notice. And I would Friday, my lord.
Or order copy ಕೊಡಿ ಒಂದ್ಸಲ ನೋಡ್ಲಿ.
I have taken this.
There is another matter on 12th, my lord. Same on the same
Number
issue.
ಕೊಡಿ. Post along with WP
It
number.
is already listed. Date has been given.
Number ಕೊಡಿ.
Yes, please.
Seal number 85. Sri Ramakrishna. 85.
For the respondent, your lordship.
Petition, my lord. In this case, LR application was allowed, amended cast was carried out, amended petition filed.
Tell the amended petition. Copy for
Last time, ಕೊಟ್ಟಿದ್ದೀವಿ.
amended petition copy.
On 13/12 ಕೊಟ್ಟಿದ್ದೀವಿ ನೋಡಿ ಇಷ್ಟ.
Application.
Application amended, nothing but amended cast title, nothing. In respect of R4.
Your lordship. Petition and response as brothers, your lordship. They entered into any partition, unregistered partition deed. According to the unregistered partition deed, your lordship, revenue records are entered, mutation was carried in the year of 1994. In respect of one survey number, your lordship, now he is claiming that survey number, I have not given, I have equally given the share of 12 guntas because it's that survey 27/3 particularly measures 24 guntas. In that survey number, I have not given the share and he challenges in the said mutation in the year of 2014. Tahsilar's order, your lordship. 2014, your lordship, the assistant commissioner set aside the said order of the mutation in respect of the one survey number.
On what ground? On what ground?
On the ground, your lordship, it is in respect of, he claims that he is having the share of the, half of the share in that particular survey number. 27/3, now our contention was, your lordship, the unregistered partition deed, which nobody, he is also holding, saying that, your lordship, we don't have the original partition deed. On the other hand, we contend we don't also have the original partition deed. In fact, your lordship, it is in the hands of petitioner. He forged the Xerox copy of the partition deed, unregistered partition, then made a petition before the assistant commissioner based on that.
Your name was entered into this survey number on the basis of that partition deed,
Yes,
unregistered partition deed.
yes.
That was challenged.
His name is also entered in the unregistered partition deed. In 94, MR number is taken in 94. One survey number 27/3
What did the DC do?
This, your lordship observes that it resolve the dispute before the civil court.
both of you got the kata change onto the same document.
Same document.
Yes, my lord, that
But you did not challenge that MR till 2004.
my lord,
Till
AC
2014.
let me alone. AC order is in my favor.
Correct. ನಾನು ಕೇಳ್ತಿರೋದು ಇಬ್ರು ಸೇರಿ ಒಂದೇ ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಟ್ಬಿಟ್ಟು ಖಾತಾ ಅದ್ರ ಪ್ರಕಾರ
ಖಾತಾ ಮಾಡ್ಕೊಂಡಿದ್ದೀವಿ ಸ್ವಾಮಿ. ಖಾತಾ ಇದೆ. Let me allow me sir submit. Why are you interpreting? Your lordship me annexer C series.
Where is the MR? Where is the MR?
MR is also entered on the same record.
ಇಲ್ಲ ಎಲ್ಲಿದೆ MR ಅದು?
MR ಇಲ್ಲ sir.
ಎಲ್ಲಿದೆ ಅದು?
ಪಾಣಿ ಇಲ್ಲ MR ಇಲ್ಲ MR ಪರ್ಚೇಸ್ ಮಾಡ್ತೀನಿ.
ಎಲ್ಲಿದೆ?
MR ಇಲ್ಲ ಪಾಣಿ ಇದೆ ಪಾಣಿ.
ನಿಮ್ಮ ಹೆಸರೇನು?
ಸಮೀರ್ ಮುನಿಯ ಚೆನ್ನಪ್ಪ.
ಚೆನ್ನಪ್ಪ.
ನೀವು ಮುನಿಯಪ್ಪನ?
ಮುನಿಯಪ್ಪ.
both are sons of Patel.
(27/3) dispute ಇದೆಯಾ?
ಹೌದು.
27/3 according to you was given to you under the partition.
Yes.
Now he challenges this
Only that survey number. In that claiming that half of the share.
My lord, according to the partition, Pani was entered. Your lordship will tell annexer C.
ಆಯ್ತು. I have the MR itself. ಇದರಲ್ಲಿ 27/3 ಅವರು
It is cooked up, no, my lord. It is cooked up. It is cooked up. My lord, revenue entries.
ಇದು ಒಂದೇ ಒಂದು ಕೂಗ್ಬಿಟ್ಟಪ್ಪ.
ಸಮಯ
27/3 ಮಾತ್ರ ಕೂಗ್ದಪ್ಪ.
27/3
ಒಂದೇ ಮಿಕ್ಕಿದೆಲ್ಲ ಸರಿ ಇದೆ.
ಮುಖ್ಯದ ಅದ್ರಲ್ಲೂ ನಮ್ಗೆ 12 ಗಂಟೆ ಬರಬೇಕು.
ಯಾವ್ದ್ರಲ್ಲಿ?
ಸಮಯ annexer C 27/3 totally measuring 24 guntas.
Correct.
Out of which I am entitled for 12 guntas.
File a civil suit.
Already filed. They have filed a suit, civil suit that has been dismissed, my lord. I have produced it.
Is dismissed.
That I don't expect.
My lord, annexer C, my lord.
Annexure.
ನಿಮ್ ರಿಪಿಟಿಷನ್ ಕೊಟ್ಟಿದ್ದೀನಿ ನೋಡಿ.
Requisition copy ಇಲ್ಲ ಸರ್ ಅದದ್ದು ಪೂರ್ತಿ. Annexures ಇಲ್ಲ.
Judgment ಕೊಡಿ.
ಸ್ವಾಮಿ annexer F.
Petition copy ಕೊಟ್ಟಿಲ್ಲ ನನಗೆ.
Annexer F, my lord. In page.
ಇಲ್ಲ plaintiff ಇದು DNP ಕೇಸ್ ಇದು. This suit for permanent injunction.
Permanent injunction filed by the R4.
ಸರಿ ಅದು ಇಂಜಂಕ್ಷನ್ ಸೂಟು ಅವ್ರ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ ಅವ್ರ ಕ್ಲೇಮ್.
ಸ್ವಾಮಿ ಅದ್ರ ಮೇಲೆ ನನಗೆ ಬರಬೇಕು ಅಂತ ಹಾಕಿದ್ರು. ಇದ್ರಲ್ಲಿ ನಮ್ಗೆ ರಿಸ್ಟೈನ್ ಮಾಡಿದ್ರು ಈ ಸೂಟ್ ಮೇಲೆ, ಈ ಪ್ರಾಪರ್ಟಿ ಮೇಲೆ.
ರಾಮಕೃಷ್ಣ ಅವರೇ, ಇದು ಇಂಜಂಕ್ಷನ್ ದಾವ. ನಾನು ಸ್ವಾಧೀನಲ್ಲಿದ್ದೀನಿ ಅಂತ ಹಾಕಿದ್ರು, ಅದು DNP ಆಗಿದೆ. ಅದರಿಂದ ನಿಮ್ ಜಮೀನು ಅದು ಹೆಂಗಾಗತ್ತೆ?
ಅಲ್ಲ ಸ್ವಾಮಿ, ಅವರೇ ಹಾಕಿದ್ರು ನನಗೆ ಬರಬೇಕು 24 ಗಂಟೆ ಅಂತ.
ಅಲ್ಲ, ಅವ್ರು ನನಗ್ ಬರ್ಬೇಕು ಅಂತ ಹಾಕಿಲ್ಲ. ನನ್ಗೆ ಇಂಜಂಕ್ಷನ್ ಕೊಡಿ, ನಾನ್ ಸ್ವಾಧೀನಲ್ಲಿದ್ದೀನಿ ಅಂತ ಹಾಕಿದ್ರು.
ಹೌದು ಸ್ವಾಮಿ, ಅದ್ರಲ್ಲಿ ಪಾರ್ಟಿಷನ್ ಆಗಿದೆ, ಅವ್ರಿಗೂ ಬರ್ಬೇಕು ಅಂತ ಹೇಳಿ
ಪಾರ್ಟಿಷನ್ ಸೂಟ್ ಹಾಕೊಳ್ಳಿ. ರಾಮಕೃಷ್ಣ ಅವ್ರು, ಇದು ಯಾಕೆ ಸುಮ್ಮನೆ ಜಗಳ ಆಡ್ತೀರಾ?
ಸ್ವಾಮಿ ಅದು ಅವ್ರು ಹಾಕಿದ್ರು, ವಜಾ ಆಯ್ತು, ಆಯ್ತಲ್ಲ.
ಅವ್ರು ಹಾಕಿದ್ ಬರೀ ಇಂಜಂಕ್ಷನ್ ದಾವ. ಇಂಜಂಕ್ಷನ್ ವಜಾ ಆಗಿದ ತಕ್ಷಣ
ಸ್ವಾಮಿ ಅದ್ರ ಮೇಲೆ MA ಹಾಕಿದ್ರು. ಸ್ವಾಮಿ MA ಹಾಕಿದ್ರು, ಅದು ಡಿಸ್ಮಿಸ್ ಆಯ್ತು. ಅನೆಕ್ಸ್ ಇನ್ ಪೇಜ್ 56 annexer G.
ಇದು ಇಂಟ್ರಿ ಆರ್ಡರ್ ಮೇಲೆ ತಾನೆ?
ಹೌದು ಸ್ವಾಮಿ.
ಇಂಟ್ರಿ ಆರ್ಡರ್ ಬೇಡಿ. Now you are claiming.
My lord, they have filed on the basis of the document, this document, they have already filed a suit that has been dismissed by the honorable.
Ramkrishna, on that ground, I can't do it. Please realize the consequence. If it's on the basis of unregistered partition deed, the entire thing will have to go.
ಅಲ್ಲ
ಅದು ಇನ್ನೂ ರಗಳೆ ಆಗುತ್ತೆ. ಅದ್ರ ಬದಲು
ಸ್ವಾಮಿ ಅವ್ರು ಎಲಿನೇಟ್ ಮಾಡ್ಬಿಡ್ತಾರೆ. ಆಲ್ರೆಡಿ ಅವರು 10 ಕೋಟಿಗೆ ವ್ಯಾಪಾರ ಮಾಡ್ಬಿಟ್ಟವ್ರೆ. ಹೋಗ್ಬಿಡಿದು
ತಕ್ಷಣ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ತಗೊಳ್ಳಿ.
ಅಲ್ಲ, ಹಂಗಾಗಲ್ಲ ಸ್ವಾಮಿ. ನಾನು ಮೆರಿಟ್ ಮೇಲೆ ಆರ್ಗ್ಯೂ ಮಾಡ್ತೀನಿ. ಆಯ್ತು
ಮಾಡಿ ಮೆರಿಟ್ ಮೇಲೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ.
ಇವತ್ತು ಒಂದ್ ಸ್ವಲ್ಪ ಟೈಮ್ ಕೊಡಿ, ನಾನು ಮಾಡ್ತೀನಿ, ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀನಿ.
ಟೈಮ್ ವೇಸ್ಟ್ ಮಾಡ್ತಿದ್ದೀರಾ ನೀವು?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಇಲ್ಲ ಸರ್, ಫಸ್ಟ್ ವೀಕ್ ಹಾಕೊಳ್ಳಿ ಸ್ವಾಮಿ. ಅಯ್ಯೋ, ಅದು ರಿಗಾರ್ಡಿಂಗ್ ಅದರ್ ಎಂಟ್ರೀಸ್ ಅವ್ರು ಪ್ರಾಕ್ಟಿಸ್.
ನೆಕ್ಸ್ಟ್ ಮಂಡೇ
ಸ್ವಾಮಿ ಮಂಡೇ ಬೇಡಿ ಸ್ವಾಮಿ, ಮಂಡೇ ಬೇಡಿ.
ಮಾಡ್ತೀನಿ, ನಿಮ್ ಟೈಮ್
ಸ್ವಲ್ಪ ನನ್ಗೆ ಮೆಡಿಕಲ್ ಇದೆ. ಫಸ್ಟ್ ವೀಕ್ ಹಾಕೊಳ್ಳಿ, ನಾನು ಆರ್ಗ್ಯೂ ಮಾಡ್ತೀನಿ.
ಆ ಫಸ್ಟ್ ವೀಕ್
19, 20, 21 ಹಾಕೊಳ್ಳಿ. 20th interior order to be
20th. 20th I'll be in Dharwad bench.
You choose a convenient date.
21st ಗೆ ಹಾಕೊಳ್ಳಿ.
21st.
Silver 86.
So interior order to be
Silver 86.
Yes.
Annexure H is the
Sir Jane,
Annexure J is the impugned order, madam, passed by the deputy commissioner.
I appear for respondent number 9. I appear for respondent number 9.
ready na?
Pray for time, sir. Objection, sir.
See list.
Date may be fixed, my lord. 16th April. 16th April.
Number 87,
Next,
Margin of PS.
Appear for the petitioner, my lord.
What is the date code?
My lord, I have purchased two properties, one bearing, in survey number 144, bearing 4 acre 38 guntas and 1 acre 38 guntas, my lord. This survey number 144 it has a total extent of 264 acres, my lord.
What is annexure A?
Annexure A is my representation to the DC for filing of reconstruction of documents, my lord. I wanted to create PODI, but they said that documents are not available. This is my representation to create for reconstruction of documents. My lord, there is also a government.
1 minute. I'll direct them to consider your request.
For reconstruction, my lord.
The petition is filed for issuance of a direction to the
Annexure A, my lord. Page number 10.
ಯಾರಿಗೆ ಕೊಟ್ಟಿದ್ದೀರಾ ನೀವು ಅರ್ಜಿ?
ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು.
Deputy Commissioner to reconstruct the file reference number 144 measuring 4 acres 38 guntas
And 1 acre 30.
and 1 acre 38 guntas. In respect of which the petitioner claims that he has been granted a temporary grant. Lord Counsel, Learned AG on instruction submits that the request of the petitioner will be considered and appropriate orders will be passed by the Deputy Commissioner within a period of 3 months from date of receipt of copy of this order. According to the said submission, the writ petition is disposed of, that the DC to consider the reply within a period of 3 months.
Much
Number
obliged.
88, Sri Marigoda.
Yes, hearing for the petitioner. The last year, the lordship heard. The other side for
Respondent 7, kindly pass out, my lord.
So,
Number 89, V Ramesh.
2 weeks time file the statement of objection, my lord.
ಏನಾಗಿದೆ ರೆಸ್ಟೋರೇಷನ್ ಆಫ್ ರಾಸ್ ಕಾಲ್ವೆ
you are implementing applicants here.
ಅದು ಪಂಚಾಯತ್
I am the implementing
ಮಾಡು ಅಂತ ಹೇಳಿದಾರೆ ಅದನ್ನ ದಟ್ ಮೇ ಬಿ ಅಲೌಡ್.
ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಬೇಕಾಗುತ್ತೆ, ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಬೇಕಾಗುತ್ತೆ.
Application allow ಮಾಡಲಾ? Implementing application.
Because my lord, they have issued
Application allow
form 9 and 10 to construct a temple on a government land. My lord, now they have to
ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲ ಆಗ್ಬೋದು ಬಟ್
The application implementing is unopposed and is hence allowed. Petition to amend the cost rating. Relist on.
next week.
2 weeks ಮೇಲೆ ಅಷ್ಟೇ ಅಬ್ಜೆಕ್ಷನ್ ಡೀಟೇಲ್ಸ್.
ನಿಮ್ಗೇನ್ ಸ್ಪೆಷಲ್, ಅವ್ರಿಗೆಲ್ಲ ಒಂದೇ ವಾರ ಕೊಡ್ತಾ ಇದೀನಿ. 10 days ಬಿಟ್ಕೊಡಿ.
20th.
Much of
ಯಾರು ಬರ್ಲಿಲ್ಲ. ಹಾ ಸರ್.
Passed over matters.
ಹಾ ಸರ್. ಹಾ ಸರ್. ಹಾ ಸರ್.
Passed over matters. Seal number 2, Shri Rajesh Gowda.
Realist.
17th.
17.
Seal number 25. Shri Vashant Kumar HT.
ಮನೆದಲ್ವಾ?
ಹೌದು ಸರ್. Which has not been communicated to the petitioners.
ತಾಯಿದಾ?
ಅವ್ರು ರೆಗ್ಯುಲರೈಸ್ ಮಾಡಿದ್ವಿ. ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಫೋಟೋಗ್ರಾಫ್ಸ್ ಅದು ಈಗ ರೀಸೆಂಟ್ ಆಗಿ 4 months ಕಟ್ಟಿದ ಮನೆ. ಅದಕ್ಕೆ ವೇರಿಯೇಷನ್ ನೋಡಿ.
But I am producing some following document.
ಫರ್ದರ್ ಡಾಕ್ಯುಮೆಂಟ್ ಅವ್ರ ತಾಯಿಗೆ ರೆಗ್ಯುಲರೈಸ್ ಆದ್ಮೇಲೆ ಗಿಫ್ಟೆಡ್ ಆಗಿದೆ ಪಿಟಿಷನ್. ರೋಡ್ ಮಾರ್ಕ್ ಹಾಕಿಟ್ಟು ರಾಮಕೃಷ್ಣ ಸಣ್ಣ ಬೆಂಗಳೂರಲ್ಲಿ.
He's got the property from his mother.
ಮದರ್ ಗಿಫ್ಟ್ ಆಗಿದೆ. ಏನಾದ್ರು ರೆಗ್ಯುಲರೈಸ್ ಮಾಡಿದ್ವಿ ಅವ್ರ ಮದರ್ಗೆ, ಅದು ಗಿಫ್ಟ್ ಆಗಿದೆ ಪ್ರಾಪರ್ಟಿ. ನೆಕ್ಸ್ಟ್ ಡಾಕ್ಯುಮೆಂಟ್ ಒನ್ ಆಫ್ ಹಿಸ್ ಬ್ರದರ್ ಆಲ್ಸೋ ಗ್ರಾಂಟೆಡ್ ರೆಗ್ಯುಲರೈಸ್ಡ್ ರೆಗ್ಯುಲೈಸ್ ಆಗಿರೋದು ಡಾಕ್ಯುಮೆಂಟ್ ಕೂಡ
ಇದ್ಯಾವ್ದು ಇವ್ರು ಅನೆಕ್ಸರಿ ಹಾಕಿರೋದು ಯಾವ್ದು ಇದು ಮತ್ತೆ? ಅನೆಕ್ಸರಿ ಫೋಟೋಗ್ರಾಫ್.
Sir, F filed by me only, Lord. Last second, his lordship has, directed the council to produce the whether I have misused the application of my mother or not. So annexure F may kindly be seen, my lord.
Have you informed in the writ petition
Yes, my
that you had made an application that was rejected?
It has
Have
not
you-
been coming. Now only I came to know that, Lord, as it has not been communicated, but I kindly appreciate, my lord. Let them direct the.
Have you stated in a petition that the property regulations in the favor of your mother is been gifted to you?
No, my lord, because no. Gifted, my lord, still is in she is in the possession only. It is not, just gifted, my lord.
I'm
But-
going to hold that you are not entailed for regularization because of this misconduct on your part.
No, my lord, because kindly appreciate, my lord. In the year 2015, I made representations, knowingly felt that already my mother has been allotted. So, my lord, no action has been taken. No order has been passed. Now, my lord, he said that in the year 2017, my application has been rejected. If it is not
I
been.
will ignore that for a minute also.
Please, my lord.
But since your mother's property, which was a result of a regularization order, it has been gifted to you, you can't make this application.
No, I have.
This
filed in the-
provision is meant for people who have no other option and build a house,
My lord, in the year.
not for people to have multiple houses in the village. And your brother also has a house.
Kindly appreciate, my lord. In the year 2015, my mother also made representation.
15 ಬಿಟ್ಬಿಡಿ, ನಿಮ್ ತಾಯಿಂದ ನಿಮಗ್ ಬಂದಿತ್ತು ಖಾತಾ ಹೇಳಿದ್ರೆ ನೀವು ರಿಟ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ
ಹೇಳಿಲ್ಲ ಸ್ವಾಮಿ. ಅಲ್ಲ, ನಮ್ಮ ತಾಯಿಗೆ 15ದಲ್ಲಿ ಅವ್ರಿಗೆ ಅಲರ್ಟ್ ಆಯ್ತು. ನಾನು
you decide on the cost.
Please kindly appreciate, my lord. 2015, my mother was allotted. In the same year, I was also applied for regularizing my occupations. So mother subsequently has gifted, but still he is in the possession.
You said so in your petition.
I'm not certain.
How much cost should I impose? You let me know.
Because the party, my lord, is an illiterate, he didn't inform me also, just I
ಏನ್
informed.
ಯಾವ್ದು ಇನ್ಫಾರ್ಮ್ ನಿಮ್ಗೂ ಗೊತ್ತು ನನ್ಗೂ ಗೊತ್ತಿವಲ್ಲ ಅವ್ರು ಎಷ್ಟು ಬುದ್ಧಿವಂತರಿರ್ತಾರೆ ಅಂತ.
ಅಲ್ಲ ಈಗ ಅವರು ಹೇಳಿದ್ಮೇಲೆ ನನ್ಗೆ ಗೊತ್ತಾಯ್ತು, ನಾನು ಕೇಳಿದೆ ಪಾರ್ಟಿನೂ
ನಿಮ್ಗೆ ಕೊಡ್ತಿದ್ದೀನಿ, ನಿಮಗ್ ಕೊಡ್ತಿದ್ದೀನಿ ಆಪ್ಷನ್, ಎಷ್ಟು ಕಾಸ್ಟ್ ಆಗುತ್ತೆ ನೀವೇ ಹೇಳಿ.
ಬರುತ್ತೆ.
ಅವ್ರನ್ನೇನ್ ಕರ್ಸ್ರೆ ಏನ್ ಜಾಸ್ತಿ ಆಗುತ್ತೆ, ನಿಮ್ಗೆ ಬಿಟ್ರೆ ಕಮ್ಮಿ ಆಗುತ್ತೆ.
ಅಲ್ಲ ಅವ್ರಿಗೆ ಗಿಫ್ಟ್ ಮಾಡಿದ್ದಾರೆ, ಬಟ್ ಈಸ್ ನಾಟ್ ಇನ್ ದ ಪೊಸೆಷನ್, ನಾಟ್ ಬಿನ್ ಹ್ಯಾಂಡೆಡ್ ಓವರ್ ಮೈ ಲಾರ್ಡ್ಶಿಪ್.
ಅದು ನಿಮ್ ತಾಯಿ ಮೇಲೆ ಕೇಸ್ ಹಾಕೊಳ್ಳಿ, ಎಷ್ಟು ಕಾಸ್ಟ್ ಆಗ್ಬೇಕು ಹೇಳಿ.
ಇದು ನಮ್ಗೆ ಅವ್ರಿಗೇನು ಗೊತ್ತಿಲ್ಲ. ಸೊ ಹಾಗಾಗಿ ತಾಯಿ ಮಗ ಒಂದೇ ಸಲ ಅಪ್ಲೈ ಮಾಡಿದ್ರೆ, ತಾಯಿಗೆ ಅಲಾಟ್ಮೆಂಟ್ ಮಾಡಿದ್ರೆ ಬಂದು. ಅಂಡ್ ಮೋರ್ ಓವರ್ ಐ ಫೈಲ್ ದಿ
ಇನ್ವೈಟಿಂಗ್ a lot of findings. You are inviting a lot of findings from me. One, your mother got the property that you got it conveyed to your favor. Your brother has got this. Your entire family is doing only this.
ಒಂದು ಫ್ಯಾಮಿಲಿ 5 ಜನಕ್ಕೆ ಕೊಟ್ಟಿದ್ದಾರೆ. ದಟ್ಸ್ ವಾಟ್ ಐ ಫೈಲ್ ದಿ ಅಪ್ಲಿಕೆಂಟ್ ಅಂಡರ್ RTA Act. Kindly direct the department to produce.
ಹೇಳಿ ಬೇರೆಯವ್ರದ್ ಮನೆ ಆಮೇಲೆ ನೋಡೋಣ.
ಅಲ್ಲ ಒಂದೊಂದು ಮನೆಗೆ 5 ಜನಕ್ಕೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ. ನಾನು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೀನಿ, kindly appreciate.
Then 1 lakh cost. But ಅದನ್ನ ನಾನು ತಗೊಳ್ಳಲ್ಲ. It's got nothing to do with this. 1 lakh.
ದಯವಿಟ್ಟು ಪಾರ್ಟಿ ಬಡವರಿದ್ದಾರೆ ಸ್ವಾಮಿ.
ಬಡವರು ಇದ್ರೆ
ಅವರು
ಬಡವರು ಇದ್ರೆ ಈ ತರ ಕೆಲಸ ಮಾಡಬಾರ್ದು. ಇದು ಬಡವರು ಮಾಡೋ ಕೆಲಸ.
ಒಂದೇ ಮನೇಲಿ 5 ಜನಕ್ಕೆ ಕೊಟ್ಟಿದ್ದಾರೆ. ಪ್ರೊಡ್ಯೂಸ್ ದ ಪ್ಲೇಸ್ ದ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅಂತ. ದಟ್ಸ್ ವಾಟ್ ಐ ಫೈಲ್ ದಿ ಅಪ್ಲಿಕೇಶನ್ ಅಂಡರ್ ದ ರೈಟ್ ಟು ಇನ್ಫಾರ್ಮೇಶನ್ ಆಕ್ಟ್. ಬೇರೆಯವರಿಗೆಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ. ಮೋರ್ ಓವರ್ ಮೈ ಲಾರ್ಡ್, ಇವ್ರ ಕೈಲಿ ಅಪ್ಸೆಟ್ ನೋ ಕಂಪ್ಲೇಂಟ್ ಹ್ಯಾಸ್ ಬೀನ್ ಫೈಲ್ಡ್ ಅಗೇನ್ಸ್ಟ್ ಮೀ ಆಲ್ಸೋ.
ಆಮೇಲೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಸಾಕು, ನೀವು ಮೆಕ್ಕಿದಲ್ಲ ಬೇಡ.
ಸೀಕಿಂಗ್ ಅಪ್ಲಾಜಿಂಗ್ ಗಾಡ್ ಬಿಕಾಸ್ ಒಂದೊಂದು ಮನೇಲಿ 5 ಜನಕ್ಕೆ ಕೊಟ್ಟಿರೋದ್ರಿಂದ ಅವರು ಕೂಡ ಅದೇ ತರ ಅಪ್ಲೈ ಮಾಡಿದ್ದಾರೆ. ಐ ವಿಲ್ ಪ್ರೊಡ್ಯೂಸ್ ದ ಆಲ್ ದಿ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೈಲಿ ಗ್ರಾಂಟ್ ವಿತ್ 3 days time. Otherwise the lordship director
it become 2 lakhs. If you say because others have done illegality, therefore I want to perpetuate illegality, it become 2 lakhs.
Select
ಲಕ್ಷಣವಾಗಿ ನಿಮ್ಮಷ್ಟು ನೀವು ಮನೆ ಹೊಡೆದಾಕ್ಬಿಟ್ಟು ಸ್ವಾಧೀನ ಕೊಡ್ತೀನಿ ಸುಮ್ಮನೆ ಇರ್ತೀನಿ. ಇಲ್ಲ, I will invite costs. You will have to demolish the house, report it to this court, then I will permit you to withdraw the writ petition. Or I will dismiss this, permit them to demolish and then impose 1 lakh cost. I'll pass it over. ಕೇಳಿ ತಿಳ್ಕೊಂಡು ನಂಗೆ ಹೇಳಿ.
Number 31.
Annex A, notice my lord, an order of attachment, Jafti Hukum my lord, 16/125 is under challenge. My lord, an award my lord is passed under the Rare Act. My lord, an appeal is preferred. My lord, in fact, the tribunal is not fully constituted. Therefore, we had filed a writ petition also, my lord. This honorable court had protected meanwhile. However, my lord, there is no functioning, my lord, complete functioning of the tribunal for the want of quorum. Meanwhile, my lord, the Jafti Hukum order is issued. My lord, be that, my lord, the appeal, my lord, and the payment is one aspect of the matter. The other aspect of the matter, my lord, when they issue this notice, my lord, what is my lord required to be, my lord, followed is, my lord, a notice of demand under section 162. And then, my lord, upon personal service, and if my lord failed to pay, my lord, it is to be recovered as a land.
Or file objections.
My lord, they have not, my lord, issued me the notice.
Raise objections on this. They'll pass some more.
Let this be construed as a notice.
I will not say anything. If you want any order from me, there'll be a condition to deposit, which you will not do.
Because, my lord, their appeal also contemplate, my lord, deposit, my lord, mandatory deposit, my lord, under the Rare Act.
A deposit ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿ, I'll consider till.
ಅಲ್ಲ, ಅದು appeal ಹಾಕೋವಾಗ ಮಾಡ್ಲೇಬೇಕು.
ನೀವು ಅದನ್ನ ಇಲ್ಲೇ ಮಾಡ್ತೇನೆ, I'll give you.
ಇಲ್ಲ, ಅಲ್ಲಿ ಅದು statutory ಅಲ್ಲಿ ಅವ್ರ ಮುಂದೆನೆ ಮಾಡು. Unless, my lord, they, my lord, satisfied.
We can always transfer it the moment it is reconstituted. You deposit the money, let us see.
But it's, my lord, the legal formality being not followed. That notice of demand, my lord, is a must, my lord, that's not. But kindly take, my lord, the relevant rules.
Your objections ಹಾಕಿ. AG accepts notice for respondents. Objections if any. ಅವರಿದ್ದಾರೆ ಪಾರ್ಟಿ. Gautam take notice for Respond number 4. R5 ಯಾರು?
R4 is
Same respondent, R5 throughout. Issue notice to R5 and R6.
Meanwhile, no precipitative action, my lord.
Any order you want, 50% deposit.
I understand, my lord. That's because, my lord, this honorable court seized the matter, protect us, my lord. What has happened is.
Can protect you, provided you protect the investors also by depositing that money.
My lord, on the other hand,
It's a fiscal demand.
Investors, my lord, have no jurisdiction to agitate their my lord, grievances before the.
Invest, ನೀವು ಕಾಸು ಕೊಡಿ ಅವ್ರಿಗೇನು ಅವ್ರು ಕೊಟ್ಬಿಡಲ್ಲ ನಾನು. ನೀವು ಡೆಪಾಸಿಟ್ ಮಾಡಿ ಆಮೇಲೆ ನೋಡಿ.
My lord, it is an integrated project.
Failure
My
of
lord,
the-
it's not that, my lord.
Seal number 48.
On to 40, my lord, and there is another matter. At 57.
Same order. ಇದು seal number 29 to seal number 31 to 39, ಆಮೇಲೆ 57.
57.
Seal number 48.
Petition.
The PDO has filed an affidavit of undertaking stating that the Kata would be registered as per the order passed by this court within 15 days. Same is taken on record, relist on. ಯಾವ್ದು ಬೇಕು? You will report it on that day. 15 days on a date.
25th.
Advise him not to be too smart.
25th.
Much obliged. Seal number 52.
Lord, this is the document, my lord, where your lordship on Friday, Lord, directed to show at least what document you have to, Lord, to establish that the petitioner husband not having this. Lord, here, Lord, what happened, Lord, the survey number 388, my lord, was, my lord, the ancestral property of the husband of the, my lord, petitioner. My lord, this fourth respondent, Lord, the name of the, my lord, the petitioner husband is also Lingaya, son of, my lord, Siddhaya. Lord, the grandfather name of the, my lord, fourth.
ನಿಮ್ಮ ಯಜಮಾನ್ ಹೆಸರಲ್ಲಿ ತೋರಿಸಿ.
Please, Lord, kindly see ILR, Lord, this original, the copy has also been made. Lord, this is a patta receipt, my lord, which has been issued in the name of the, my lord, husband of the, my lord. First, my lord, patta receipt.
MR ಕೊಡಿ ಇದೆಲ್ಲ ಬೇಡ.
MR ಅಲ್ಲಿ, my lord. What did, my lord, kindly, IL is there, earlier to IL,
How was your husband's name entered? I need the MR.
not through IL, my lord.
IL ಬೇಡ, MR ಇದ್ದೇ ಇರುತ್ತೆ.
MR fell, my lord, that is what now they are given an endorsement that is not available. Copies which RTL ಅಲ್ಲಿ have produced 1912-23 ಅಲ್ಲಿ have sought in the RTA that IHC, my lord, has been entered. Kindly see, this is the, my lord, one more IHC number, it is mentioned in the, my lord,
ಇಲ್ಲ,
RTC.
ಈ ರಿಮಾರ್ಕ್ಸ್ ಓದಿ IL ಅಲ್ಲಿ MR 9/3940 PM
Not Siddhaya bin, in RTC it is there. Siddhaya bin Lingaya it is there. RTC, in RTC. And IHC, my lord, right and side, Pitajita. Lord, RTC is there, one more RTC which has been produced there, along with that, RTC.
RTC I need to know on what basis.
Lord, true, that is on the basis of the, it is a Pitajita.
Look at the documents, I'll have it next week. Relist.
17th. Seal number 57. Seal number 71.
Petitioner in this case, my lord. Sorry, my lord, I could not be present in the morning.
2012 matter ನನ್ನ
ಹೌದು ಸ್ವಾಮಿ.
ಲಾಸ್ಟ್ ಟೈಮ್ ಆಸ್ ಎ ಲಾಸ್ಟ್ ಚಾನ್ಸ್ ಅಂತ ಕೊಟ್ಟಿದ್ದೀನಿ.
ಹೌದು, ಅದು there were several directions issued by this honorable court earlier also.
What is the matter about?
ಇದು ತಿಪ್ಪಗೊಂಡನಹಳ್ಳಿ ಕೆರೆಗೆ ನಮ್ಮ ಜಮೀನು ಇಡೀ ಊರೇ ಮುಳುಗಡೆ ಆಗಿದೆ. ನನಗೆ ಕಾಂಪನ್ಸೇಷನ್ ನನಗೆ ದೇರ್ ವಾಸ್ ಎ ಸ್ಕೀಮ್, ರಿಹಬಿಲಿಟೇಷನ್ ಸ್ಕೀಮ್ ಪ್ರಕಾರ 1:1 ಕೊಡ್ತೀವಿ ಅಂತ ಸ್ಕೀಮ್ ಇದೆ. ಅದರ ಪ್ರಕಾರ ಬೇರೆಯವರಿಗೆಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ, ನನಗೆ ಇನ್ನೂವರೆಗೂ ಕೊಟ್ಟಿಲ್ಲ. This court has taken astonished with the facts that for 4 decades, Assistant Commissioner has filed the affidavit, and thereafter the court felt that Deputy Commissioner has to file the affidavit, not the Assistant Commissioner. Under the order dated 2/9/2022, specifically pointing out various things, my lord, in that order. ಮೇಡಮ್, ಸ್ಕ್ವೇರ್ ಆಗಿದ್ದಕ್ಕೆ ಏನು ಇಲ್ಲ ಅಂತ ಹೇಳಿಲ್ಲ. ಅಲ್ಲಿ ಹೇಳಿರೋದೇನು ಹಂಗೆ ಹೇಳಿಲ್ಲ, ಅಫಿಡವಿಟ್ ಅಲ್ಲಿ ಆ ಥರ ಹೇಳಿಲ್ಲ. ಬೇರೆ ಒಂದು 3-4 ಜನ ಕೊಟ್ಟಿದ್ದಾರೆ, ಅದು ನಮ್ಮ ಫ್ಯಾಮಿಲಿ.
What is there to show that your lands were lost?
ಇಲ್ಲ, whole of the village submerged. And I have produced the notification also. May I just take your lordship through my affidavit that is dated. In that I have specifically mentioned about the lands that have been lost in the notification, reference of the notification, everything.
Please read para. These are the very same surnames referred to in the order
Yes, my lord.
in the affidavit of the
Yes,
Assistant
my lord.
Commissioner.
Yes, my lord. These are the lands. In fact, it is my other.
No, but
What-
you are claiming
Yes, my
that
lord.
you are the owner of the lands mentioned in para 2 of your affidavit.
Yes, my lord.
Assistant Commissioner says in para 3 of his affidavit that these very lands were the lands of one Venkatramanappa. And his family members have already been granted alternative land.
Venkatramanappa is my forefather. Venkatramanappa is my forefather. There was a partition in 1968 itself. Others have separated. From 96, I have produced all the sale deeds, everything I have produced in respect to the very same properties. There are court decrees also. Even earlier also, the LAC court has also, there was a dispute with regard to my ownership also. There are separate claims made by the third parties. For that, in the LAC court has held that I am the owner of these properties. But I have produced all those.
The total extent of family property that you own?
My total extent, my lord, my family owned more than 70-80 acres. In that, my lord, in 1968 partition, my lord, myself, my family owned about 25 lakhs, 27 acres of land and also house sites and buildings. In fact, thereafter, my sisters, everybody has executed release deeds. The registered release deed also I have produced before the Supreme Court. All those things have been taken into consideration by the court. Even there was a partition suit also pending. It was decided in 1981 itself, wherein these properties have been allotted to me. The other family allotted some other properties. Even that copy decrease, everything I have produced before the Supreme Court.
You are claiming that
I am not claiming any other land which has been allotted to any other person of my separated family. Way back in the year 1945 separated. 68 separated, 68 other documents, other properties. I in my affidavit, sorry. Madam, if you have not seen it.
that he is referring to a partition suit prior to that, 81.
Yes.
You must be aware as to who was the owner of this particular property as on the 81, isn't it? No, Assistant Commissioner order never talks about,
This was considered, my lord, that is thereafter only, my lord, the order dated 2/9/2022 has been passed by the Sama Court, my lord, wherein court has said may I just read the order, my lord.
I have passed some order of this.
Yes, my lord. Your lordship also directed them to file the affidavit. They have taken any number of time before this, before your lordship also.
DC ಹಾಕಿಲ್ಲ ಮಾಡೋಣ affidavit.
ಇಲ್ಲ ಹಾಕ್ಲಿಲ್ಲ. I think I would sit with my learned friend herself and give her all details so that she will be in a position to tell the revenue officials and to. ಆಗಿದ್ದೀರಿ.
2922 order ನೋಡಿದಿರಾ?
Take that order.
ದಯವಿಟ್ಟು ನೋಡಿ 2922 there is a detailed order passed as to what you should do. 2922 and there's one more order passed.
5/7/2022 is made clear that if the affidavit is not filed by that time, both the deputy
And,
commissioner and
7324.
special will be.
And 7324. Relist.
Number 72.
Sorry, my lords, did not appear in the morning session. This matter had come up on earlier occasion, my lords. It was heard for some time. This case pertains to 9A of Inam Abolition Act, tenant under 9A.
You are the tenant under 9A.
Please, my lord, there was a subsequent sale in the year 1968. Your
Must
lordship-
write a fact, sir.
Please, my lords.
For changing annexure A alva?
Annexure A. That is
The-
form number 7, my lord. Rejection of form number 7 filed by the petitioner.
You said there's an order of the
Out of
DC,
the
continuing
DC.
there as a tenant.
Please, my lord. 19. That is annexure B. 1963, my lords, the Inam Deputy Commissioner has ordered that I may be continued as an ordinary tenant under section 9A. my lord.
Which is that order permitting you to continue as tenant?
Annexure B, my lord.
Annexure E.
B, my lords. Page 22, my lords. Page 22.
second portion, my lord. The petitioner claims to be cultivating the above two survey numbers since ancestral times on payment of Kandayam, but no receipts are.
Hello, the page 14.
Please,
Are you reading annexure?
pardon, my lord.
Hello, Tidra, annexure?
Annexure, page 22, annexure B, my lord, the second part, the last paragraph. Because with respect to survey number 17 and 18, Kelgade, page 22, annexure B, my lord. Now the disputed survey number is 17, my lords. In respect of 17, the petitioner claims to be cultivating the above two survey numbers since ancestral times on payment of Kandayam, but no receipts or other evidence, either documentary or oral, is produced. Jodidar denies the claim and says that he has given these for Vara cultivation only since 2 years. In addition, the Jodidar has claimed these lands as his Casa land in case number so and so, wherein the claim of the Jodidar has been upheld. As there is no documentary evidence and as the Jodidar denies the claim of Kandayam cultivation, and also in view of the fact that Jodidar admits that the land has been given for Vara since 2 years, the petitioner is treated as ordinary Vara tenant under section 9A of the Act.
How does the land tribunal consider this order?
Lords, subsequently, my lord, this order has been set aside, confirming the right in favor of the purchaser who has purchased the property in the year 1968, my lord. This order has been not considered by the land tribunal, my lords, though there is reference to this order, my lord.
Where is this order that is set aside?
My lords, at annexure G, my lords, which has been produced subsequently by way of amendment. Annexure G, my lord. Which is without notice to the petitioner, my lords.
In somebody's proceedings without you being a party. Athane?
Please, my lord. I have been made as a party, but no notice has been issued. There is no reference as to issuing notice calling for objection from petitioner.
Annexure G.
Annexure G, my lord, by way of amendment has been. It appears it is in amendment application. This time, my lordship. Subject occupancy rights in respect of Jodi Chakpura village, Narsapura Obli, Kolar Taluk.
ನಿಮ್ಮ ಹೆಸರು ವೆಂಕಟಸ್ವಾಮಪ್ಪನಾ?
Please. My father name. Chokkappa is the rival contesting respondents.
ಇವರು ಇದ್ರ ಲ್ಯಾಂಡ್ ಲಾರ್ಡ್ ಪಾರ್ಟಿ ಮಾಡಿದ್ರ ಚೊಕ್ಕಪ್ಪ?
Pardon, my lords? Chokkappa, this is the one filed by the Chokkappa, my lords. As on the date of 1963, my lords, Inam DC order, Sampangi Ramaya was the Jodidar, my lords. There was no sale transaction as on that day. It was only in the year 1968, my lords. But in this case, it has been wrongly mentioned as 73, my lords, year. It was 63, my lords.
Who appears for this Chokkappa in this case?
Chokkappa, Rashid Ahmad, Rashid Khan. The lordship asked me to produce a sale deed, typed copy of sale deed on last occasion. The sale transaction that has been taken place is called 1968 sale.
Typed copy ಇದೆಯಾ?
Typed copy ಹಾಕಿದ್ದೀನಿ sir. Page.
ಸ್ವಾಧೀನ ಬಗ್ಗೆ ಏನು ಒಪ್ಕೊಳ್ಳಲ್ವ? ನಿಮ್ ಸ್ವಾಧೀನ ಒಪ್ಕೊಳ್ಳಲ್ಲ ಅಲ್ಲ?
ಇಲ್ಲ ಇಲ್ಲ, ಅದ್ರಲ್ಲೇನು there is no reference. And the
ಮೇಡಮ್
impugned,
ಇದ್ರಲ್ಲಿ ನೋಟಿಸ್ ಆಗಿತ್ತಾ? ನೆಕ್ಸ್ಟ್ ಜಿ ಎಲ್ಲಿದೆ ನೋಟಿಸ್ ಹೋಗಿರೋದು?
there is
Sir,
no
G, there's no indication that notice.
annexure G. There is no reference in the order, annexure G, my lords.
Prior to?
Annexure GL, there is no reference that notice has been issued. And also the address shown is something else different, my lords. In annexure G. Matnalli anta ತೋರಿಸ್ತಾರೆ. Matnalli is the village of Jodidar. I reside in Chakpura village.
How can the special DC cancel the order?
His
passed
own
earlier?
order, my lords. Sitting over his own order, this order has been passed.
Now both the cases will be decided with the land tribunal only. But so long as that order of his is not challenged. The first order permitting him to continue as a tenant, that is not challenged. And how can there be a different order? What does the land tribunal say in your?
Lord, land tribunal says that, my lords, as page 21 is the finding, my lords. Last para. ಉಪವಿಭಾಗೀಯ ಅಧಿಕಾರಿಗಳು ಕೋಲಾರ ಉಪವಿಭಾಗ ಅವರ ಆದೇಶ ಕ್ರಮಾಂಕ CMC 11/1976-77 ದಿನಾಂಕ 2/1/1984ರಲ್ಲಿ ನೀಡಿರುವ ನಿರ್ಣಯದಲ್ಲಿ ವಿವಾದಿತ ಜಮೀನ ಸ್ವಾಧೀನಾನುಭವವು ಎರಡನೇ ಎದುರುದಾರರಾದ ಚೊಕ್ಕಪ್ಪ ಬಿನ್ ನಾಚಪ್ಪರವರೆಗೆ ಇರುತ್ತದೆ. ಆದುದರಿಂದ ಚೊಕ್ಕಪುರ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 5ರಲ್ಲಿ ಭೂ ಸುಧಾರಣಾ ಅಧಿನಿಯಮ ಜಾರಿಗೆ ಬಂದ ದಿನಾಂಕ 1/3/74 ಅಥವಾ ಅದಕ್ಕೆ ಮುಂಚೆ ಆಗಲಿ ನಂತರವಾಗಲಿ ಅರ್ಜಿದಾರರಿಗೆ ಸ್ವಾಧೀನಾನುಭವ ಇಲ್ಲದಿರುವುದರಿಂದ ಸದರಿಯವರಿಗೆ ಗೇಣಿ ಅರ್ಜಿ ಪರಿಗಣಿಸಲು ಬರುವುದಿಲ್ಲ. This CMC order which has been referred as 1976-77, my lords, this has been challenged by the petitioner in criminal revision petition, and in that criminal revision petition, my lord, the district judge has ordered that land shall be with the possession of the Tahsildar as a receiver.
Even now it is in the possession of the Tahsildar.
But that order is says that is the final order, my lords, in criminal revision petition.
ಮಾಡಕ್ಕಾಗಲ್ಲ. DC can't not have passed this order in 76. ರೆಕಾರ್ಡ್ ಪ್ಲಸ್ ನೋಡ್ತೀರಾ ನಿಮ್ಸಲ? Annexure B ಅಲ್ವಾ ನಿಮ್ ಪರ ಆರ್ಡರ್?
Please, my lords, annexure B. Annexure B. The other one is annexure G.
ಪಾರ್ಟಿ ಮಾಡಿದ್ರೆ ಅದರಲ್ಲಿ
ಇದಾರೆ legal heirs is dead. 4 and 5.
I'll have day after tomorrow, madam. Agata?
I'll just serve it now. Give one more copy.
Number 76, BM Siddhappa.
Please. Challenge ಮಾಡಿದ್ರ? Which is the order that you challenged? 136, huh? 136 ಅಲ್ಲ ಇದು. ಇಲ್ಲಿ ಇದರಲ್ಲಿ ಏನಾಗಿದೆ, ಸರ್ವೆ ನಂಬರ್ಗಳು ಕೊಟ್ಟು ಎಲ್ಲ ಆದ ಗ್ರಾಂಟ್ ಎಲ್ಲ ಆಗಿದ ಮೇಲೆ ಅವ್ರು ಸಿವಿಲ್ ಕೋರ್ಟ್ನಾಗೆಲ್ಲ ಅದೆಲ್ಲ ಕನ್ಫರ್ಮ್ ಆಗಿ RSA ಅವರಿಗೂ ಕನ್ಫರ್ಮ್ ಆದ್ಮೇಲೆ AC ಕೋರ್ಟು ಹೋಗಿದ್ದಾರೆ. AC ಕೋರ್ಟ್ನಾಗ ಅದೆಲ್ಲ ಸೆಟ್ ಅಸೈಡ್ ಮಾಡಿ ಇದು ಮಾಡಿ ಅದ್ರ ಮೇಲೆ ಅದೆಲ್ಲ DC ಗಮನಕ್ಕೆ ತಂದ್ರು ಸರ್, DCನೂ ಅದನ್ನ ಕನ್ಫರ್ಮ್ ಮಾಡಿ. AC ಆರ್ಡರ್ ಇದೆ. Next scene. OS my lord, your lordship, in this very with regard same property. AC order ಯಾವುದು? AC order Annexure C, page 49. Typed copy 54. ಅವರೇ ಸಿವಿಲ್ ಕೋರ್ಟ್ಗೆ ನಮ್ದು ತಹಸೀಲ್ದಾರ್ ಆರ್ಡರ್ ಯಾವುದು? ತಿದ್ದುಪಡಿ ನಂಬರ್ 7 ದಿನಾಂಕ 21/6/2005. ಅದ್ರ ಮೇಲೆ ಅಪೀಲ್ ಹಾಕಿದಲ್ವಾ AC-ಗೆ? ಅದ್ರ ಮೇಲೆ ಅಪೀಲ್ ಹಾಕಿದ್ರು. Where is that order? 21/6/2005. ಅದೇ ಅದು ಈ ನಂಬರ್ ಏನ್ ತಹಸೀಲ್ದಾರ್ ಕೊಟ್ಟಿದ್ರಲ್ಲ ಆ ನಂಬರ್ ಬೇಸಿಸ್ ಮೇಲೆ ದೇ ಫೈಲ್ ದಿ ಸೂಟ್ OS. ಅಲ್ಲ ಆರ್ಡರ್ ಏನು? ವಾಟ್ ಇಸ್ ದಿ ಆರ್ಡರ್? 21/6/2005. ವಾಟ್ ವಾಸ್ ದಿ ಆರ್ಡರ್? ಪ್ಲೀಸ್ ಪೇಜ್ 54 ಬನ್ನಿ. ಪೇಜ್ 54 para 1 ಪ್ರಸ್ತಾವನೆ. ತಹಸೀಲ್ದಾರ ಚಳ್ಳಕೆರೆ ತಾಲೂಕು ಹೋಬಳಿ ಓಬಣ್ಣನಹಳ್ಳಿ ಕಾವಲ್ ಸರ್ವೆ ನಂಬರ್ 124, 25, 26 ಮತ್ತು 127 ಜಮೀನುಗಳನ್ನು ಅದಲು ಬದಲು ಮಾಡಿ ತಹಸೀಲ್ದಾರ್ ಚಳ್ಳಕೆರೆ ಅವರು ಕೇಸು ಫೈಲ್ ಮಾಡಿದ OS ಫೈಲ್ ಮಾಡಿದ ನಂತರ ಅಲ್ಲಿ ಹೋಗಿದ್ದಾರೆ. ವಾಟ್ ಇಸ್ ದಿಸ್? ಆದೇಶ ವಿರುದ್ಧ ದಿನಾಂಕ 21/6/2005 ವಿರುದ್ಧ ಅಪೀಲನ್ನು ಸಲ್ಲಿಸಿದ್ದಾರೆ. ವಾಟ್ ಇಸ್ ದಿಸ್ ಆರ್ಡರ್? This order is my lord, originally OS that is 89 and all old numbers are there. He has given new numbers to the survey numbers. So those are on that basis, after assigning the new number, the respondent number 4 approached the civil court, that is the owner of the survey number 125. After recording the finding, after adducing the evidence, the trial court dismissed it, failed to prove it. Against RA was filed. RA also dismissed. This is and second appeal also filed, second appeal also dismissed. Thereafterwards, these orders have to be came to pass. Even you brought to the notice of the deputy commissioner, up to the finding has been confirmed by the Honorable High Court. So the civil revenue courts have no jurisdiction in this regard. When the High Court says that 125 belongs to the defendant, now they cannot go. Where is the finding that it belongs to you by the trial court? Your lordship, your Honorable High Court, your lordship. Your lordship, Annexure, my lord, B, page 42. The Sambal Court judgment. This is the appeal filed by the respondents here. ನೀ ಪಾರ್ಟಿ ಇದ್ರೆ ಇದ್ರಲ್ಲಿ? ನೀ ಪಾರ್ಟಿ ಇದ್ರೆ ಇದ್ರಲ್ಲಿ RSA ಅಲ್ಲಿ? ಯಾರು ನಾವಿದೀವಲ್ಲ? ಯಾರ ಬರೀ ಸುರಮ್ಮ ಸುರೇಶ್ ಅಂತ ಕರಿಬಸಪ್ಪ ಸತ್ತೋಗಿದ್ದಾರೆ ಎಲ್ಲ. ನೀವ್ ಯಾರ ಕಡೆ ಕ್ಲೇಮ್ ಮಾಡ್ತಿರೋದು? ಅಲ್ಲ ನೀವ್ ಯಾರ ಕಡೆ ಕ್ಲೇಮ್ ಮಾಡ್ತಿರೋದು? ಕರಿಬಸವೇನ್ ಕೇಳೋಣ. ಕರಿಬಸ. ಇದರಲ್ಲಿ ಕರಿಬಸಿ ಇಬ್ಬರೇ ಮಕ್ಕಳು, ಬಸವರಾಜ ಅಂಡ್ ಪ್ರಕಾಶ್ ಮೂರ್ತಿ. That is petitioner number 2 and petitioner number 5. ಅವ್ರು
ಹೌದು.
ಮಾತ್ರ ಹಾಕಿ.
ಆಮೇಲೆ ಸೂರಮ್ಮ ಅಂಡ್ ಸುರೇಶ ಮಲಾಡ್ ಅವ್ರದ್ದು. ಸೊ plaintiffs in OS number
Suit for injunction ತಾನೆ.
suit for injunction. There it is incidentally this question arises.
ಎಲ್ಲಿದೆ ಫೈಂಡಿಂಗು? That
Ma'am.
you are the owner or Karibasway is the owner ಅಂತ.
Yes, please. Para 7 of the Dissamapur finding. Having heard both the sides, so for suit land concerned, it is mentioned that for section survey number 125 measuring 9 acre 20 guntas land. However, the documents produced by defendants indicated that the defendants were granted land 9 acre 32 guntas in survey number 18 and later changed to 125 days. The plaintiffs did not dispute this fact that the course of cross-examination, DW1 Exhibit P11 grant certificate, no mention is made to the plaintiffs having been survey number 9 acre 32 guntas was landed. Thus, the oral and documentary evidence placed before the court below to the view that plaintiffs had that the established the suit land was granted to them.
How do you get over this finding? The finding is that you are not granted, you are not established the grant.
Suit land was granted to them, but the extent is not mentioned in the grant certificate. Particular in survey number 89, it allotted more than 20 to 30%. But extent is not mentioned in the grant order. Initially, 125 is in my name and 127 is in the name of the petitioner. Later on, Tahsildar, without issuing the notice to all the grantees, the interchange is survey number. That question.
Where is that order?
Tahsildar order they are not produced. But later development has made national authorities have acquired the land and produced the document. In the Kadadar column, for survey number 125, my name is shown. For survey number 127, the petitioner's name is shown, India 2004 itself. They are not questioned they are not raised any objection for the acquisition of land. In my statement of objection last week,
So-
the appointment is issued to me in my favor.
No, but how do you justify the entry of Kata in your name? If-
Confession of the grant.
The,
They are not also disputing that in the
No.
petition also they are
The-
not disputing that I
in-
am granted any land.
in second appeal, the finding is that you have not established the grant.
Not established the grant of 9 acre 32 guntas.
Now, where is it that you've established grant of a lower extent?
This is a case that the case of the petitioner I have granted only 6 acres. They are granted 9 acre 32 guntas each in survey number 89 A and B.
Shashidhar, unless there's a finding that you have been granted a land.
The DC is recorded the finding. I am granted the
But
land.
what about the civil court's finding that no grant is exist?
But the extent I am not to prove. I am in question of 9 acre 32 guntas. That is the finding of the civil.
ಅದು ಹೆಂಗಿದ್ರು ಸೂಟ್ ಫಾರ್ ಇಂಜಂಕ್ಷನ್ ತಾನೇ ಅದು.
Sorry, only injection.
ಇನ್ನೊಂದು ದಾವಾಗ ಎಸ್ಟಾಬ್ಲಿಷ್ ಮಾಡಿ ಗ್ರಾಂಟ್ ಎಷ್ಟಾಗಿತ್ತು ಅಂತ.
KDC, the assistant commissioner, why the assistant commissioner remanded the case only to the Tahsildar? No, not entire order is not set aside.
Where is the order? ಎಲ್ಲಿದೆ ಆರ್ಡರ್?
Assistant commissioner order foreign movement, page number
Typed copy is at page 54.
58 and typed copy. Page number
59.
58. Third pair, ಅವರೇ ಕೊಟ್ಟಿದ್ದಾರೆ ಸಾಗವಾಣಿ ಚೀಟಿ ಅವರಿಗೆ 9 ಎಕರೆ 30 ಗುಂಟೆ ಅಷ್ಟೇ
Page 58.
58 typed copy third pair
ತಹಸೀಲ್ದಾರ್ ಗ್ರಾಮ ಲೆಕ್ಕಾಧಿಕಾರಿ.
ಪ್ರತಿಷ್ಠಿತ ವೀಕ್ಷಕರು ಮತ್ತು ತಾಲೂಕು ಸರ್ವೇಯರವರು ಎದುರುದಾರರ ಅನುಕೂಲ ಉಂಟು ಮಾಡುವ ಉದ್ದೇಶದಿಂದ ಈ ಹಿಂದಿನ ಯಾವುದೇ ದಾಖಲೆಯನ್ನು ಪರಿಶೀಲಿಸದೆ ಈ ಆದೇಶ ಹೊರಡಿಸುವುದು ಈ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಮನದಟ್ಟಾಗಿರುತ್ತದೆ. ಎದುರುದಾರರು ಸಲ್ಲಿಸಿರುವ ಸಾಗುವಳಿ ಚೀಟಿಯಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 89/13ರಲ್ಲಿ 9 ಎಕರೆ 32 ಎಕರೆ ಜಮೀನು ಮಂಜೂರಾಗಿದ್ದು ಇದು ದುರಸ್ತು ಸರ್ವೆ ನಂಬರ್ 119 ಆಗಿರುವುದು ದುರಸ್ತಿಯಲ್ಲಿ ಕಂಡು ಬಂದಿರುವುದರಿಂದ ಎದುರುದಾರರ ಕರ್ಬಶೆ ಇವರು ಜಮೀನನ್ನು ಸಾಗು ಮಾಡುತ್ತಿದ್ದಾರೆ. ಅವರಿಗೆ ಬೋರ್ಡ್ ಮಾಡಿಕೊಡಲು ಸಹಾಯಕ ನಿರ್ದೇಶಕರು ಹಾಗೂ ತಹಸೀಲ್ದಾರ್ ಚಳಕರಿಗೆ ನಿರ್ದೇಶಕರು ಸೂಕ್ತ ಕ್ರಮ ಆಗಿದೆ. They are owner of 9 acre 30. I am not also disputing that they are granted 9 acre 32 gunta land. This case is that they are granted in 19 acres and odd.
My objection, can you produce the RTC extract?
What does the DC say?
Confirm the order of question.
Internal page 4. ಎಲ್ಲಿ ಓದ್ತಿದ್ರ? ಅಪೀಲ್ದಾರರು ಸರ್ವೆ ನಂಬರ್. And there's nothing wrong with this order. Nothing wrong with this order.
Then your lordship kindly see the trial court order. Para 11, all the things AC order has been considered.
No, the Tahsildar, on what basis did he pass this order?
Huh?
How did he change the survey numbers and the extent? What is this?
On the basis of the changed survey numbers, they approached the trial court.
Forget about that.
Huh.
On what basis did Tahsildar?
The
do that?
basis is that sir, already grant certificates are there in the favor of the
So-
dependents as well as the plaintiff.
So tomorrow the Tahsildar can pass one more order, reducing the extent according to you.
No, extent and change agilla.
Revenue entries are once changed. On what basis does he change the entry and interchange the survey numbers or increase or decrease the extent?
That is incorrect, my lord. Your lordship kindly see, therefore,
What was done?
civil court finding.
I will not come to civil court for a minute. Tahsildar order was changing the survey number and changing the extent. On what basis did he do that?
Changing, no change of extent, that is incorrect of the AC order. That is incorrect. There is no changing.
Show me the order of the Tahsildar there.
Okay, kindly see the matter.
Show me the order of the Tahsildar, 21/9/2005. That is the original order, isn't it?
Huh?
That is the original order, 21/9/2005.
That is the order they have challenged.
Please show me the order.
That I don't have a copy. my lord.
ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ madam? Petitioner to produce the order of the Tahsildar dated 21/6/2005, referred to in the order of the Assistant Commissioner. The list. Show me that order. I will-
My son, sir, 125 mala standing in the name of the respondent.
I don't even know what is the original order against which the appeal was filed and the revision was filed. Shashidhar ಹೇಳಿದ್ರಂತ ಬರ್ಕೊಂಬಿಡ್ಲಾ?
24. Serial number 77. P. N. Harish.
My lord. That I was held up in court call number 10. Yes. That the order of the father of the petitioner's when Chandra Nayaka was a tenant. The land in question was a Patel Umli land. So he filed a declaration before the land tribunal in the year 1974. The tribunal in the year 1976 says that since the land is a Patel Umli land, it has not been regranted to the village officer. It has no jurisdiction to consider the application and an application order to be filed. That is what the order has been said. Then Millard, because he was ignorant, he initiated proceedings under section 7A and sought for confirmation of occupancy rights from the assistant commissioner. Then he came to know that the land has been regranted in the year 1993 in favor of the village officer because the landlord has.
In whose favor?
In the favor of the landlord. Because Patel Umri lands, it has been regranted and it has been held that since the land is regranted, I am entitled for conferment of occupancy rights. Well, that we came to know when in the 7A proceedings that has been filed before the assistant commissioner. Because there the landlord appeared and filed a statement saying that it has been regranted to him. Then we made an effort and we came to know that land is regranted in the 1993 itself. So I made an application to the land tribunal requesting it to reconsider its decision since the land is already regranted, confer the occupancy rights in my favor. Well, in the similarly placed person who is the next cultivator to me, and cultivating the same survey number next to me, he has also made the same request and the land tribunal confers the occupancy rights to him to a separate order and rejects my application saying that I have not produced any document before it to show that I am a tenant. The fact remains that from the year 1964, my name, the father of the petitioner name is shown as a tenant, Chandra Nayaka. I produced annexure A and B, Millard, the revenue records that clearly indicate.
He has failed to? ಎಲ್ಲಿದೆ ನೆಕ್ಸ್ಟ್ ರೆಫರ್ಲಿ ಎಲ್ಲಿ ಓದ್ತಿದ್ರ ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ರ
ಹಾಜರಾಗಿದೆ engaged counsel.
Page 29 is the reasoning, huh?
Please.
ಹುಣಸೋಡು ಗ್ರಾಮದ
Last paragraph is the reasoning. That is the order portion.
ಶ್ರೀಶ್ವರಪ್ಪ 93 regret ಆಗಿರೋದಾ?
ಹೌದು, 93 regrant. There is no dispute regard. Being on the land tribunal also accepts it. It has been regranted.
Where is your first order rejecting? 76.
That annexure A, my lord.
You're challenging that order also, no?
Yes, I have challenged that order also. Lord, the order is a typed copy of page number 26. Case called applicant is present, the respondent is absent. This is a Patel Umli land and is not yet regranted. The tribunal has no jurisdiction to grant the occupancy right of law. Hence, the application has to be filed. Announcement in the open court. Both the orders have challenged. Annexure, Millard, kindly annexure A and B, Millard, the revenue records.
Village of Abolition Court. Anyhow, he's not been given a chance, isn't it? I'll send it back. ಇದು 2011 ಆರ್ಡರ್ ಅವ್ನು ಕೇಳಿಲ್ವ? When did you make the second application? This was rejected in annexure,
Lord, I made an application for reconsideration of the order subsequent to the regrant. When I came to know that land is regranted. That order is passed in their, my lord, that is on 2016. I'm sorry, 2000.
who was opposing you?
He remained, served and remained on the president.
Anyone? The petitioner filed an application in form number 7, seeking for grant of occupancy rights. The said application was rejected by an order dated 16/11/76 in the following terms, page 26. It is obvious from the said order that the tribunal had rejected the claim on the ground that it had no jurisdiction, as the land in question was a particular land coming within the purview of the Karnataka Village Office Abolition Act. Subsequently, it appears that on 17/11/1993, the land was regranted under the provision of the Village Office Abolition Act, and the petitioner, on coming to know of this fact, made an application to the tribunal requesting it to reconsider its earlier order, since it was clear that the land was now belonging to the respondent therein. This order, the land tribunal has rejected this application on the ground that there was no document produced to indicate that the father of the petitioner was in possession as on 1/3/1974. Land counsel for the petitioner points out that right from 1916,
64.
The name of the petitioner's father was entered in the revenue records, and as far as the relevant date is concerned also, the name of the petitioner's father was entered in the revenue records. The RTCs which are produced at annexure B also indicate that for the year 73-74, the entry was made in favor of the petitioner's father.
Father, Chandra antide.
ಎಲ್ಲಿದೆ ಅದು?
Second name, Sevya Naika ಕೆಳಗಡೆ ಇದೆ.
ಈಶ್ವರಪ್ಪ ಗೌಡ, ಮಲ್ಲಪ್ಪ ಗೌಡ ಅಂತ ಇದೆ.
ಕೆಳಗಡೆ ಇದೆ. Third name. Sevya Naika, next to Sevya Naika.
ಆ page ಹೇಳಿ.
Pardon?
Page ಯಾವ annexure?
Page 19 ತಾವು ನೋಡು, original RTC. Typed copy next page ಅಲ್ಲಿ ಇದೆ.
ಈಶ್ವರಪ್ಪ ಗೌಡ್ರು,
Sevya Naika and Bhu Chandra. 60.
ಇಲ್ಲದ ಮೂರು ಹೆಸರು ಈಶ್ವರಪ್ಪ ಗೌಡ, ಮಲ್ಲಪ್ಪ ಗೌಡ, ಬಸಪ್ಪ.
Page number 19 ಮಿಲಾರ್ annexure B. ಮೂರನೇ ಹೆಸರು ಚಂದ್ರು ಅಂತ ಇದೆ. ಚಂದ್ರ ಅಂತ ಬರೆದಿದ್ದಾರೆ.
ಇಲ್ಲ 73-74 ಇದೆ ಚಂದ್ರ ಅಂತ.
ಅದೇ 69-70 ಇದೆ.
ಇಲ್ಲ 73-74 ಇಲ್ಲ ಹಂಗಾರೆ. 73-74. ಈಶ್ವರಪ್ಪ ಗೌಡ್ರು, ಮಲ್ಲಪ್ಪ ಗೌಡ್ರು.
ಅವಾಗಿಲ್ಲ. 69, 70, 71 ತನಕ ಇದೆ. 72 ಇಂದ ಇಲ್ಲ. 64 ಅಲ್ಲೇ ಹೆಸರು ಕರೆಕ್ಟ್ ಆಗಿ ಬರೆದಿದ್ದಾರೆ. The type of cultivation, annexure, Milord, page number 17.
71, 72, 72, 73, 74 ಇಲ್ಲ ನಿಮ್ಮ ಹೆಸರು.
Illidu Milord, he has been continued as a tenant. Still now he is in possession of the land. Because 1964 I have been tenant. It is nobody's case that I have been disposed of subsequently. The revenue records have not been.
As on the relevant date, your name is not there.
Yes, it is not there. But 1964 in the entry shows that he is a tenant.
The name of the
And the
petitioner's
landlord
father
has
was-
not said anything yet that I have been disposed of.
And as of 1970-71, and the RTC entry for the year 70-71 also stands in his name. The perusal of annexure B, the RTC also indicates that for the year 69-70 and 70-71, the name of the petitioner's father has been entered in column number 12, and the type of cultivation is shown as tenanted. In my view, in the light of
Milord,
this
also
material,
Milord, annexure G, Milord.
the land tribunal could not have come to the conclusion that there was no document to indicate that the father of the petitioner was not in possession.
Annexure G may kindly be seen.
The impugned orders are quashed, and the tribunal is directed to consider the application, keeping in mind the revenue entries as on 1374 and the years prior thereto, and determine whether the father of the petitioner was the tenant of the land in question. Petition accordingly allowed.
Please.
Number 80.
The petitioner's father was by name Giritimaya. He was cultivating the lands in question.
What is the order that you're challenging?
I am challenging the order passed by the Deputy Commissioner, rejecting the application filed by the petitioners for grant of occupancy rights and conferring the occupancy rights on behalf of the contesting respondents.
Rival tenants.
Yes, Miller?
Rival tenants.
Rival tenants. What had happened was this.
Where is the order of the DC?
DC's order is at next F. But before going there, I would like to state certain facts. What had happened was this. The lands were governed by the provisions of the Mysore Religious and Charitable Norms Abolition Act. The vesting date was 1/7/1970. Admittedly, my client's father was the tenant in cultivation as on the date of vesting. Admittedly, the contesting respondent claimed to be in possession right from 1972, not from 1970. But in that background, when the applications were considered, first time by the land tribunal, the chairman of the land tribunal holds, because I have been in possession of the property as on 1/7/70, I am entitled for occupancy rights and not the rival tenant. But the majority of the land tribunal members, they take a different opinion. And the order was passed on the basis of the majority opinion. That was challenged before the Land Reforms Appellate Authority, because at that particular point of time, Appellate Authority was there. The Appellate Authority, what happened? Same situation developed. The judicial member agreed with my contention, saying that admittedly since as on 1/7/1970, my client's father was in possession of the property. My client is entitled to grant of occupancy rights. The revenue member took a different view because he felt that subsequent to 1/7/70, they were probably guided by the provisions of the Land Reforms Act. He wrote a dissenting order. Then the matter was referred to the civil court. There was a possibility of referring the matter to civil court if there is a dissenting opinion between the judicial member and the revenue member. Civil court came to the conclusion that yes, the occupancy rate should be granted in favor of the petitioners. Thereafter, the matter was challenged before the High Court, and the Honorable High Court remanded the matter. In an LRRP, the matter was decided, and the matter was remanded back to the Deputy Commissioner for a fresh inquiry. The Deputy Commissioner does not consider anything. He passes an order hold only on the ground that the occupancy rate will have to be granted to the respondents. He doesn't consider the rate of vesting. Nothing has been done.
Where is the reasoning portion of his order?
Kindly see the Deputy Commissioner's order. Kindly go to 109, page number 109.
Page 110, ದಾಖಲೆ ಪರಿಶೀಲನೆ ಅಂತೆ. Page number 110, ದಾಖಲೆ ಪರಿಶೀಲನೆ ಅಂತೆ.
110ದಲ್ಲಿ ದಾಖಲೆಗಳ ಪರಿಶೀಲನೆ ಅಂತೆ. ಸರ್ವೆ ನಂಬರ್ 14ರಲ್ಲಿ 1 ಎಕರೆ 36 ಗುಂಟೆ, 3 ಗುಂಟೆ ಜಾತ 1 ಎಕರೆ 33 ಗುಂಟೆ, 29ರಲ್ಲಿ 4 ಗುಂಟೆ, 36ರಲ್ಲಿ 14 ಗುಂಟೆ ಜಮೀನು ವರದರಾಜಸ್ವಾಮಿ ದೇವರಿಗೆ ಇನಾಮತಿ ಜಮೀನು ಎಂದು ಪಹಣಿಗಳಲ್ಲಿ ನಮೂದಾಗಿರುತ್ತದೆ. ಸರ್ವೆ ನಂಬರ್ 14 ಸೋನ್ಸೋ 1 ಎಕರೆ 33 ಗುಂಟಾಸ್ ಜಮೀನಿಗೆ 1972-73ರಿಂದ 78-73 ಪಹಣಿಗಳಲ್ಲಿ ಕಾಲಂ 12-2ರಲ್ಲಿ ವೆಂಕಟಗಿರಿ ನಾಯಕ ಅವರ ಹೆಸರು ನಮೂದಿದ್ದು 12-3ರಲ್ಲಿ ಗುತ್ತಿಗೆ ನಮೂದಾಗಿರುತ್ತದೆ. ಸರ್ವೆ ನಂಬರ್ 29ರಲ್ಲಿ 4 ಗುಂಟೆ, 30ರಲ್ಲಿ 14 ಗುಂಟೆ ಜಮೀನು 1973-74ರಿಂದ 81-82 ಪಹಣಿಗಳಲ್ಲಿ ಕಾಲಂ ನಂಬರ್ 12-2ರಲ್ಲಿ ವೆಂಕಟಗಿರಿ ನಾಯಕ ಅಂತ ಹೆಸರು ನಮೂದಿಸಿದ್ದು 12-3ರಲ್ಲಿ ಗುತ್ತಿಗೆ ನಮೂದಾಗಿರುತ್ತದೆ. ಹಾಗೂ ಮುಂದೆ ಪಹಣಿಗಳು ಸಹ 2002ರಿಂದ ತನಕ ಅರ್ಜಿದಾರ ವೆಂಕಟಗಿರಿ ನಾಯಕ ಅವರ ಹೆಸರು ನಮೂದಾಗಿರುತ್ತದೆ. ಭೂನ್ಯಾಯ ಮಂಡಳಿಯು ಅರ್ಜಿದಾರ ವೆಂಕಟಗಿರಿ ನಾಯಕ ಅವರ ಹೆಸರಿಗೆ ಅಭಿಭೋಗ ದಾರಿಕೆಯನ್ನು ಮಂಜೂರು ಮಾಡಿರುತ್ತಾರೆ. ಇದರಿಂದ ಅರ್ಜಿದಾರರಾದ ವೆಂಕಟಗಿರಿ ನಾಯಕರವರ ಜಮೀನನ್ನು 72-73ರಿಂದ ಗುತ್ತಿಗೆ ಪಡೆದು ಗೇಣಿದಾರರಾಗಿ ಜಮೀನು ಸಾಗುವಳಿ ಮಾಡಿದಿರುವುದು ಪಹಣಿಗಳಲ್ಲಿ ಬರುತ್ತದೆ. ಭೂನ್ಯಾಯ ನ್ಯಾಯ ಮಂಡಳಿಯ ದಿನಾಂಕ 19/7/82 ಆದೇಶವನ್ನು ಎತ್ತಿ ಹಿಡಿದಿದೆ. The first order which was set aside, he confirms the order.
This is the reasoning of the London Deputy Commissioner. And even going by the reasoning,
Where's your form number 1?
my lord, I had form number 1 I have not produced. But there is no dispute about the fact that I have been in possession of the property.
Does he admit that?
My lord, the RTC records findings are in our favor.
There's no dispute and does he admit?
The dispute in the sense, the revenue records, there is no dispute about it. Even the finding of the Deputy Commissioner, your lordship may kindly see.
He is only referring from 72.
72. That means as on 1770, he is not in possession. That is an admitted fact. There are no records. Apart from that, kindly go to the order passed by the land tribunal. My lord.
Some of the documents, statement of
Kindly,
I have a solution is that the author denied that he was not a tenant in occupation other than that day. He was in occupation on the basis of Panchasalu. It does not come within the purview of the definition of the tenant.
But where is the consideration by the DC about?
At least has not been considered. I'll come to that. My another submission is that he has no local file application itself because he has surrendered the lease. Kind indicate director R1 8 mail.
Yes.
Not that after the completion of this period of 5 years, not Panchasalu.
Please read R1.
Lord, I think number 8 Lord, action proceedings held 6 and
ನನಗೆ ಅಬ್ಜೆಕ್ಷನ್ ಕಾಪಿ ಕೊಟ್ಟೇ ಇಲ್ಲ ಸ್ವಾಮಿ. ಐ ಡೋಂಟ್ ಇಲ್ಲ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ನನಗೆ. ಇಲ್ಲ ನನಗೆ ನನ್ನ ಹತ್ರ ಯಾವುದು ಕಾಪಿ ಇಲ್ಲ. ಇಲ್ಲ ಇಲ್ಲ. ಐ ಆಮ್ ಟೆಲ್ಲಿಂಗ್ I don't have any copy of the documents filed by them. ಅಲ್ಲ ಬೇಕಾದ್ರೆ ಕೊಡ್ಲೇಬೇಕಲ್ವಾ? I have not received any copies.
Lord, he has surrendered the lease in the year 1972 itself. By surrendering the lease, my lord, his all his rates was property as Panchasalu Kutta.
Where is the surrender indicated?
My lord, he has participated in the action, my lord, data. 15th and 1970, impact number 8, my lord, I typed the copy of that. He himself has, the father of the petitioner has participated in the action proceeding. After surrendering the lease of 1970.
Question is, as on 1770, who is in possession of the property? That's all.
ನನ್ನ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಕ್ಕೆ
ಅಲ್ಲ ನಾನ್ ಮಾಡ್ಬೇಕು, ನಾನು petitioner ನಾನು ಹೇಳ್ತಾ ಇದ್ದೀನಿ.
ನಾನೇ ಅವ್ರಿಗೆ ಕ್ವೆಶ್ಚನ್ ಕೇಳಿದೆ.
I'm sorry, what I'm submitting is, the question is that date of vesting, I will read the relevant provisions of the act also.
And he him up one of the father of the petitioner.
When did he get this Panchasalu Kutta?
From 1968 onwards. Earlier RTCs also, according to the orders passed by the authorities, they were standing in my name. 68 onwards, 67, 68 onwards, I was in, as per the Panchasalu Gutti, I have been in possession of the property. And your lordship may kindly see.
Then you were there till what time?
Till 1972, even as per the Panchasalu Gutti.
Somebody else was in possession.
Subsequently, he claims to be in possession.
He also was
He was not in possession of the property as on 1770.
birth in 70. 72 admal you lost possession then.
No, I don't say that I have lost possession.
Was he the
According to-
successful auction
But
bidder?
what had happened is this, so far as 1770 Act came into force with effect from 1770. The land vested with the government with effect from 1970. Subsequently, even assuming that he claims to be in possession of the property,
How did he get in possession and how did he lose possession? Does it not indicate that you have to be in continuous possession on the date of vesting?
he is not in
For
possession.
you to be granted occupancy rate,
Yes, my lord.
you should be on possession on that particular date and continue to be in possession.
No, as on that date, I should be in possession.
Then if you, in an auction, if you surrender possession,
No, what I am saying is subsequent to 1770, my lord,
let us see the provision regarding,
kindly see the act, my lord. Kindly see the act. Who are the persons who are entitled to claim
Check.
possession?
under which act did you make an application?
Release in chartable norms of abolition. Panchasalu Guttigeದಲ್ಲಿ ಇದೇನಂದ್ರೆ I am a tenant only, that is one thing. But kindly go to section 6, my lord.
Page
My lord,
6. Section 6.
other tenants to be tenants under the government. Every tenant of the inamdar other than the Kadim tenant or a permanent tenant shall with effect on and from the date of the vesting and subject to the provisions of the act shall be entitled to be continued as a tenant
under the government in respect of the land, even assuming that I am not a Kadim
So the
tenant.
tenancy, section 6 only gives you the right to continue as a
Yes,
tenant.
my lord.
If you have surrendered possession
My lord, what I am
after the
submitting,
expiry of your 5 years period,
my lord, what I am
then
submitting,
you are not a tenant.
my lord, why submission is this, my lord? I am a tenant as on 1770, my lord. As on 1770, I am a tenant. As on, from 1770 onwards, my lord, the land vested with the government. And the rights, my lord, once the lands vested with the government, the grant of occupancy rights is the question that remains. But the subsequent conducting of Panchasalu Guttiga in 1972 or all that, my lord, they are inconsequential because,
Your application was claiming occupancy rates under either as a Kadim tenant, protected tenant or a permanent
and
tenant.
as a tenant, I have made a claim, my lord. As a tenant,
To be continued as a tenant.
even, my lord, one submission is
The
this.
section 6,
Yes, my
all
lord.
that they can do is they can continue as a tenant.
Maybe whatever rights I am entitled
Let us see
to.
your form number 1.
My lord, form number 1, my lord, I don't have right now. I'll have to get it. But my submission is kindly see the orders passed by the authorities all along. Kindly see the orders passed by the authorities all along. Right from beginning, my lord, kindly see the annexure A, my lord. That is the order pass.
How can you be conferred with occupancy rates?
Yes, my lord.
Under which section can I bring you and say
My lord,
that you should be entitled to be registered as an occupant?
my lord, kindly see the order, my lord.
No,
This is
from-
what it says.
No, from the from which provision can I?
Section 6 keradde ನಾನು government keradde ಅದು continue ಮಾಡ್ಬೇಕು ನನ್ನನ್ನ. What's
Section-
the scenario? Assuming that I have filed an application seeking occupancy rights, the fact that, my lord, as on 1770, they have to determine my status.
68, you say that you had a Pansal Gutta in your favor.
Yes,
72,
next minute.
you have surrendered possession.
But that particular fact, I don't admit it, because what happened is this: in 1972, these authorities, without taking into account the fact that the land had already vested with the government from 1770, if they hold some Panchasalu Guttige, and if assuming that because the expiry of time, a period of 5 years,
When did you make the application to continue you as a tenant under section 6?
my lord, I had filed the application, my lord. I'll submit. My application was filed, my lord, on 19/8/1970. Two applications were filed in 1976. One on 17/8/1976, another on 19/8/76. I will check whether I can get these
Both
documents
dates,
also.
on both dates, the Tahsildar had auctioned this tenancy rights in favor of somebody else.
That was without authority, almost. Is it not without authority, my lord? Ultimately,
You should have challenged that, isn't
no,
it?
ultimately, my lord, question is this.
Sit at home and say
My lord,
that.
ultimately, my lord, my question is this, my lord. If the law says that as on 1770, whoever is in possession, his possession should be affected because that is the day on which the land vested with the government. Whether the subsequent illegal actions of any authority,
The order by which you were permitted to be inducted as a tenant, which is that order, 68 order?
well, 68,
68 you were inducted as a tenant.
Panchasalu Guttige ನಾನು ತಗೊಂಡಿದ್ದು.
Where is that?
The order, it is reference, it is referred to in the order passed by the land tribunal.
Let us see the order itself.
My lord, that particular order,
What is the amount that you paid?
1968 document, I don't have, my lord. That is an admitted fact. Kindly see the order passed by the DC, land tribunal, which wherein, my lord, on the basis of the majority order, the order has been passed in favor of the other side. Kindly see annexure A, my lord.
No, I am concerned only with the fact as to whether you had a right or not.
My lord, that
As-
particular aspect, my lord, my possession as a tenant as on 1770 is an admitted fact.
For you to be coming under section 6, you need to be a tenant under the Inamdar.
My lord, what happened?
According to you,
My lord, what was,
your claim as a tenant was under the government.
well, my submission is this.
For you to come within section 6,
Correct. The lands were vested with the temple, which was a Muzirai temple.
that is besides upon
No, no, I'm trying to clarify your lordship. The lands were vested with the temple, which was a Muzirai temple. Muzirai officer was the Tahsildar. The Tahsildar was conducting Panchasalu Guttiga auctions. So in 1968, pursuant to that particular authority, he had auction.
even if I accept your argument,
Yes,
section 6 categorically states that you have to be a tenant under the Inamdar.
You know,
Since you admittedly say that you were
Yeah.
inducted as a tenant by the government is
no,
not
no, my
Inamdar.
submission is this, your lordship may kindly see. I am not a tenant under the government because that I am a tenant of the temple, which was a Muzirai temple, and it was Tahsildar in the capacity of the Muzirai officer, he was auctioning it.
Six
I am not a tenant under the government.
6 intends to protect those persons who had been inducted by the Inamdar.
Inamdar is the
Not by the-
temple. Inamdar is the temple. The land is given to the temple as such.
Inam temple is a Muzerai temple, and it is managed by a Muzerai officer under the old Act, 1927 Act. That Muzerai officer under the 1927 Act was a Tahsildar. It is he representing the temple and the deity, he was conducting auctions. Not that, this was a government land and all that. As on 1968, when auction took place, the land was belonging to the temple and not to the government. It vested with the government only on 1/7/1970. So, question of any subsequent actions by the Tahsildar in 1972, seeking to auction the property, is without his any jurisdiction. That cannot confer any rights on him.
One of the form filed by before the court, my lord, annexure, my lord, R3, my lord. He has filed an application with CA, my lord, claiming that is the Archaka of that.
Right.
Please check. 14, my kindly.
Archaka, no, problem is, I don't know.
You're saying no under section 4.
He claims under section 6 that application or annexure R3.
6
R3 Archaka claim, sir. Archaka can make an application of section 8.
Typed copy of section 4 anತಾರೆ.
Then ಹೇಳ್ತಾರೆ, but the precedence in that ದೇವಸ್ಥಾನದ ಅರ್ಚಕನಾದ ನಾನು ದೇವಸ್ಥಾನದ ಪೂಜಾರಿ ವ್ರತ ಕಾರ್ಯ ನಡೆಸಿಕೊಂಡು
ಯಾರು ಸೈನ್ ಮಾಡಿದ್ಯಾರು ನೋಡಿ ಸ್ವಾಮಿ.
ಕಂದಾಯ ಪಡೆದ ಪಾವತಿ ಮಾಡ್ತಾ
ನೀವು ಕಾಪಿ ಕೊಡಿ, ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಕೊಡಿ ಅವ್ರು ಮೇಡಮ್. Get the records. Relist. Next Monday.
Bill number 83. B. Vachan.
Lord, the hearing for respondents 6 to 10.
17.
My lord, the order of the special deputy commissioner, my lord, at annexure A. Lord, I have purchased, my father purchases the property in 1992, my lords. MR entry is made in my name is entered in the RTC also.
Next year, yena.
Annexure A, my lords.
136, sir.
136 proceedings. My lords, one submission, my lords.
Yes.
Council on record is unable to attend court today. If any other date may be fixed, even tomorrow is fine. And for respondents 6 to 10, my lords.
Relist.
Any date, my lord.
ಕೊಡ್ತಾರೆ.
18.
Grateful. Obliged, my lord.
Seal number 88. Marigoda.
Respondent. Sir, on the last occasion, your worship have directed, where have you filed anything challenging the grant made in this favor? That order I am using. But my friend has suppressed that order also in the entire, he has participated in this appeal. And my lord, in this appeal, may just pass on the order. But it is referred to in the order passed by the Assistant Commissioner and also by the date. When I made a submission that the grant have been made by the committee. Earlier, at the first instance, his application and our applications were rejected. Second instance, my lord, without challenging that order, land without issue, it only takes up and grant the same land to him alone. That was called the question in that appeal by both of us. And both, my lord, the Assistant Commissioner cancels the grant made in this favor, my lord, page number 2, last paragraph. May I just read that last paragraph, but ಈ ರೀತಿ ಗೆಜೆಟೆಡ್ ಪ್ರಕರಣ ಆದಾಗ ಪ್ರಸ್ತುತ ಪ್ರಕರಣದಲ್ಲಿ ಸಕ್ರಮ ಕೋರಿದಂತಹ ಎಲ್ಲಾ ಅರ್ಜಿಗಳನ್ನು ಒಟ್ಟುಗೂಡಿಸಿಕೊಂಡು ವಿಚಾರಣೆ ನಡೆಸಿ ಗೆಜೆಟೆಡ್ ಪ್ರಕರಣದಂತೆ ಲಭ್ಯವಿರುವ ಜಮೀನು ಆದೇಶ ನಿಯಮಾನುಸಾರ ಸಕ್ರಮಗೊಳಿಸಿ ಕ್ರಮ ಕೈಗೊಳ್ಳಬೇಕಾಗಿದೆ. ಆದರೆ ಈ ಪ್ರಕರಣದಲ್ಲಿ ಒಮ್ಮೆ ಕಮಿಟಿಯಲ್ಲಿ ವಜಾ ಆದ ಅರ್ಜಿಯನ್ನು ಕಮಿಟಿಯೇ ಸ್ವಯಂ ಪ್ರೇರಣೆಯಿಂದ ಮತ್ತೆ ಕೈಗೆತ್ತಿಕೊಂಡು RA 67/98/92 ಎರಡನೇ ಎದುರುದಾರರಿಗೆ ಜಮೀನು ಸಕ್ರಮಗೊಳಿಸುವುದು ಭೂ ಮಂಜೂರಾತಿಯ ಸ್ಪಷ್ಟ ಉಲ್ಲಂಘನೆ ಆಗಿದೆ.
ಆದುದರಿಂದ ಪ್ರಸ್ತುತ ಆರ್ಯ 46 ಮತ್ತು 47 98 99 ಅಪೀಲುದಾರರ ಬೇಡಿಕೆಯನ್ನು ಪುರಸ್ಕರಿಸಿದೆ. ಹಾಗೂ ಆರ್ಯ 67 98 99 ಎರಡನೇ ಅಧಿಕಾರಿಗೆ ಮಂಜೂರಾಗಿರುವ ಮಂಜೂರಾತಿಯನ್ನು ರದ್ದುಪಡಿಸಿದೆ. This order he has never called in question before any other authority. This order has attained finality. Now, Lord, he is before this honorable court on an endorsement. Lord, this, your lordship may kindly come to now, your lordship may kindly come to annexures, Lord, what my learned friend is referring to in annexure E. With this background, my lord, may I take your lordship to annexure E, Lord? What is called in question in that?
Yes.
Lord, annexure.
What was this appeal challenge filed against?
We are based on endorsement based on this order, what I refer to now.
No, this is 2001.
Yes, Lord. This one he has filed in 2001 to an endorsement was
No,
issued.
in this, he refers to Mutturu Tahsildar avara dinaka.
Rejection order. The very first rejection order he has filed a question in this.
When was the first order of rejection?
Lord, this one.
Where do you get that in this order?
Lord, lordship, in this order, lordship kindly see. Page number 2, may I take your lordship again to page number 2, Lord, in that order. Second paragraph, may I read?
Yes.
ಉಭಯತ್ರರ ವಾದ ಸಲ್ಲಿಸುವ ದಾಖಲಾತಿಗಳಲ್ಲಿ ಕಳೆದ ಕಚೇರಿಯಿಂದ ಮೊದಲಾದ ಕೆಲಸಗಳನ್ನು ಪರಿಶೀಲಿಸುತ್ತೇನೆ. ವಿವಾದಿತ ಸರ್ವೆ ನಂಬರ್ 139ರಲ್ಲಿ ಆರ್ಎ 46, 47, 98 ತಲಾ 2 ಎಕರೆಯಲ್ಲಿ ಆರ್ಎ 67, 98, 92 ಎರಡನೇ ಎದುರುದಾರ 2 ಎಕರೆ 23 ಅಕ್ರಮ ಸಾಗುವಳಿಗಾಗಿ ಸಕ್ರಮ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದಾರೆ. ದಿನಾಂಕ 6/6/98ರಂದು ಮದ್ದೂರು ತಹಸೀಲ್ದಾರ್ ಅವರು 3 ಪ್ರಕರಣಗಳನ್ನು ಅಪೀಲುದಾರರಿಗೆ ಈ ಸರ್ಕಾರಿ ಜಮೀನು ಸರ್ಕಾರಿ ಪೆಟ್ಟೆ ಆಗಿರುವುದರಿಂದ ಸಕ್ರಮಗೊಳಿಸಲು ಅವಕಾಶವಿಲ್ಲವೆಂದು ಕಮಿಟಿ ನಿರ್ಣಯದ ಮೇರೆಗೆ ಹಿಂಬರಹ ನೀಡಿರುತ್ತಾರೆ. ಅದೇ ರೀತಿ ಆರ್ಎ 67/98 ಎರಡನೇ ಎದುರುದಾರನು ಕೂಡ 19/4/93 ಕಮಿಟಿ ನಿರ್ಣಯ 92 ಅನುಸಾರ 18/8/93 ಇದೇ ನಿರ್ಣಯವನ್ನು ಉಲ್ಲೇಖಿಸಿ ಹಿಂಬರಹ ನೀಡಿರುತ್ತಾರೆ. In this order, the lordship can kindly come to in annexure E. The lordship can kindly come to page number 45 for a minute. Class 4, 3 and 4 in that. Page number 45.
This order was not brought to his notice?
It was brought to you.
No, before the AC.
Yes, page number 45.
La.
In annexure E, your lordship can kindly come to page number 45.
Type copy.
Yes, page copy page number 49. May I read, Lord?
Yes.
ಮಂಜೂರಾದ ಈ ಮಂಜೂರಾತಿ ಹಾಗೂ 6/6/98 ಪರಿಷ್ಕೃತಗೊಂಡ ಅರ್ಜಿಗಳು ಇದರ ಆದೇಶ ಕ್ರಮಬದ್ಧತೆ ಪ್ರಶ್ನಿಸಿ ಸೇರ್ಪಡೆದಾರರು ಇದೇ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಮೇಲ್ಮನವಿ ಸಲ್ಲಿಸಿ ಇದು ಆರ್ಎ 47, 48 ಮತ್ತು 67, 98, 99
ಎಲ್ಲೋ ಹತ್ತಿರ page 49.
paragraph number 4. Reconstruction.
That is internal page 3.
Yes, madam. Internal page 3. Paragraph number 4. Thank you.
ಹೆಂಗಾಗತ್ತೆ ಗೌಡ್ರೆ?
ಸ್ವಾಮಿ,
ಹೆಂಗಾಗತ್ತೆ? ಈ ಆರ್ಡರ್ ಆದ್ಮೇಲೆ how can he pass this order?
ಈ ಆರ್ಡರ್ ಕೊಟ್ಟಿದ್ದಾರಲ್ಲ ಅದಲ್ಲ ಸ್ವಾಮಿ.
In the light of this order, how could the assistant commissioner have passed this order in 2003? In one breath, he says it can't be given to you. And you don't challenge this order. Then you once again go and challenge the original rejection. Otherly, virtually reverses his order.
ಇದು ಇದ್ರ ಬಗ್ಗೆ
He says ಮೂರನ್ನು ಒಟ್ಟಿಗೆ
ಅಲ್ಲ ಎಲ್ಲ ಕ್ಲಬ್ ಮಾಡಿ
Reverses this order.
even that is also ಮೂರು ಕ್ಲಬ್ ಮಾಡಿ ಹೋಗಿ
ಎಲ್ಲ ಕ್ಲಬ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಕ್ಲಬ್ ಮಾಡಿ ಎಲ್ಲವನ್ನು ಕ್ಲಬ್ ಮಾಡಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಎಲ್ಲ ಆರ್ಡ್ರು ಅಷ್ಟೇ ಸ್ವಾಮಿ ಇರೋದು. ಇವ್ರು ಎಲ್ಲ ಆರ್ಡ್ರು ಕೂಡ ಕ್ಲಬ್ ಮಾಡಿನೇ ಮಾಡಿ ಅಂತ ಹೇಳ್ತಾರೆ.
What is a DC say now?
DC ಆಲ್ಸೋ ಅದನ್ನೇ ಹೇಳೋದು, ಕ್ಲಬ್ ಮಾಡಿನೇ ಮಾಡಿ ಅಂತ. ಇವರ ಅಪ್ಲಿಕೇಶನ್ ಎಲ್ಲ ಕ್ಲಬ್ ಮಾಡಿ. ತಾವು ದಯವಿಟ್ಟು ನೋಡಿ ಲಾಸ್ಟ್ ಪರಾಗ್ರಾಫ್
Then why have you challenged that order?
ಇದು ನೋಡಿ ಆದೇಶ ಅಲ್ಲ.
Last time indirect submission granted, then the impact taken up. That was a false submission made by him.
ಆದೇಶ ಮಾತ್ರ ಲಾಸ್ಟ್ ಸುಮ್ಮನೆ ಆದೇಶ ಇದು DC ಆದೇಶ ಪೇಜ್ ನಂಬರ್ 61 ಟೈಪೆಡ್ ಕಾಪೀಸ್ 61. ಅಪೀಲುದಾರರ ಅಪೀಲು ಅರ್ಜಿ ವಜಾ ಮಾಡಿದೆ. ಪ್ರಸ್ತುತ ವಿಭಾಗೀಯ ಆದೇಶ ಸಂಖ್ಯೆ ದಿನಾಂಕ 29 ಆದೇಶ ಎತ್ತಿಡಿದೆ. ಈ ಆದೇಶನು ಈಗ ಲಿಖಿತ ಅಂದ್ರೆ ಇದು ಆರ್ಡರ್ ಈ ಟೋಟಾಲಿಟಿ ಲಾರ್ಡ್ಶಿಪ್ ಕೈಂಡ್ಲಿಸಿ ಈ ಎಲ್ಲಾ ಅಪ್ಲಿಕೇಶನ್ ಕ್ಲಬ್ ಮಾಡಿನೇ ಮಾಡಿ ಅಂತಾನೆ ಇರೋದು ಸ್ವಾಮಿ.
ನಿಮ್ಮದು ಯಾಕೆ ಹಾಕಿದ್ರಿ ರಿಟ್ ಪಿಟಿಷನ್ ಯಾಕೆ ಹಾಕಿದ್ರೆ?
ಅಲ್ಲ ಇದು KT ಇಂದ ಆರ್ಡರ್ ಆಯ್ತಲ್ಲ ಸ್ವಾಮಿ.
ಅಲ್ಲ ಏನಕ್ಕೆ ಬಂದ್ರಿ ಅಂತ KTಗೆ ಯಾಕೆ ಹೋದ್ರಿ? ಯಾರು ಹೋದ್ರು?
ಈ ಆರ್ಡರ್ ಮೇಲೆ ನಾನೇ ಹೋದ್ದು KTಗೆ. ಈ DC ಆರ್ಡರ್ ಮೇಲೆ KTಗೆ ಹೋದೆ ನಾನು.
ವಾಟ್ ಇಸ್ ದ KT say now?
KT ಇದನ್ನ ಕನ್ಫರ್ಮ್ ಮಾಡಿದ್ದಾರೆ. ಇದು ಈ DC ಆರ್ಡರ್ ಕನ್ಫರ್ಮ್ ಮಾಡಿದ್ದಾರೆ.
Then why did you file a writ petition if ultimately this order and the order passed to the Assistant Commissioner and the DC was to combine all the applications considered? Why did you file the writ petition?
ಅಲ್ಲ ಈಗ ಅಂದ್ರೆ the only question Milad, since I have been granted grant certificate that has been challenged by anybody.
This has been cancelled alva.
ಎಲ್ಲಿ
By this order.
ಎಲ್ಲಿ
By this order ರದ್ದುಪಡಿಸಲಾಗಿದೆ.
Suppress ಮಾಡಿದರೆ
No.
ಎಲ್ಲೂ ಹೇಳಲ್ಲ ಅವರು. Doesn't speak a word about that and it doesn't produce it
ಅಲ್ಲ
also.
ಈ ಆರ್ಡರ್ 47 of 98, 99 ನಲ್ಲಿ ಈ ಆರ್ಡರ್ ಈಗ ಕೊಟ್ಟಿದ್ದಾರೆ.
3 ಅಪೀಲ್ ಇತ್ತು. RA 47, RA 48, RA 67 ಅಲ್ವಾ? 3 ಅಪೀಲ್ ಇತ್ತು. ನಿಮ್ ಕ್ಲೈಂಟ್ ಹೆಸರು ಏನು?
ಸಿದ್ದಪ್ಪ.
ನಿಮ್
ಸಿದ್ದಪ್ಪ ನಮ್ದು ಸರ್.
ಇವಾಗ
67 ನಮ್ದು.
ಲಾಸ್ಟ್ ನೋಡಿ RA 67/98
ನಮ್ದು ಅದು.
ಎರಡನೇ ದೂರದಾರಿಗೆ ಜಮೀನನ್ನು ಸಕ್ರಮಗೊಳಿಸಿರುವುದು ಭೂ ಮಂಜೂರಾತಿಯ ಸ್ಪಷ್ಟ ಉಲ್ಲಂಘನೆ ಆಗಿರುತ್ತದೆ. ಆದುದರಿಂದ ಪ್ರಸ್ತುತ RA ನಂಬರ್ 4047ಗಳನ್ನು ಅಪೀಲಿದಾರ ಮೇಲ್ಮನೆಯನ್ನು ಪುರಸ್ಕರಿಸಿದೆ ಹಾಗೂ RA 67/98 ಎರಡನೇ ದೂರದಾರಿಗೆ ಮಂಜೂರಾಗಿರುವ ಮಂಜೂರಾತಿನ ರದ್ದುಪಡಿಸಿದೆ. Then how can it be granted to you?
ಇದ್ರ ಬಗ್ಗೆ I will Lordship have it tomorrow. I will come to this. ದಯವಿಟ್ಟು ಹೇಳಿ ನಾಳೆಗೆ ಇಟ್ಕೊಳ್ಳಿ. I will come to this.
ವಿಡ್ರಾ ಮಾಡ್ಕೊಳ್ಳೋದು ವಾಸಿ ನೀವು.
ಇಲ್ಲ ನಾನು ನಾಳೆಗೆ I will make.
ನಾನು ಸುಮ್ಮನೆ ನೀವು ಸಪ್ರೆಸ್ ಮಾಡಿದಿರಾ ಇದನ್ನ ಬಚ್ಚಿಟ್ಟಿದ್ದೀರಾ ಅಂತ ಹೇಳಿದ್ರೆ ನಾನು
ಅಲ್ಲಲ್ಲ ಈಗ ನಾಳೆ ತಾವು ದಯವಿಟ್ಟು ನಾಳೆಗೆ ಇಡಿ, ನಾನು ಹೇಳ್ತೀನಿ. I make my submission on this point. ನಾಳೆಗೆ ಹೇಳ್ತೀನಿ. Tomorrow.
Number 90, BR Vishwanath.
In view of repeated malafide exercise of power, my lord, the Tahsildar was directed to file an affidavit, my lord, giving an explanation with regard to re-enquiry, my lord, as per orders dated 1/10/2024, my lord. What had happened, my lord, the grant was confirmed on several occasions, because when I approached for getting of Kata, my lord, all proceedings were held. The learned assistant commissioner holds that's the genuine Kata. Inquiry was held. Kata was ordered to be registered in my name. Subsequently, the same Tahsildar, my lord, also holds an inquiry and holds that it's a genuine Kata, and as per Annexure K, my lord, records a finding that I am entitled for registration of Kata. But subsequently, my lord, I don't know what reasons. Once again, the same inquiry is initiated. There also they record that, my lord, I have been in possession, the grant is genuine, everything. Ultimately, again, they try to initiate one more inquiry, my lord. Here also, my lord, in the affidavit also, they say that the grant is genuine.
No, your affidavit virtually says that the order is malafide. Then what remains?
Lord, he was directed to physically present, then also it was confirmed, my lord.
Though he is retired, not the plan was made. But already Malad, he had another extent of land was granted.
When was this grant made? 25 years afterwards you started. ಏನ್ ಮಾಡ್ಬೇಕು?
Speaks Malad, Malad, though he is not entitled, not the grant was made.
Can you sit in judgment over that grant now? And the affidavit and the orders, you virtually concede that they are guilty. What is the order that you have challenged?
Lord, annexure A, my lord. There also, my lord, they say that the grant is genuine. Annexure A, my lord.
If you don't withdraw this in the light of this affidavit and those orders, I'll have to impose cost and pass something. And you have yourself said that you intend to take action against this revenue inspector who misled the Tahsildar. No, but you want to go against the revenue inspector as per the affidavit. The earlier village accountant Gangnar Smaya had already retired. A proposal is submitted to the DC to initiate disciplinary proceedings against Sri S. Chandrasekhar, RI, by letter dated 9/12/2024. What happened there afterwards? Then you're protecting them then. What else? ಅಲ್ಲ ಇವನ್ ಆರೇ ಇದ್ನಲ್ಲ ಯಾರೋ ಎಸ್ ಎನ್ ಚಂದ್ರಶೇಖರ್. Next week ಹಾಕೊಳ್ತೀನಿ, get instructions. It's better that you quietly withdraw this and accept that the grant is valid. So I can drop the proceedings here, or else you invite an order from me, I'll have to go against these gentlemen and impose cost. ಇವತ್ತೇ ಮಾಡ್ಲಾ ಇಲ್ಲ ಏನ್ ಮಾಡ್ಲಿ? No, I'm leaving it to you. If you leave it to me, you will suffer a serious order. Day after tomorrow. Monday.
Silma 91.
Okay.
श्रीमती विद्यावती के
Monday, your lordship may kindly post it in the order. ಇದು ಹಾಗೆ
ಬರುತ್ತೆ, ಮೆನ್ಷನ್ ಮಾಡಿ. ಆಯ್ತು, 4 ಮೆನ್ಷನ್ ಮಾಡಿ ತಗೊಳ್ತೀನಿ. ಆಯ್ತು.
I appeal for petitioner, my lord. The land is granted to the father of the petitioner.
Petitioner has been preferred. Appeal before special DC. Okay.
I'm from the
My
petition.
lord, the same objection raised at the time of granting an interim order. It is not maintainable, my submission, because the respondent number 4 has no locus to challenge the entry made in my favor, my lord. Because he is not a family member, he is
Madam,
not a affected.
Can you pursue parallel remedies?
No, it is already withdrawn.
Withdraw.
Because for wrong advice, because of wrong advice,
After filing writ
Have they
petition.
withdrawn it or what?
It is not
it
brought
is
before.
withdrawn. It is withdrawn, my lord.
It has been not done.
It is withdrawn, my lord.
ಯಾವತ್ತು?
Date, my lord, I don't have, but as per the instruction of the client, it is withdrawn. The thing is, my lord, even the proceedings itself is not maintainable, my humble submission.
the respondent number 4 is a stranger to the family and he don't have any right over the property, he has filed an objection before the assistant commissioner under 136(2). The 136(2) says that, my lord, the affected party can prefer an appeal under 136(2). Your lordship, kindly see the provision. He is not a affected party.
But the KLR Act contemplates public inquiry, isn't it? Anybody can file objections.
Please, my lord. No,
Form
the
number 21.
person, related person can file an objection. It is not a
Disputing the
PIL.
will, your lordship. The grant is
Order
for
is also the-
6.4 acres. Annexure G.
Your lordship, kindly see the impugned order annexure G. What the assistant commissioner says that 130, if your lordship goes to 136(2), my lord, there is any person affected by an order made under subsection 4 or an entry certified under subsection 6 of the section 129 may within a period of 6 days. He is not a affected person. He is a stranger to the family. He had filed an appeal under before the assistant commissioner. Your lordship, kindly see.
Survey number 101, 6 acres 20 quintals is the dispute, correct?
Please, my lord.
In whose name was the
There is a
Kata
dispute
standing?
on that.
Please, my lord.
In
This
whose
is
name was the Kata standing?
Khata is standing in the name of the petitioner father. First petitioner father.
What is his
Your
name?
lordship, kindly see page number 19 grant order, my lord, on 25/1/1985.
What is the name of the Katadar?
Khatadar is, my lord, Suresh Sundar Joshi.
Suresh Sundar Joshi.
Please, my lord. Your lordship, kindly come to page number
Is
19.
alive or is no more?
Now he is no more.
When did he die?
He died on thereafter, my lord, his
4/10,
wife.
2019, my lords.
410?
2019.
9.
19.
4/10/2019, my
And
lord.
there are only two sons,
Allah,
No,
one
no,
wife
daughter.
and daughter.
Radhika and who's Dinesh?
My lords, he's a well-wisher, my lords.
Lakshmi Bai. Lakshmi have
He's got only one.
One daughter, my lords. Petitioner number 1 is the only daughter, my lords.
No wife, no sons.
Wife was there, my lords. She passed away, my lords.
And who's this Naveen?
My lords, he's a stranger, my lords. He is nowhere concerned to the family, my lords.
No, after Suresh passed away,
Yes, my
what
lords.
happened to the Kata?
My lords, Suresh had made a will in 2016, my lords, in favor of petitioner number 2.
Number 2.
Petitioner number 2 is a well-wisher, my lords.
Registered will?
Yes, my lords, it's registered.
What is the date of the will?
My lords, the will was dated 2/9/2016, my lords.
And who's this Naveen?
My lords, he's a stranger, my lords. He's nowhere concerned to the family. He's nowhere.
And why did he prefer the appeal?
Yes, my lords.
Lordship,
Why did he prefer the
I am
appeal?
appearing for the name, your lordship. Respondent number 5. Lordship, kindly see the annexure here, your lordship. The grant is for 6.4 acre, your lordship. The grant,
ನಿಮ್ಗೂ ಈ ಜಮೀನ್ ಏನ್ ಸಂಬಂಧ?
your lordship, we are disputing the will, your lordship. Even though
Who are you?
I am the public, in the sense Naveen. When
So you're not claiming a right in the land.
because the land contains ದೊಡ್ಡ ಆಲದ ಮರಗಳಿದೆ. Even though the land
You
ಅವರಿಗೆ
challenge the grant made in favor of Suresh.
the land
No,
is
my
only
lords, he
for
did not
6.4 acres. Land is only for 6.4 acres.
My lords, kindly
When-
see, my lords.
when- The land is only for 6.4 acres. The will, it's contains 6.20 acres.
Forget about the will. The land was granted to Suresh.
Land is granted for.
Did
the
you
student.
challenge the grant?
We are not challenging the grant, your lordship.
All right. If
We
the
are
name-
challenging the will.
Please listen. If the Kata was standing in the name of Suresh,
Yes, your
on
lordship.
his death, we will assume that the will is not there. In whose name should it go?
It should be inherited, your lordship.
So what is your right? You did not challenge the grant in favor of Suresh.
We are not challenging the,
If you don't challenge the grant at all, even if I ignore the will, the Kata will have to go in favor of the daughter Radhika.
but it is will not in the favor of the radicals, your lordship.
I will direct the Kata to in the name of Radhika. You will be satisfied.
Lordship, kindly see,
The Sagavali cheat has been taken by the petitioner after executing the will, your lordship. No, your lordship, kindly apologize.
Have you
After
challenged the grant in favor of Suresh?
you are not challenging the,
If you have not challenged the grant in favor of Suresh, Kata is bound to stand in his name. If he is dead, the Kata will have to go to his elders, even if the revenue authorities can't go into the will.
we are
They will only say, go and establish the will in the civil court. Until then, the Kata will have to be transferred in the favor of the legal heirs. There's only one legal heir.
but Tahsildar has not transferred to anyone. On the basis of the will, Tahsildar passed an order for the petitioner, your lordship. That's what we are challenging.
My lords, I am the
If
petitioner.
there is
number one,
if they want to execute the will, let them go to the civil court
Until that transferred in whose name?
in name of Dinesh, your lordship, petitioner.
My lords, I am petitioner number one,
Petitioner.
my lords, and
Radhika.
petitioner number two is Dinesh, my lords. Petitioner number one has no objections, my lords.
There
They
is
will
a dis-
direct the Kata to register in the name of Radhika, because she is the daughter. And I'll permit Dinesh to go to the civil court and establish his rights under the bill. Why should you the will?
May I permitted to make submission, my lord?
Madam, on the basis of the will, the Kata can't be changed by the authorities.
The thing is, your lordship kindly see annexure D. The Lakshmi Bai, the wife of Suresh, has filed an application to change the khata in the name of petitioner number 2 on the ground of bill. During the pendency of the petition, my lord, at the time she passed away. Then her daughter filed an affidavit stating that, my
Madam,
lord, she is the
let
only
the-
legal.
Let the Kata come in the name of Radhika, thereafter file a suit against Radhika, get a declaration and then come and get it changed. On the basis of the
Well,
will,
they-
which has not been established, the revenue authorities can't be given the right to challenge the change the Kata.
Now the petitioner number 1 is a
And
Radhika.
I can
And
understand.
she filed an affidavit.
No, I can understand if this P2, petitioner number 2, is the son or the daughter. He is a stranger to the family.
No, he is not a stranger. He is a legatee. It is
Hey, madam.
executed during the
Legatee.
life.
Vidyavati madam, legatee andre our magano maglu agidre, we can ask the authorities to act according to the will. Because even otherwise, even if the will is ignored, it will come to them.
But legal heirs don't have any objection. They themselves filed an
Therefore,
affidavit.
it is not my
Affidavit.
duty. ನಾನು ಅಡ್ವೈಸ್ ಮಾಡಬಾರ್ದು ನಿಮ್ಗೆ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹೋಗ್ಬಿಟ್ಟು ನೀವು ದಾವ ಹಾಕೊಂಡು ಡಿಗ್ರಿ ತಗೊಂಡ್ಬಂದು ಆಮೇಲೆ ಮಾಡಿಸ್ಕೊಳ್ಳಿ ಅದರೂ ರಾಧಿಕನ ಹೆಸರಿರ್ಲಿ.
Please, my lord, in both name, my lord, it may be continued because now
Both
my
names-
humble submission.
both names
Respondent
ಇದ್ದೇ ಆಗಲ್ಲ
number
madam.
4. Allah,
ರಾಧಿಕಾ
respondent number.
ರಾಧಿಕಾ ಹೆಸರಲ್ಲಿ ಮಾಡ್ಬೋದು ಅಷ್ಟೇ, ಇಬ್ಬರ ಹೆಸರು ಮಾಡಕ್ಕಾಗಲ್ಲ.
But application is application before the Tahsildar filed by the Lakshmi Bai, wife of Suresh.
She
Sundar.
cannot do it, madam. She cannot do it.
The thing is, my lord, the respondent number 4 don't have any locus to
No.
file an objection.
That I will hold.
It is not a PAL. Please, my lord. Yes, ma'am.
That
Yes,
I will hold.
Please, ma'am.
We'll get the instructions, your lord.
What instructions?
The payer is only for to transfer the kata on the name of the petitioner. We are challenging the will, your lordship.
How can you challenge the will? Before the Tahsildar, before the AC?
Before the AC we are challenging.
So if the AC gives a finding that the will is proved, you will accept it.
Lordship will fill an appeal. That's what they have to prefer on 136 clause
Like a
3, your
trade.
lordship.
Who are you to question the will?
Your lordship, we are the public. That's the matter.
It is not a public interest litigation.
It is not a public interest litigation, but still.
The land bearing survey number 101 measuring 6 acres 20 guntas was granted to Suresh Sundar Joshi as he was an ex-serviceman. Shri Suresh Sundar Joshi passed away on 4/10/2019. Living behind him, his daughter Radhika, the first petitioner, as his only legal heir. However, it appears that Suresh Sundar Joshi had executed a will dated 2/9/2016 in favor of the second petitioner, and at the request of Suresh Sundar Joshi's wife and the petitioner's no objection, the kata was changed in favor of the second petitioner.
Registered will, ma'am.
This transfer of kata was challenged by the respondent,
Respondent number 5, your lordship.
by the fifth respondent before the assistant commissioner, and the assistant commissioner by the impugned order has set aside the order of the Tahsildar on the ground that the will was being disputed. The Assistant Commissioner has also gone on to state that there were some irregularities in the grant and therefore the matter is required to be examined and a report and a proposal be submitted to him. Next paragraph. It is not in dispute that a land grant was made in favor of Suresh Sundar Joshi. And it is also not in dispute that this grant made in favor of Suresh Sundar Joshi was not challenged by anybody, much less by the fifth respondent. If on the basis of the grant, the name of Suresh Sundar Joshi was entered in the revenue records, it is obvious that on his death, his legal heirs, the name of his legal heirs will have to be entered in the records. Thus, the fact that the name of Radhika, the only daughter of Suresh Sundar Joshi, was to be entered cannot be in dispute. It is no doubt true that on the basis of a will, the authorities, ostensibly on the basis of the consent given by the wife and the first petitioner, have changed the changed the entries in the name of the second petitioner by considering him as a legatee. This process adopted by the revenue authorities, that is accepting a will merely on the consent of the wife and the daughter cannot be accepted. It is settled law that if a change of entry is based on the basis of a will, and that too a will in favor of a person who is not a blood relative of the Katidar, the propounder of the will have to necessarily approach a civil court and secure a declaration regarding his entitlement. Only then can the entries be changed in his favor. In the light of this legal position, it would be appropriate to dispose of this writ petition by setting aside the order of the Assistant Commissioner and directing the name of the first petitioner Radhika to be entered in the revenue records as the legal heir of Suresh Sundar Joshi. So it will be open to the second petitioner to secure an appropriate declaration from the civil court on the basis of the will that he claims has been executed in his favor by Suresh Sundar Joshi, and thereafter seek for change of Kata. Writ petition.
Chandrakant R. Patel.
Mandamus directing the respondent Tahsildar to issue Sagwali cheats in favor of this petitioner as per official memorandum by annexure D. Lord, the
Released on 24. Interim order granted earlier shall continue till then.
please.
Seal number 93.
Writ of mandamus ದುರಸ್ತಿ ಮತ್ತೆ ಪೋಡಿ ಮಾಡ್ಲಿಕ್ಕೆ MRL ಇರುತ್ತಾ?
You consider its representation.
The prayer in this writ petition is for issuance of direction to the third respondent to consider the representation dated 16/7/24, a direction to the first respondent to consider the representation dated 21/1/2025, and also other representations given to respondents 2, 3, and 4. By these representations, the petitioner is requesting for a durasti of the land
ದುರಸ್ತಿ.
and the consequential podi of the land. So, AG on instruction submit that the request of the petitioner for conducting a durasti would be considered and approved orders would be passed within a period of 3 months from the date of receipt of a copy of this order. This submission is taken on record and the petition is disposed of directing. Have responded.
Respondent number.
ಒಬ್ಬರ ಹತ್ರ ಹೋದ್ರೆ ಒಬ್ಬರ ಹತ್ರ ಹೋಗಿ ಅಂತಾರೆ, ಅದಕ್ಕೆ ಎಲ್ರಿಗೂ ರೆಪ್ರೆಸೆಂಟೇಷನ್.
4 and 5, madam.
Response 4 and 5 to consider the representation submitted by the petitioner for durasti and podi and pass approved orders within a period of 3 months. It is hereby clarified that nothing said in this order shall be construed as an opinion being rendered on the merits of the claim of the petitioner. And the petitioner's claim shall be considered strictly in accordance with law.
Silma 94, Raju.
The petition. Short for the writ of mandamus.
Total.
Total.
In both. The list. 2 weeks.
Last week is notes.
17. So, passed over matter, serial number 25.
Submit notes. But the gifted is executed subsequently 11 months back, just 11 months back, I will try to convince my lordship. My application was filed in the 2015. And there is a FMA kindly be seen, for which, my lord, my name has been shown.
ಯಾವತ್ತು ಕೊಟ್ಟಿದ್ ನೀವು?
2015 ಕೊಟ್ಟಿದ್ದೆ, annexure FMA kindly be seen. Please let me submit, then you will submit. Annexure FMA. Wherein, my lord, my name has been shown, they are issued the endorsement saying that application has been received.
3/2/2015.
Yes, ma'am. Thereafter, my
The
lord,
application,
ನಮ್ದೇ ಅಪ್ಲಿಕೇಶನ್ ಅದು ನನ್ನ ಹೆಸರೇ ಇದೆ ಸ್ವಾಮಿ, ರಾಮಕೃಷ್ಣ ಅಂತ ಹೆಸರನ್ನೇ ಇದೆ.
when did his mother make the application?
But mother and sons equally they made an application.
She is also filed in the.
ಮತ್ತೆ ಇವ್ರ ಅಣ್ಣಂದು ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ವಿ ಅಂತಂದ್ರೆ ಮನೆ ಇತ್ತು, ಅದಕ್ಕೆ ಕನ್ಸಿಡರ್ ಮಾಡಿ ರೆಗ್ಯುಲರ್ ಮಾಡಿದ್ವಿ. ಇವ್ರದ್ದು ಮನೆ ಇರಲಿಲ್ಲ,
ಇಲ್ಲ ಅವ್ರದ್ದು ಯಾವ ಡೇಟ್ ಹಾಕಿದ್ರು ಮದರ್ ಅಂಡ್ ಬ್ರದರ್? ಡೇಟ್ ಇಲ್ವಾ?
ಅವರು 15 ಎಲ್ಲ ಹಾಕಿದ್ರು, ನಾವು 15 ಎಲ್ಲ ಹಾಕಿದ್ವಿ ಸರ್. So,
mother of petition.
so 15 ಆದ್ಮೇಲೆ no action has been taken.
ಅಲ್ಲ ಅವ್ರ ತಾಯಿಗೆ ಯಾವಾಗ ಕೊಟ್ರೆ?
5/3/2018. Regularization registered document has been executed, registered on 5/3/2018.
ಬ್ರದರ್ಗೆ?
2015 ಅಲ್ಲಿ, ಬಟ್ ಅವ್ರ ಹೆಸರಲ್ಲಿ ಇವಾಗ ಪ್ರೊಡ್ಯೂಸ್ ದಿ ಡಾಕ್ಯುಮೆಂಟ್ number. under the ಆಶ್ರಯ ಸ್ಕೀಮ್
1992.
92 ಅದು.
ಅಲ್ಲ ಬಟ್ 15 ಅಲ್ಲಿ ಹಾಕಿದ್ರು ಬ್ರದರ್ ಅಂತಂದ್ರೆ
ಇವ್ರು ಮದರ್ ಮತ್ತೆ ಪಿಟಿಷನರ್ ಮಾತ್ರ ಹಾಕಿರೋದು. 92 ಅಲ್ಲಿ ಬ್ರದರ್ ಹಾಕಿದ್ದಾರೆ. ಫಸ್ಟ್ ಸನ್ ಆಫ್ ದಿ
1992 ನಾ?
under the ಆಶ್ರಯ ಸ್ಕೀಮ್ is also reflected in this one.
ಅವ್ನ್ಗೆ ಯಾವಾಗ ಕೊಟ್ರಿ?
1992 sir. Panchayat Khata is also standing in this.
When did the mother give the property to him? And then reject ಆಗಿದೆ ಅಂದ್ರಲ್ಲ ನೀವು ಇವ್ರದ್ದು? What is document number 1?
Document number 1 is the application filed by the petitioner. Next document, my lord, the endorsement has been issued, my lord, after getting the report from the revenue inspector, my lord.
This is not challenged.
may I submit that.
I'm just correcting the dates. Then when was the mother's property gifted to him?
Mother property gifted on 21/2/2024. The Khata could have standing in the name of the petitioner.
Registered gifted, huh?
Registered. Khata could have produced along with him. For that method, tax has been paid, Kandaya has been paid in respect of the gifted property.
Kata changed and Kandai also paid by the petitioner.
Yes.
And you have admitted not said anything about the gift.
Yes, I will admit it, my lord. My lord, the document number 2, the file by endorsement, you may kindly be seen, my lord. So which is not been communicated.
Report says, Lord, this report is given from the year 2017.
ಆ ರಿಪೋರ್ಟ್ ಅಲ್ಲೂ ಕೂಡ ನಮಗೆ ಗಿಫ್ಟ್ ಏನಾಗಿದೆ ಮತ್ತೆ ರಿಜೆಕ್ಟ್ ಮಾಡಿ
ಖಾಲಿ ನಿವೇಶನವಾಗಿದ್ದು ಅಕ್ರಮ ಸಕ್ರಮದ ಅಡಿಯಲ್ಲಿ ಶಿಫಾರಸು ಮಾಡಲು ಅರ್ಹ ಇರುವುದಿಲ್ಲ ಅಂತ ಈ ರಿಪೋರ್ಟ್ ನೋಡಿದ ಮೇಲೆ 1 ತಿಂಗಳ ಮನೆ ಕಟ್ಟಿದ್ದಾರೆ.
ಇಲ್ಲ ನಾನು ಹೇಳ್ತೀನಿ ಸ್ವಾಮಿ, ರಿಪೋರ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಬಟ್ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಇಶ್ಯೂ ಮಾಡೋಕ್ಕೆ ಕ್ರಮ ತಗೊಂಡಿದ್ದಾರೆ. ಇನ್ನು ಕೈಂಡ್ಲಿ ಸಿ ದಿ ಎಂಡೋರ್ಸ್ಮೆಂಟ್. Endorsement says, Madam, if it is never rejected my claim, you may kindly approach the next D2. ಅಲ್ಲಿ ಏನು ಹೇಳ್ತಾರೆ ಅಂತಂದ್ರೆ ವಿಲೇವಾರಿ ಹಿಡಿದಾಗಲಾಗಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ. They have not been rejected my claim. You may kindly approach that. ರಾಮಕೃಷ್ಣ ಆದ ನೀವು ಬೆಂಗಳೂರು ದಕ್ಷಿಣ ತಾಲೂಕು ಒಬ್ಳು ಕುರುಬಳೆ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 100.
Annexure G that he has produced. Annexure G. Permission to construct ಅಂತ ಹೇಳ್ತಾರೆ. Permission granted for him to construct. ಯಾವ ಜಾಗಕ್ಕೆ?
ಅದೇ ಜಾಗಕ್ಕೆ ಸ್ವಾಮಿ.
If it's unauthorized dwelling house, where is the question of granting permission?
No, because he has residing for the past 30 years, for which my lord he has been paying the regular.
The PDO has granted you a license to construct on government land.
Yes, my lord. Because my lord, in 2014 also my lord, permit me to produce the additional.
Can you do that? Can you grant permission to construct on government land?
Yes, you don't have any jurisdiction, I do agree.
Especially when you accept that you're an unauthorized occupation.
Since 2010 in the tax cut permit me to put a certain document. The first document, after filing this petitions, I filed the application to get the information. How many Hakkupatra has been issued to the same families?
I am coming, we will come to them afterwards.
Yes, ma'am. Second
How
document.
how can you make, so even according to this 21/9/23, you constructed the building for the first time after you obtained permission?
Yes, madam. And second,
Are you sure?
first shed ಇತ್ತು ಸ್ವಾಮಿ, ಶೆಡ್ ನಲ್ಲಿ ಏನು ಅದಕ್ಕೂ ಟ್ಯಾಕ್ಸ್ ತಗೊಳ್ತಾ ಇದ್ರು. ಸೆಕೆಂಡ್ ಡಾಕ್ಯುಮೆಂಟ್ ಕ್ಯಾನ್ ಬಿ ಸೀನ್ 4/9/2014.
ಎಲ್ ಖಾತಾ ತಗೊಳ್ತಾ ಇದ್ರು?
ಅಲ್ಲ, 4/9/2014 ದಿ ಪಂಚಾಯತ್ issued notice to me the revenue tax.
2015 you make the application.
Yes, madam. Prior to that, it was a shed, madam.
The application, what does it say? Was the kind of construction?
For regularize the unauthorized occupation.
Please let us look at your application. ಯಾವ ತರ ಮನೆ ಯಾವಾಗ ಕಟ್ರಿ ಅಂತ ಬರ್ದಿದ್ರ?
Application produced by the respondents, my lord. ಅನಧಿಕೃತ ನಿರ್ಮಾಣದ ಕ್ರಮಬದ್ಧಗೊಳಿಸುವ ಅರ್ಜಿ ನಿಯಮ 108. They have produced the document, my document.
So you claim that you put up a structure of 1,600 square feet as on 1/1/2006.
Not 300 square feet, not 1,000.
This is your application I am reading. The application indicates ಅರ್ಜಿದಾರರಿಂದ ಅಥವಾ ಅವರ ಕುಟುಂಬದ ಯಾರೇ ಸದಸ್ಯರಿಂದ ಮಾಡಿದ ಅನಧಿಕೃತ ನಿರ್ಮಾಣದ ಇತರೆ ಇಲ್ಲಿ 158 ಯಾರ್ದು? What is one, whose is 158? ಆಮೇಲೆ what is the second volume? ಸಕ್ರಮಗೊಳಿಸಬೇಕಾಗಿರುವ ಎಲ್ಲ ವಿವರಗಳ 158. This is the land ತಾನೆ? This is 1,600 square feet. You suppress the fact that your mother had also made an application.
Simultaneously, my mother and I have made 2 applications.
So you say 2006 you had constructed the building.
ಹೌದು ಸರ್, 1,600 square feet ನಲ್ಲಿ 45.
If you have put up the building in 2006, why did you seek for permission?
Subsequently renovated. ನಾನು 20 ವರ್ಷದಿಂದ ಇದ್ದೀನಿ, for which I produced the documents. Aadhaar card is issued by the government and the election ID card.
I'm asking you a question.
Yes.
In 2006 you already put up the construction.
Yes.
Why did you secure permission again in 2023?
But which has not been regularized. Still my application is pending for consideration.
Our application ಬಿಟ್ಬಿಟ್ಟು ಕಂಡ್ರೆ ನಿಮ್ಮ ಮನೆ ಕಟ್ಟಿದಂಗೆ 23 ಅಲ್ಲೇ ತಗೊಳ್ಳ?
So this statement is wrong.
Yes, 23 ನಲ್ಲಿ ಕಟ್ಟಿದ್ದಾರೆ sir.
So this statement that you made in the application is false.
ಡೆಮಾಲಿಷ್ ಮಾಡಿ 23 ನಲ್ಲಿ ಹೊಸದಾಗಿ ಕಟ್ಟಿದೀವಿ. ಎಸ್, ರಿನಿವೇಟ್ ಮಾಡಿ ಹೊಸದಾಗಿ 23 ನಲ್ಲಿ ಕಟ್ಟಿದೀವಿ.
ವಸಂತ್ ಕುಮಾರ್ ಅವರೇ, ನಿಮ್ಮ
Please.
ಅರ್ಜಿ ಪ್ರಕಾರ 2006ನೇ ಇಸ್ವಿಯಲ್ಲಿ ನೀವು ಮನೆ ಕಟ್ಟಿದ್ದೀರ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಎಸ್ ಮೇಡಮ್, ಇಟ್ ವಾಸ್ ಅ ಶೆಡ್. ಇಟ್ ವಾಸ್ ತಾವು ಫೋಟೋಗ್ರಾಫ್ ಹಾಜರುಪಡಿಸಿದ್ದೀನಿ. ಹಂಚಿನ ಮನೆ ಕೆಲವು ಹುಲ್ನಲ್ಲಿ ಕಟ್ಕೊಂಡಿದ್ದಾರೆ. ಇಟ್ ಈಸ್ ಬಿನ್ ಡೆಮಾಲಿಶ್ಡ್ ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ ವಿತ್ ಪರ್ಮಿಷನ್ ಆಫ್ ದಿ ಮಂಡಲ್ ಪಂಚಾಯತಿ ವಿ ಆರ್ ಕನ್ಸ್ಟ್ರಕ್ಟೆಡ್. ಬಿಕಾಸ್ ಮೈ ಅಪ್ಲಿಕೇಶನ್ ಸ್ಟಿಲ್ ಪೆಂಡಿಂಗ್, ನೋ ಆಕ್ಷನ್ ಹ್ಯಾಸ್ ಬೀನ್ ಟೇಕನ್. ತಾವು ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಅಲ್ಲಿ ದೇ ನಾಟ್ ರಿಜೆಕ್ಟೆಡ್ ಮೈ ಕ್ಲೈಮ್. ದೇ ಹ್ಯಾವ್ ಸ್ಟೇಟೆಡ್ ದಟ್ ವಿಲೇ ಇಡಲಾಗಿದೆ.
I am trying to understand your case.
ಪ್ಲೀಸ್ ಮೇಡಮ್.
You apply for permission to put up a building.
Not for
On-
put up,
on-
regularize another occupation of my site.
Correct.
Yes,
That land is still not granted to you.
yes, ma'am.
You admit that the government owns that particular property.
Yes, ma'am.
Knowing fully well government as owns the property and being fully conscious of the fact that it made an application for regularization,
Please, ma'am.
you seek for permission to the PDO to construct. And PDO grants you permission to construct.
Yes, ma'am.
Is it,
Yes,
Once
it's
that-
not, yes, it's not permissionable because,
once you construct a building, pursuant to that permission, your application for regularization goes?
yes, ma'am. I do agree, my lord, because this is an.
Your application for regularization goes. Then what is your rate?
Yes, I do agree, my lord, because he's an illiterate. He didn't know the legal aspect for which, my lord, with permission of the PDO is constructed. He made application in the 2015. According to them, my lord,
Who is that PDO who had granted that annex ref?
for 2017 endorsement may kindly be seen, my lord.
Next, G. 21/9/23.
My lord, endorsement may kindly be seen, my lord. They issued by them in the 2017, which is not been
What
communicated.
is annex G?
J, my lord, the certificate issued by the Bandal Panchayat only, Chennai Nandi. Akshepana Rahita Dudik, they have no objection to construct the building. And
Document is fabricated.
The document is?
Fabricated. Next, G. Lord, this is the PDO signature.
And what about annex J? Annex J.
Seal is there, my lord, Rajesh.
That PDO has signed the document.
What is annex J?
J, my lord, the Akshepana Rahita Patra issued by the Rajeshwari Panchayati Adhyakshara. The president of Panchayati issued a no objection certificate to construct the building, my lord.
ಯಾರ್ದಿದು? ನಮ್ಮ ಹತ್ರ ಯಾರ್ದು? This is some other.
PDO signature.
Rarely, I'll ask you to fill an affidavit. What about annex J?
President, I mean,
Rajeshwari,
yes, my lord.
President of Panchayat.
president ಆದ?
Awesome.
ಇಲ್ಲ,
Rajesh.
ಕೊಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ ಗೌರ್ಮೆಂಟ್ PDO ಕೊಡ್ಲಿಕ್ಕೆ ಬರೋದಿಲ್ಲ.
ಇಲ್ಲ ಪಂಚಾಯತಿ ಅಭಿವೃದ್ಧಿ ಅಧಿಕಾರಿ ಅಲ್ವಾ? ಅದು ಪ್ರಿಂಟೆಡ್ ಅಧ್ಯಕ್ಷ.
Secretary.
ಇಲ್ಲ, but seal ಇರೋದು ಪಂಚಾಯತಿ. Ask who Rajeshwari is. And who has given this no objection?
President of Tenant Gram Panchayat.
He will do it only obviously if the PDO says give. ಇವರೆಲ್ಲರೂ ಶಾಮೀಲ್ ಆಗಿದ್ದಾರೆ.
40 into 40 ಅಂತ 30-40 ಅಷ್ಟೇ maximum.
Another electricity bill, my lord.
File the affidavit as to how annexure this, what is this, annexure G and J are given. Then I'll take action.
Another K may kindly be.
I will also ask you to go against the PDO and the president who has done this.
My lord, the-
I'll grant you permission to demolish that building, provided you file an affidavit saying that this is a forgery.
my lord, the
Monday, you want it.
Monday.
the electricity bill could have provided ಮಾಡಿದೆ ಸ್ವಾಮಿ. And they issued the endorsement subsequently, which has not been communicated. Wherein endorsement says that not in urgee any
I'm dismissing your petition only on one ground. You have got a gift deed from your mother.
Yes, ma'am, I do.
You have suppressed
Yes,
that fact.
Yes, ma'am. No,
And
subsequent-
therefore, you are not entitled for all this, and I'll impose cost on you and ask them to recover the cost.
subsequent
of
apology,
demolition.
ma'am, that agreement subsequently, ma'am, I came to us just 11 months back, he has executed the gift deed.
So the moment he got the gift from his mother, he ought not to have pressed this application.
Pardon, my lord?
The moment he got the property from his mother, he should not have pursued
No,
this
because-
application.
Because what has happened, my lord, there is a quarrel between the ಇವರು ಅತ್ತೆ ಸೊಸೆ ಜೊತೆ ಜಗಳ ಆಗಿದೆ. ಸೊ ಹಾಗಾಗಿ my lord ಅವ್ರು
You have got the property and registered gift deed.
yes ma'am.
You got the kata change in your favor.
ma'am.
You
Yes,
paid
ma'am.
the kandayam.
Yes, ma'am.
And yet you are pursuing this application?
Not permit me to, I will convince the party to vacate and ಅವರೇ demolish ಮಾಡಿ they have take back the
I warned you in the first time, ಅದ್ ಮಾಡಿ ನಿಮ್ಗೆ ನಾನು ಬಿಡ್ತೀನಿ ಸುಮ್ನೆ ಅಂತ ಅಂದೆ. ನೀವು ಪುಷ್ ಮಾಡಿದ್ರೆ ನೀವು ಒಬ್ಬರಿಗೆ ಅಲ್ಲ,
ಇಲ್ಲ sir.
PDOಗೆ ಪ್ರೆಸಿಡೆಂಟ್ ಎಲ್ರಿಗೂ ಬರುತ್ತೆ ಕುತ್ತಿಗೆಗೆ.
ಅಲ್ಲ ಅವ್ರು ಕಟ್ಟುವಾಗ್ಲಾರು ಬಂದು ಅವ್ರು ಸ್ಟಾಪ್ ಮಾಡ್ಬೋದಾಗಿತ್ತು, ನೋಟಿಸ್
ಅವ್ರನ್ನ
ಕೊಡ್ಬೋದು.
ಚೆನ್ನಾಗಿ ನೋಡ್ಕೊಂಡಿದ್ರಿ, ಅದಕ್ಕೆ ಅವ್ರು ಸುಮ್ನೆ ಇದ್ರು. ಇವಾಗ ನೀವು ಅವ್ರು ನೋಡ್ಕೊಳ್ತಿಲ್ಲ,
ಅದೇ ಆಗಿರೋದು sir.
ಅದಕ್ಕೆ ಇದಾಗಿದೆ.
Yes, yes,
ಅದಕ್ಕೆ ನಾನು ನಿಮ್ನು ನೋಡ್ಕೊಳ್ತೀನಿ,
exactly.
ಅವ್ರು ನೋಡ್ಕೊಳ್ತೀನಿ. ನಿಮ್ಗೆ ಯಾರಿಗೆ ಅವಕಾಶ ಮಾಡಕ್ ಬಿಟ್ಕೊಟ್ರಲ್ಲ,
ಹೌದು sir.
I'll go against them
Yes,
and also against
I
you.
bound by the order of this lordship only, yes ma'am. Because endorsement ಅಲ್ಲೂ ಕೂಡ ನಮ್ಮ claim reject ಮಾಡಿಲ್ಲ
You
sir.
have time till Monday, you decide, or else you have told
ಅಲ್ಲ
me
ಇವತ್ತು
whatever.
ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ರೆ ನಾವು ಕಟ್ಟಪ್ರದ ಅವ್ರ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಏನ್ ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ, ವಿಲೆ ಇಡಲಾಗಿದೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
I have
ತಾವು
told you,
ದಯವಿಟ್ಟು ಇದನ್ನ ನೋಡ್ಬೋದು ಸ್ವಾಮಿ.
Vasanthar, I have told you
Please.
what I will do.
ಪ್ಲೀಸ್ ಮ್ಯಾಮ್,
I will go against you, at the same time I will go against them.
ಪ್ಲೀಸ್ ಮ್ಯಾಮ್,
And I'll keep the petition pending so
Yes.
far as they are concerned, and I'll ensure that action is taken against the PDO.
ಪ್ಲೀಸ್ ಮ್ಯಾಮ್.
I'll make sure that the PDO meets this
ಆಲ್ಸೋ ದಿಸ್
fate.
lordship has to take the against
If the affidavit is filed by them saying it is a forgery, you are still in bigger trouble.
Please,
I'll ask him to register a criminal case against you and go against you
let them face me because I can't do anything because
by
They are-
Monday.
no,
Take
this
a decision by
lordship also
Monday.
have to take serious against the revenue department also because 2017
ಅವ್ರಿಗೆ ಅವ್ರ ಮೇಲೆ ಏನ್ ಮಾಡೋಕ್ ನಾನು ಗೊತ್ತ
ಅಲ್ಲ at least ಅವ್ರು illiterate ಅಂದಾಗ ಒಂದು ನೋಟಿಸ್ ಕೊಟ್ಟು ಸ್ಟಾಪ್ ಮಾಡಬಹುದು.
illiterate ಇಲ್ಲ ಇದ್ರಲ್ಲಿ. Illiterate ಅಂತ ಇದು
Bound by duty of the obligatory authority, they have to stop by issuing the notice. They have not issued any notice. Only after constructing building, they are coming for demolition.
ವಸಂತರ, I'll take them also to task.
Please, madam.
ಅವ್ರ ಮೇಲೂ
Please, madam.
1,00,000 ಕಾಸ್ಟ್ ಹಾಕ್ತೀನಿ,
Please, madam.
ಕಿದ್ವಾಯ್ ಕೂಡ ಕೇಳ್ತೀನಿ, ನಿಮ್ಮ ಹತ್ರ 1,00,000 ಕಾಸ್ಟ್.
ಆಮೇಲೆ ನಾನು ಇನ್ನೊಂದು ಏನಂತ ಪ್ರೇಯರ್ ಅಂತಂದ ಕೈಂಡ್ ಡೈರೆಕ್ಟ್ ದಿ ಪಾರ್ಟಿ ಟು ಪ್ರೊಡ್ಯೂಸ್ ದಿ ವಾಟ್ ಎವರ್ ಸಾರ್ಟ್ ಬಂದಿ ಅಂಡರ್ ಇನ್ಫಾರ್ಮೇಶನ್ ಆಕ್ಟ್ ಒಂದೊಂದು ಮನೆಗೆ 5 ಜನಕ್ಕೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ.
I will not allow you to argue on merits because you suppress the fact that you got your
Yes,
mother's
that is
property.
me extremely sorry, Malan. I
That
seek
is all.
apology because my client is here, he didn't inform me also. Just he
And
killed
ನಿಮ್ಮನ್ನ
11
blame
months.
why do you think I'm blaming you? He has committed a mistake, you will suffer the
11
consequence.
months back ಈಗ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡ್ಕೊಟ್ಟಿದೆ ಅಂತ ಈಗ ಹೇಳ್ತಾರೆ. At least I would have stated that.
Monday, get the affidavit filed of the PDO that whatever is the person who ನಿಜಾನ
Then one more aspect I have
to
to,
annex charge ಎರಡು ಮಾಡಕ್ಕೆ ಹೇಳಿ. But I am warning you that I will go against them also.
one more aspect I have to bring to
Monday.
his lordship. No complaint has been filed against me only. Complaint filed against my brother. Based on my brother, he have taken the action against me only.
If they file an affidavit saying that this building person license is forged,
Yes, madam.
then I will direct the criminal case to be registered.
Please, madam. Allah, they are also committed so many mistakes because my lord,
I am not going to allow them to go scot free. They were going to pay for it.
ನಮಗೆ ಪ್ರೇಯರ್ ನೋಟಿಸ್ ಇಲ್ಲ ಏನಿಲ್ಲ, ಮುಂಚೆನೆ ನೋಟಿಸ್ ಕೊಡ್ಬೇಕಾದ್ರೆ at least ನಾವು would have stopped
ಅದು ಮೆರಿಟ್ಸ್ ಮೇಲೆ ನಿಮ್ ಮಾತಾಡಕ್ಕೆ ಬಿಡಲ್ಲ ನಾನು. ಮಿಕ್ಕಿದ್ ನೀವು
It's only the
ಮಾಡಿದಿರಲ್ಲ,
suppressing of
ಅದಕ್ಕೆ
facts. I am extremely sorry. I do.
ಅವ್ರನ್ನ ಏನ್ ಮಾಡ್ಬೇಕು ನಾನು ಮಾಡ್ಕೊಳ್ತೀನಿ.
Please, madam.
ನಿಮ್ಗೊಂದು ಚಾನ್ಸ್ ಕೊಡ್ತಾ ಇದ್ದೀನಿ, ನಿಮ್ಮಷ್ಟು ನೀವು ಖಾಲಿ ಮಾಡ್ಕೊಂಡು
Please, madam. I will
ಸ್ವಾಧೀನ
convince my
ಕೊಟ್ರೆ
party also. Yes, madam.
ಸರಿ, ಇಲ್ಲ ಅಂದ್ರೆ
Please.
ಮಂಡೇ
affidavit of PDO or procedural?
you decide. Because somebody will get stuck, isn't it? So you decide who will file the affidavit.
ಇದ್ರ ಒಂದು ಕೇಳ್ಬೇಕು, ತಾವು ಯಾಕೆ ಕ್ಲೈಮ್ ರಿಜೆಕ್ಟ್ ಮಾಡಿಲ್ಲ, ವಿಲೇವರಿ ಇಟ್ಟಿದೆ ಅಂತ ಹೇಳಿದೆ 17 ನಲ್ಲಿ. ಸೊ ಕ್ಲೈಮ್ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ರೆ at least would have
ನಿಮ್ದು ಮೆರಿಟ್ಸ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಕ್ ಬರಬೇಡಿ ನೀವು.
they are also committed so many mistakes. That's what I bring by before the lordship only. Not good.
430 PM matter for further consideration, serial number 96. Arjun draft.
For the petitioner, madam.
I am filing fresh calculation, taking into consideration the law that was prevailing.
ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಾ?
Yes, sir. I've received a copy. Your Honor, I want to make 3 submission on their memo of calculation. Your Honor, may I kindly see their remarks itself, my lord. They've levied tax and fees at the same time on the panchayat lands as well. And second thing is that on the holdings on private lands, they've imposed license fee, which is as per the agreements, which is based on the panchayat lands at the rate of 25. Now they're imposing on me license fee at the rate of 25, along with advertisement tax at the rate of ₹5 as per Schedule 4. My lord, this is not as per the submissions which was made by the AGA, nor as per the directions of this
Give your
honorable court.
response to this. The first two, like I told you, panchayat land, there's no difficulty.
Yes,
with the
ma'am.
agreement. The second is only as per Schedule 4.
Yes.
Yes, my lord.
Yes.
Only as per
My lord, I
schedule 4.
filed my memo of calculation as well, which is based on the agreement.
To this.
Not to this. This I'll reply, my lord. A date on
Yeah.
Friday may be given.
Friday.
Grateful.
ಇನ್ಫೆಕ್ಷನ್ ಆಗ್ತದೆ ಅದಕ್ಕೆ ವಾಪಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅನ್ಸುತ್ತೆ ಅದಕ್ಕೆ ಆದ್ರೆ ಇಲ್ಲಿ ಎಷ್ಟು ನೋಡ್ತಾ ಇದೆ ಅಂದ್ರೆ
Twenty-three, 24.